of the largest bar of the largest sub-regional bar, the largest sub-regional conference, largest sub-regional gathering of lawyers in Nigeria. You are here at the NBA Lagos Law Week Day 3. A round of applause for that. A round of applause. Let's kick things off. Exactly. I want to hear a resounding applause. Thank you. Now, yesterday we began with the theme. The theme for this year's NBA Lagos Law Week is Lawyering in the Digital Age. And yesterday we began with a powerful keynote address delivered by the one and only, the Chief Justice of Nigeria, making her first official outing to any branch in Nigeria. Please, a round of applause for the Chief Justice of Nigeria. I want her to hear it all the way in Abuja, that NBA Lagos loves her, NBA Lagos appreciates her for taking our time. The Honorable Chief Justice of Nigeria, Justice Kudirat Motomori Kekere Ekun, GCON. Such a powerful name. Please, a round of applause for her. A round of applause. Thank you. And we are kickstarting today's event on a much more powerful note. I wish I could give you a recap of everything that went down yesterday. The governor of Lagos State was also here. He was represented by the secretary to the state government. A round of applause for Mr. Governor. A round of applause for the governor of our state, always taking our time to be with us. The Attorney General of Lagos State was also here present. Please, a round of applause. And all this was made possible by the Law Week Planning Committee. Now, I wish I could give a recap, but I would not be giving a recap of yesterday's event. I have the chairman of the Programs and Content Subcommittee coming on stage in about a minute, Mr. Babajimi Ayorinde. He's coming on stage to give a recap of yesterday's event. Please make him welcome on stage. Do that better, do that better. They have put this event nicely. Thank you so much, sir.
Good morning, everyone. Before I start the recap, can we take the NBA opening prayer, please? Can Kogito put it on the board, please? Please, can everybody rise for the NBA opening prayer? All right. Almighty God, our Creator, our endeavors that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, fellow men, and our country. Amen. Thank you very much. My lords here present, distinguished life bencher, Mrs. Harriet Balogun, OON, learned senior advocates, my esteemed colleagues, distinguished guests, ladies and gentlemen, I bid you good morning. As we commence the second day of the 2026 NBA Lagos Branch Annual Law Week Conference, it is fitting that we take a few moments to reflect on the remarkable conversations and key outcomes from yesterday's proceedings. Day one set a very inspiring tone for this year's conference, themed Lawyering in the Digital Age, Navigating Technology, Justice, and Innovation. It brought together an exceptional gathering of judicial officers, legal practitioners, policymakers, academics, and technology experts to examine how the legal profession can successfully navigate an era increasingly shaped by technology while remaining firmly anchored in justice, ethics, and the rule of law. The conference formally opened with inspiring addresses from the chairperson of the Law Week Planning Committee, Mrs. Obosa Akpata, the chairman of the Nigerian Bar Association Lagos Branch, Mrs. Uchenna Akingbade, and goodwill messages from our distinguished guests. The governor of Lagos State was represented by the secretary to the state government, Mrs. Salu Hundein, whilst the Deputy Governor of Lagos State and the Attorney General of Lagos State were represented by Mr. Olayinka Hamid Adeniji, Solicitor General and Permanent Secretary, Lagos State Ministry of Justice. While conveying their goodwill, they reaffirmed the Lagos State government's commitment to strengthening the administration of justice through innovation, institutional reform, and sustained collaboration with the bar and bench. The intellectual highlight of the day was the keynote address delivered by the Chief Justice of the Federation, the Honorable Justice Kudirat Kekere-Ekun, GCON. It was titled, Beyond Disruption, Redefining Legal Practice at the Intersection of Law, Technology, and Justice. Her Ladyship challenged us to move beyond viewing technology merely as a disruptive force and to embrace it as a strategic instrument for strengthening justice. Her Ladyship reminded us that no technological advancement can replace human judgment, ethical responsibility, or the constitutional values upon which our justice system is built. The first plenary session explored the rise of AI in legal practice and examined whether it is a threat or a tool for the modern lawyer. The discussions reaffirmed that artificial intelligence is no longer a futuristic concept, but an integral part of today's legal practice. The consensus was that while AI has become an invaluable professional assistant capable of enhancing research, drafting, and legal analysis, it cannot replace the lawyer's independent reasoning, ethical judgment, or professional responsibility. Delegates were reminded that every AI-generated output must be carefully verified against primary legal sources, and that the responsibility for protecting client confidentiality always rests with the lawyer. The second plenary session examined how justice delivery can be enhanced through e-filing and virtual hearings. The distinguished panelists shared practical experiences from the Federal High Court and the Lagos State Judiciary, highlighting the significant gains made through electronic filing, digital case management, and virtual proceedings. While acknowledging that implementation challenges exist, the session reinforced that technology is already improving efficiency, transparency, and access to justice across our courts. Now, the Oxford-style debate. It provided one of the most engaging moments of the day as the debaters considered whether digital innovation can truly reform Nigeria's justice system without a corresponding drive to tackle and drastically reduce ethical misconduct at the bar and the bench. The overwhelming conclusion was that technology can undoubtedly strengthen justice delivery by promoting transparency, accountability, and efficiency. But lasting reform will always depend on integrity, professionalism, and the ethical conduct of those entrusted with administering justice. Delegates were also given a practical demonstration on the use of artificial intelligence in legal practice, further illustrating the opportunities available to lawyers who are willing to embrace innovation responsibly and ethically. Several important themes emerged from yesterday's deliberations. We were reminded that technological competence is now an essential component of professional competence, that lawyers must continue to adapt to remain relevant in an increasingly digital world. While technology will continue to transform legal practice, justice, integrity, and professionalism will remain the enduring values that define our noble profession. As we embark on today's sessions, we are confident that the conversations begun yesterday will continue to challenge our thinking, deepen our knowledge, and inspire practical solutions for the future of legal practice and justice delivery in Nigeria. On behalf of the Nigerian Bar Association Lagos branch, we once again appreciate our distinguished speakers, panelists, moderators, sponsors, partners, and every delegate for their active participation and invaluable contributions to the success of Day 1. With this brief recap, we will now kick off what we trust will be another exciting day of insightful discussions, meaningful engagement, and professional development. Thank you, and once again, welcome to Day 2 of the 2026 NBA Lagos Branch Annual Law Conference.
Make that better, make that better. That's a representative of the Law Week Committee. Please make that better, make that better. Thank you for putting together such an insightful Law Week. That was a very, very wonderful recap. Yesterday we had insightful conversations, and today's conversations are going to be very, very enlightening, insightful. And ladies and gentlemen, I forgot to introduce myself when I came out stage the first time. My name is Nimi Edime, and I won't be doing this alone today. Please put your hands together as our panelists come on stage, and for my co-compare, Chinasa Akachukwu. Chinasa, please make that better. Make that better. Our panelists are already coming on stage.
Distinguished guests, ladies and gentlemen, once again, good morning. It is indeed my pleasure to be your co-host this morning. Yesterday we had a series of panel discussions, and we're going to continue with the fourth panel session. And to introduce the members of the fourth panel session, I'll be inviting Mr. Femi Onakoya to introduce the members of the panel. Mr. Femi Onakoya, please a round of applause for him.
Good morning once again. My lords, learned silks, honorable benchers, distinguished colleagues, ladies and gentlemen. My name is Femi Onakoya, and I am the coordinator for this session. Welcome to the second day of plenaries at this year's Law Week. The 2027 elections are on the horizon, and it is important to interrogate some of the issues in that regard. That is what this session will be doing. It's themed the 2027 general elections, leveraging technology to achieve election integrity. And it seeks to look at the impact of technology on the electoral process and how it can be utilized to deliver credible elections. To discuss this critical issue, we have assembled a stellar panel of distinguished legal practitioners and experts. On this panel, we have 3 senior advocates of Nigeria, 2 former attorneys general, 2 directors at INEC, past and present. And so, without further ado, please join me to make welcome our panelists, beginning with our session chair, Mr. Augustine Alege, SAN, CON. The founding and principal partner at Alege & Co., and is a past president of the NBA, elected as the 27th president of the association between 2014 and 2016. Bernard Silk, you're welcome, sir. To his right, we have Mr. Etigwe Uwa, Senior Advocate of Nigeria. He is Senior Partner and Head of the Dispute Resolution Department at the law firm of Stream Sowers and Corn. By my side, Learned Silk, Mrs. Abimbola Akeredolu, SAN, is a partner at Banwo and Igodalo and a former Attorney General of Ogun State. To her immediate right, we have Mr. Oluwole Osaze-Ozi, a past Director of Legal Services at INEC and a former Attorney General of Edo State. You're most welcome, sir. And on the far end of the panel, we have Dr. Lawrence Bayode. He is the Director of ICT at INEC, and he leads the Commission's AI division and is currently driving INEC's 2025 to 2027 AI roadmap. Ladies and gentlemen, please sit back, pay close attention to the discussions, and I wish us all a very pleasant and enjoyable session. Mr. Chair, sir, I yield the floor.
Thank you very much, Femi. Welcome, everybody. I think we're going to have a very robust session. Elections interest everybody, and I'm sure that we'll have a participatory engagement at this session. Permit me, as always, to recognize our doyen, Mrs. Harriet Balogun, former Attorney General of Lagos, former General Secretary of the Bar, former Chairman of the Body of Benchers, and our mommy always. She's former in everything, but she's our mommy always. We are very happy to see you here, and I believe you're one of the first people to come here. I asked the chairman of the branch, and they said it looks like Mama not only has a car, she has a boat, because to get here very early, you must have had to go through a lot of water. Thank you very much for being here. Without taking more time, we have our session outline. We are going to hear from the man that carries the can, the INEC man, because we are looking at election technology and seeing how elections can be better and have more credibility and more acceptance in Nigeria, leveraging on technology. So we'll hear from INEC first. After that, we'll hear the perspective of Mrs. Akeredolu, who's passed this and passed that, former Attorney General of Ogun State. When she was Attorney General of Ogun State, she was allocating a lot of land. I don't know why I didn't get any. And Mama did not get any too. And then after we've heard from her, we'll take an intervention from Mr. Waitigwe, who though is a well-known commercial lawyer, is also one of us who has ventured into the political arena and has encountered first time what election in Nigeria is. Then we'll take a remark and contribution from Mr. Oluwole Osazewole Uzi. Wole Uzi, he was in INEC for so long that I thought he wasn't going to leave, but I'm happy he eventually left, and he became Attorney General in my home state. He has knowledge on both the technology side, on the legal side, and he knows what drives the bar. He's the barman in his younger days before he went to INEC. I think he was Secretary of the branch at one time, yeah, long time ago. So Dr. Bayode, my old friend, I knew Bayode as a very young man in those days in the ICT department of INEC. And I had no doubt from that time when I knew him that he will rise to the top. And I know that he must be developing more things in INEC to give us more credible elections. So Bayode, we are all waiting to hear from you, and we trust that what we'll hear from you will encourage us and give us hope that our country is going to be better after this next election. Thank you very much. Bayode, you have the floor.
Thank you, the chairman of this session. Please kindly permit me to stand on the already established protocol. Again, you permit me, sir, to say this before I present my paper. When I received the letter of invite to come for this program, and, at the time the chairman also received the letter, and he called me, and I went to him, sir, you know we are preparing for Ekiti election. And after the election, honestly, sir, I will want to rest before we commence preparation for the Osun State governorship election. And he looked at me with one kind high. He said, "What do you mean? You don't know this is my constituency. Whether you like it or not, you have to go." And yesterday night, he called me and he said, "Please, I should tell them that I send my greetings." So I think I've been able to deliver the chairman's message, who is a member of this constituency. Having said that, this paper presentation is focusing on leveraging technology to achieve election integrity. Electoral integrity is the bedrock and foundational pillar of democracy. And this is because it ensures the will of voters is reflected through free, through fair, and through credible elections. Since 2002, the Independent National Electoral Commission has been leveraging technology to deepen the integrity of its electoral process. But for this presentation, I will just be focusing on the technology deployed to support one of the key activity on a day of election. Next slide, please. The technology that I will be discussing on a day of election collectively eliminate fraud, streamline processes, and build public trust. Talking about bimodal voter accreditation system, the frontline accreditation integrity tool. Talking about the newly introduced electronic form EC8A, which is a digital version of the polling unit result that is completed by the presiding officer after poll on a day of election. And the third is INEC result viewing portal, a real-time system that ensures public transparency, a system that accepts scanned from EC8A images to ensure transparency. Next slide. The bimodal voter accreditation system has impacted so well on Nigeria electoral integrity. For example, the key achievement of this system, when we talk about integrity, is that it has allowed the elimination of ghost voting. Why? Because biometric matching ensures only a registered voter can be accredited. This system has also prevented voter impersonation, and this is because the dual layer, that is the face and the fingerprint check, makes it virtually impossible to accredit someone using another person's permanent voter's card. The system has also ensured a real-time audit trail where every accreditation is time-stamped and logged electronically. The system has ensured faster and more efficient accreditation. However, we still have challenges. And one of the challenges for this system, bimodal voter accreditation system, is network dependency. Even though we don't need network, as soon as the system is configured to be deployed to the field, we don't need network to carry out accreditation on the day of election. The network is needed to configure the system. Network is needed to ensure that voters for a particular polling unit are all downloaded onto the system. Information of such voters are downloaded onto the system. Their biodata and their biometrics. Another challenge is staff competency. Over time, we have experienced that inadequate training of ad hoc staff leads to operational errors and voter frustration at the polls. And recently, during the conduct of the just concluded governorship election in Ekiti State, with some of the polling units where human interference to eliminate transcription errors and manipulation during collation. But the current system of INEC that our result collation remains manual. We don't currently have a electronic collation system. Next slide. I think I will just skip this because of time, and I will just go to lesson learned and key risks going forward. So far, since the deployment of these technologies to support one of the key day election activity, the bimodal voter accreditation system, the INEC result viewing portal, and the newly introduced electronic EC8A. The system, the electronic EC8A was first introduced during the FCT chairmanship and the councillorship election. And what the system does is to ensure that the result that was recorded at the polling unit is the same result that is uploaded to the high-ref, because the system allows you now to key in the figure of each score of political parties on the high-ref. So what the system does, it takes the image using OCR technology, digitize that image, compares the image with what is inputted on the system. And if everything is fine, it uploads straight to the high-ref. If there are discrepancies, you have to correct those discrepancies before the system allows any result that is emanated from the polling unit to be uploaded to the high-ref. Because why is INEC deploying the system? We have seen in time past where the results from the polling unit uploaded to the high-ref will be different from the one used to collate results at the collation center. So we keep improving on this system. So lesson learned so far: public expectation of instant results is rising. The communication vacuum invites misinformation. Another lesson learned: gaps between the bimodal voter accreditation records and IREV upload must be eliminated through better integration. And that was, I said, that was the reason why the Commission deployed the electronic EC8A. One more lesson that we have learned in the Commission is that technology intent alone cannot substitute for operational readiness and staff competency. Delay uploads erode trust faster than no upload at all. Speed of communication is critical. From 2023 till date, we have learned a lot of lessons. We are still learning because the Commission is a learning organization. Evidence from Beavers and high-ref together strengthens election petition processes when, I say again, when properly documented. Now the risk. Let me just, I think the risks are there. Misinterpretation of IRF upload failure as election rigging or coalition manipulation. We experienced this during the 2023 general election. We are deploying technology. We are doing our best to ensure that what happened in 2023 will not repeat itself again. And that is why every election that we have conducted after that, we have ensured. People keep asking me, what is glitch? What is glitch? And I will tell them, a glitch is a glitch. Yeah? Glitch is a glitch. When you design something and you deploy it and it refuses to work the way you have asked it to operate, then that is a glitch. I think because of time, let me just say thank you for listening. Thank you.
Thank you very much.
Thank you, Mr. Chairman.
Thank you for throwing light on what INEC is doing and how INEC is addressing the issues. We'll have Mrs. Akeredolu, SAN, give her contribution, and she will take it from the perspective she prefers to take it and give us her perspectives on it. I know she has a court hearing and she's running late, but I hope she will still give us the benefit of her views before she departs. Thank you very much. Akeredolu.
Thank you very much, Mr. Chairman. I'd like to thank the NBA Lagos branch for putting this together and for the honor of being a member of this very august panel, even though it's June. Thank you very much. I must confess I have had the benefit of seeing Dr. Bayode's presentation and have distilled what has agitated my mind. And the main thing that has agitated my mind, which he did touch on, is can technology truly guarantee election integrity in Nigeria? He has told us much about what technology can do and what the various BVAS, IREV, and E-C8A is designed to achieve. But however, I am of the view that we must be realistic about what technology can and cannot do. Yes, technology can create audit trails. Clearly, BVAS makes it significantly harder to pad voter numbers beyond what accreditation data can support. IREV, when it functions correctly, makes result sheet substitution at collation centers an immediately detectable fraud. These are genuine and important gains. We must accept that and we must not trivialize this fact. But remember my question, can technology truly guarantee election gains in Nigeria? I'm of the view that guarantee is too strong a word for any context. And it's particularly too strong for Nigeria as presently constituted. Technology cannot guarantee integrity where the institution deploying it lacks genuine independence. Thank you. Technology cannot guarantee integrity where network infrastructure is unreliable. Technology cannot guarantee integrity where officers who sabotage the working of technology face no real consequence. And technology cannot guarantee integrity where the legal framework for enforcing compliance is riddled or is gifted an escape clause, as our 2023 experience demonstrated. No doubt, technology is a necessary condition for electoral integrity in 2027. I believe you will all agree with me on that. But it's not by itself sufficient. Sufficiency requires strong institutions, clear laws, and accountable human beings. This is where the legal framework becomes critical. Section 139 of the Electoral Act 2026, which substantially repeats Section 135 of the 2022 Electoral Act provides, and with your kind permission, I shall read. An election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this Act and that the non-compliance did not affect substantially the result of the election. I need not remind us from the benefit of case law that substantial compliance in Nigeria and anywhere really varies with the proverbial size of the chancellor's foot. Topic for another day. The effect of this provision is that technological failures or deviations from prescribed procedures will not automatically invalidate an election. So a petitioner must not only establish that there was non-compliance, but must also demonstrate that the non-compliance was substantial and materially affected the result. How Herculean that task is, I leave to your imagination. In the case of INEC, Nemeka and INEC, reported in parts 2024 of the NWLR, the Supreme Court reaffirmed this principle. That's a 2026 decision. And I quoted it, but in the interest of time, I won't take you through that. So if electoral technology is to become a genuine safeguard against electoral malpractice, the legal consequences of failing to deploy or utilize that technology as prescribed must be clear and certain, must not be left to conjecture. I will try and be unselfish and leave my contribution to this, as I may have to leave because I have a court appearance. Thank you very much.
Thank you very, very much, Kedulu. We know you have to go now, and we understand clearly your perspective. But let me just add before she leaves that, like I said at the onset, we want there to be sufficient audience participation. So if you have any questions, please start preparing them. And if you have any questions for Mr. Akeredolu, Mr. Owa Etigwe will answer them in her absence. Thank you very much.
Thank you, Mr. Chairman. Thank you, audience. Thank you, NBA Lagos branch.
Thank you. So we now have Mr. Owa Etigwe to give us his own perspective. Thank you very much. Owa.
Thank you very much, my president, emeritus. And I don't know whether I should thank you for letting the cat out of the bag, that apart from being a lawyer, I've also been a participant in the political process, and the politicians taught me politics 101 that I'm not sure I've recovered fully from. But the issue of electoral integrity is so important because our leadership selection and filtration process is something that is so critical for our development as a nation. So speaking to the topic of today, which is how you can leverage technology to guarantee electoral integrity. My colleague from INEC has told us about the three major innovations that we've witnessed over the years, the progressive innovations we've witnessed over the years. And I agree with him that the BVAS system has really helped in the sense that you can now know the exact number of people who voted during an election, who were accredited, and so on and so forth. So that BVAS is okay. There might be certain need for some slight adjustments. Now, the place where I have a bit of a problem is the IREF. And some progress has been made In 2022, the provision was that the transmission will be done in a manner that is prescribed by INEC. And INEC, of course, gave its prescription that you transmit electronically to the IREV portal. But we saw in Obi and the INEC and Atiku and INEC that was just maybe a secondary means of transmission. It wasn't the primary means of transmission. And we had the court saying that for you to be able to prove any electoral fraud, you still needed the actual Form EC8 A's from the various places where you allege that a fraud occurred. Now, if you take a presidential election, for instance, that position of our jurisprudence is such that it is impossible to establish electoral fraud if it's on a widespread basis. The reason is simple. You have about close to 800,000 polling units all over the country. You have about 8,000 and something wards all over the country. Imagine a trial where you gave one witness just 15 minutes and you were to call 800 witnesses. It's not 800,000 witnesses. It's not possible. You won't finish it, perhaps even in 5 years. So once you have that kind of situation, it is impossible for you to deal with electoral fraud. There are two issues. Issue number one, you need to have the appropriate technology in place. And then you need to have the human beings who administer that technology, who administer it in such a way that the technology will work for us the way we want it to work for us. Okay. Now, if it turns out that as a result of mistake, or let's even say it's deliberate, that system is not meant to work the way it ought to work, then the next thing is that you have recourse, and your recourse is to the courts. But if you have an evidential body that is impossible to discharge, there's not much you would be able to do. And the truth about it is that if somebody gets away with electoral fraud today, he will do it again tomorrow. But if he doesn't get away with it today, the chances that he will attempt it tomorrow will be less. So there's something that we need to do about our own jurisprudence on the issue. Now, thankfully, in Section 60 of the 2026 legislation, it now says that you have to transmit electronically to the IREF portal. Okay, so that's an improvement. But what is this IREF portal? You then go to Section 60, I believe it's Section 64, and it says that the primary election result for the purpose of collating their election results is the Form EC8A. In saying that, is it saying the Form EC8A, the manual version, or the electronic version? Now, the Act doesn't tell us what this IREF does apart from viewing. The whole idea is not for us to be entertained to be looking at the scores on the IREF. The IREF should be done in such a way that it integrates the results from every polling unit and calculates it by itself. Calculation is the easiest thing to do. We all have calculators. Once you punch in the figures, it should tell you that all these parts form this whole. So if the IREF is going to be useful, it should have an embedded correlation function so that you can sum up everything and tell us this is what the result is. Now, if you now have a situation, where assuming somebody says that there was a problem with communication, and then he sends a manual from EC8A or the various other forms at the various levels of collation that is different from the one that was sent to the IREF, what happens? Is it the manual one that is signed by the electoral officer or the electronic one that was sent by IREF? Which one will prevail? The Act is silent on it. And so this morning when I was talking to some of our colleagues, I said part of the biggest problem we have as a country is our political class. Our political class, I do not think, want us to have credible elections. And that's why you keep finding that in the law, as passed by the National Assembly, there will be one loophole or the other that people can exploit. What happens if the IREV, if the transmission to IREV is different from what we eventually find in the manual thing, and you use the manual one for the issue of collating the results? Now, Mr. Keridolu made a very important point. He says that technology alone is not enough to guarantee credible elections. So if he has made that point, that is okay. A teacher of mine taught me that it is better to light a candle than to cause the darkness. Okay, so it's not enough to guarantee electoral integrity. What are the other things that we need? We need to look at our political party system. That is that's the first stage of filtration. It is the political parties that will bring out to us the people that we can go and vote for. If you have 4 political parties and those 4 political parties present idiots, then you're going to choose they're going to choose one idiot of the 4 idiots the political parties have presented. So we need to look at our political party system. And if our political class, especially those in the National Assembly, if they are really interested in the development of the country, then they should legislate independent candidacy. I don't have to be part of a political party to put myself forward for election. And if I'm part of a political party, and you go and through some means you deregister the party, I tell you, go with your party. And then I go out there and we go and slug it out at the polls. So that is something that we should have in our law. Again, our appellate courts have contributed to the problem that we have. The way in which they've construed this issue about internal party disputes, with the greatest respect, has actually encouraged truancy and encouraged rascality amongst political parties. A political party does something that is wrong. You take them up, and then they say these are internal party disputes. What are they saying? They are saying that those who lead these political parties can basically do what they want, and if you try to challenge them, they will strike it down on the basis of what they refer to as internal party disputes. And when you look at the law on this area, the decisions, it's not coherent. The decisions are confused. The jurisprudence is a confused jurisprudence. Because today they will tell you it's an internal political party issue, they strike it out. Tomorrow they will tell you it's not an internal political party issue, it is this particular faction that is the faction that should be recognized. And I'll take one example. Okay, the political party I used to belong to, ABGA. In 2021, the Supreme Court determined that the chairman of that party was a gentleman called Victor Oye. Subsequently, they amended that decision by administrative means and said it's somebody else called Edozie Njoku. Then the man went to the High Court to try and enforce that decision. The High Court enforced the decision. INEC did not obey the decision. They went to the Court of Appeal. Court of Appeal reinstated what the High Court said and said it's Edozie Njoku. Enforce it. INEC enforced it. They went back to the Supreme Court. This was the 3rd journey to the Supreme Court. And the Supreme Court said, no, it is Victor Oye. And so you begin to wonder what really is going on. I still have 1 or 2 things to say. So I think that as a warning bell. And I'll round up.
You will have another bite.
I'll round up in just 2 minutes. Just 1 or 2 more things. I think that, assuming the process fails, there needs to be a robust system that challenges the process. A robust system that does not give somebody who is guilty of electoral fraud any advantage. Therefore, all electoral disputes must be concluded before swearing in. You shouldn't sit as an incumbent and use our resources to pay for your election petition matters. Secondly, we shouldn't have a multi-tier system. That multi-tier system is just a way of giving food to some lazy lawyers, with the greatest respect. If you have an election petition at the level of Senate, House of Reps, or State House, it should just be one tribunal. First court, final court. If it's gubernatorial, it should be the Court of Appeal. First court, final court. If it is presidential, it should be only the Supreme Court. And let's be truthful, I do not see any Court of Appeal having the strength to tell a president who has won the election, you didn't win the election, if they are not the final court. Because you know that if the Supreme Court rules against you, you can be toast. We know what happened to some of our justices in the past and all of that. So let's have a one-tier system, have a 3 months or 6 months period, do the elections in good enough time to finish the disputes before anybody is sworn in. Thank you very much.
Thank you. Thank you very much, Uwa. You know, the thrust of our topic here is technology and elections. But like Uwa said, Uwa has encountered these politicians. And the way he's speaking, you know, he's still feeling some pain from encountering the politicians. And I believe that we'll have more time to address those issues. For me, one of the things we should be thinking about and asking ourselves is, with this AI they are talking about, can AI not be introduced into this electoral process to sift through who voted, who did not vote, who rigged, who did not rig? I mean, when I talk of technology and elections, we should start looking at such areas and seeing how we can bring those things into the electoral space. So let me now go to Mr. Wole Ozi, who is a doyen from INEC, a doyen from the bar, and former Attorney General of Edo State. So he has a very broad perspective. Wole, I'm sure you will keep your own to technology and elections.
I will try. Thank you very much. First of all, let me just quickly appreciate the organizers, the NBA Lagos, for inviting me to be part of this discussion. It's a very important discussion. This is, I guess, is the last law week before the general elections, and coming, as it were, with the reform of the legal framework with the 2026 Electoral Act that was passed in February of this year. Let's just recall that the Act came about as a result of some of the controversies arising from the 2023 general elections. And I don't know why I was invited, whether to speak as an insider in INEC, having spent over 2 decades in INEC, or whether it's my 4 decades as a legal practitioner. But I'll try and give a snippet of both perspectives. So I understand and appreciate what Dr. Bayode has done. But which brings me, let me just quickly start by, he has defined in his presentation, his slide, I'm not too sure everybody saw it, but he tried to define 2 concepts, the IREV. The Electoral Act refers to IREV and calls it IREV, which is an acronym. It's very unusual to have an acronym in an act without spelling it out. It doesn't define it. But fortunately, INEC in its guidelines and from Dr. Bayode's description or definition, it says INEC Results Viewing Portal. IREV is an online public portal that enables real-time upload of scanned form for open access by the general public. So it gives us the perspective what it's for. It's for open access to results by the general public. Prior to now, results were pasted at every polling unit. That is still done. But if you're not in the polling unit, you cannot see it. So this is where technology comes in. Whether you are in your polling unit or not, wherever you are, you can see what happened in any particular polling unit on election day. So that's a beautiful thing. It was not in the Act like that before, so it's an innovation. But has it improved the process one way? In that perspective, it has. Good thing in the Act as well, every political party is required to, something that has not been mentioned, required to keep an electronic register of voters. And during that's section 77, and during the primaries, you are supposed to bring that electronic register out, and it goes on to say that only those whose names appear on the electronic register given to INEC 30 days, 21 days before the election, that can vote and be voted for. As for that second bit, be voted for, I don't know whether that is constitutional. As lawyers, we might have to interrogate that. Is membership of a political party at the time of submission of the names, the prerequisites to qualification to to be voted for at the primary. But that's one of the technological bits that has been introduced by this act. The second definition that Dr. Abayede Lawrence gave was this transmission, electronic transmission. And he defined it thus. I think it says that it's called transmission, electronic transmission of results from the polling unit. That is how, under the slide, result upload and result transmission, it says the direct, let me use this exact words, the direct electronic transfer of actual votes count data, that is numerical figures, from polling units to collation centers. So he has defined that, but Bayade, I think you might have to discuss with your legal department, because the Electoral Act of 2026 has actually defined transmit. And it says transmit means to send, to transfer, or communicate from one person or place to another manually or electronically. Manually or electronically. So the transmission referred to in Dr. Bayade's paper it's not in accord with that in the Electoral Act. And there's a significant difference, and I'll tell you why. In the transmission to IREV, Section 62, the Electoral Act says it has to be done electronically. But in the transmission, for purposes of collation, it says it's silent about electronically. It says it shall be transmitted direct from the polling unit and does not use the word electronically. So when you look at that, that's why you go to Section 155 and go to the definition of transmission, and it says it can be done manually or electronically. So have we moved one jot from the 2023 position and control of IREV? And one thing is important, IREV is not part of the collation. It's not used for collation. As Dr. Abayede Lawrence said, it is for viewing. And it has been defined. The Supreme Court, all the courts have said, it's a viewing portal. It's entertainment, more or less. It's a cinema. You just go and you watch as you watch TV. Because it's not used for collation. What is used for collation is that is transmitted from the polling unit to the next level of collation, which does not say it will be done electronically. So all the controversies, and all of those of you who were hoping that the technical glitch will not be an issue in 2027, I'm afraid that you might have a surprise coming. They are not going to use your result in IREV. So what is the essence of IREV? It shouldn't be just a viewing portal. When there is a dispute between the electronically, the one transmitted from the polling to the next level of collation, when there's a dispute, the Act has actually provided what should be done. It says you bring the paper, the EC8A, then you look at that transmitted to the collation system. INEC in the guidelines says that you transmit to the collation system. INEC does not ordinarily look at the IREV. So that's the problem. The second problem you're going to have, and I think a learned senior advocate who has spoken about that, is purpose of proof, onus and burden of proof. It hasn't changed. And if you want real reform, that is what you should be addressing. The onus still lies on the petitioner, who does not have the beavers. And the Supreme Court, the courts have said, you bring out the beavers and you bring the beavers to court to prove overvoting, to prove falsification of results. You have to bring the beavers to court. And then not only you bring it to court, if you look at the Taylor's case, if you look at all the cases, you now have to demonstrate it. You are not the operator of the machine. INEC is. And again, you have to front load it. You have to front load all documents. Beavers is a document for purposes of the list of documents must contain your beavers. These things are in custody of INEC. But you bring it, you don't know how to operate a beavers. Most of us cannot operate a beavers. Most of us have not held a beavers. But you and your counsel in tribunal will come, open the beavers and demonstrate it. Power it and open it and demonstrate it. Then start comparing results of each EC8A and what is contained in the beavers. How do you expect anybody? So, of what use is that technology that we have used? So, what is the efficacy of that thing we have done? How much better are we in 2027 than we were in 2023? And the interpretation of courts, that's an issue. So unless and until you bring out your register, bring out your EC8A, you have not started. So I think, because of time, as Leonard Silk said, EC8A is still the original and primary source, because in addition to the Evidence Act, you must go to the Electoral Act, the schedule to the Act as to evidence, and then go to the Evidence Act. And EC8A, because what you have is a scanned document, the EC8A, the paper, is still a primary source. So you are building a superstructure, a digital superstructure on a manual foundation, and you expect it to stand the test of time. Whether it does, you say. Thank you.
Thank you very much. Wale, we are navigating technology, justice, and innovation this law week. And Nigeria is a great country where technology is being used by other countries to aid the process. Our own technology may be used to glitch the process. Because what Mr. Ozi is saying now, if you who do not, you have never operated a beaver's machine, but to prove that you won the election, you are required to come and operate the beaver's machine in court. It's going to be a tough call. And then my understanding is better today that IREV is an electronic notice board. That is what it is. Electronic notice board. No more, no less. So thank you very much, Wale. Thank you, Mr. Waitigwe, and thank you, Dr. Bayo. We now want to have questions or contributions from the audience and then and conferees. And the way we are going to do it, we are going to take 2 from this side and 2 from this side. Madam, don't give anybody the microphone yet. We have to identify those who want to ask and make sure that they are equally covered. 2 should be, there should be gender sensitivity in Lagos branch. So we need to ensure that even if there are no gentlemen in skirts willing to ask questions, we will compel some. Like I can see Lady Debbie Budoku, live bencher. I'm sure she has some political interest in her state, so she will ask questions today. All right, you can start with our gentleman over there. Please introduce yourself and let us know if you have a question or you are making a comment. And you have 30 seconds because we have just 5 minutes left.
Thank you. Thank you, Chair. My name is Michael Ikechkwigwebike. I have 5 questions, but I will reduce it to 3, please.
You have permission to ask 1 question, so choose your most important question to ask. Thank you. Understand that other people will also like to have a bite. Thank you very much.
Okay, thank you, Mr. Chair. On the issue of electronic voting, why does Nigeria still use both paper ballots and beavers, what I tag auto-manual voting? Can INEC adopt full electronic voting to make election faster, cheaper, and more efficient? So when we go for voting, you discover that we still use ink to stand the hand and all of that.
Your question is very clear. I'm sure
you.
that we all understand your question.
Thank you, Chair.
And I believe that Bayode can answer the question. Bayode, so just note it, you will answer him later, please. Next question, please. Yes. There's a lady there, yeah.
Good morning, sir. I don't have a question, but I just want to
We don't know you. You look very beautiful.
Thank you. My name is Sandra.
Sandra
Anyanwu. Yes. Sir, Dr. Bios, I'm suggesting, or I think INEC should come up with AI chatbots that would help voters' education and constant reminders on what to do and how to go about it. Because not everybody knows how to speak English, most especially in the northern part of Nigeria, in Kano, Kaduna. Most of the people in that place don't know how to speak English, only Hausa and Fulani. So if there's an AI chatbot that could, maybe like 3 months or 2 months before the election, keep them abreast with what they should know, it will be better. Thank you.
Thank you very much. Nobody from this side? All right, bring the microphone this way. I have some people who must ask questions. Any volunteer from this side of the hall? Give it to the Rear Admiral in front here. No, here. The man in front of you, I'm sure he must have. No. Yes, sir. On behalf of this side, please, make a contribution or ask a question or tell us if you are going to vote or not vote. I'm coming to the next line just behind you.
My name is Vice Admiral Labinjo. Not Rear, Vice.
Oh, sorry, Vice Admiral. My apologies, sir.
The issue of viewing rather than computation, there's a need for INEC to look into it, rather than making the IREV.
Just a notice board.
Not exactly. They should rather make it an operational board that can compute. And when we look at it, we see it, and we know who has won, who has not won. Thank you.
Thank you very much. Please give it to there's a beautiful lady there. She's wearing, yes, she knows she's the one I'm talking to. Just give it to her. She's smiling already. Yes. No, not you, behind you. Yes. After her, you will then have your shot.
Good morning, everybody. My name is Lillian Nwachukwu. I desire that 2027 election will be done free and fair. That's my comments.
Okay, thank you very much. So give it to your colleague next to you. Yeah.
Good morning. My name is Oluwatobiloba. My contribution would align with Sandra, but for the youth, sensitization. We find that many youth are not particularly interested in election and all that it has to offer. So if there's a way to sensitize the youth on electoral processes and what happens after, I believe it will build confidence, yes, in the system. So, thank you.
Thank you very much. We have a past chairman of Lagos branch in the House, former judge of the Federal High Court who has encountered electoral matters and who is very technology savvy, my Lord Justice Taiwo. Please, we want to hear from you on technology in elections.
Well, as far as I'm concerned, if technology is made to technically work without any human input, I think we'll go a long way into ensuring a fair and fair election. Thank you very much.
Thank you very much. Please come back to this side. There's a lady here who wants to. Yes, right there.
Thank you, Chair, sir. My question is to Mr.
I'd like to
Bayode.
know you, please.
My name is Aditola Boknotaiwo. I'm not sure who had mentioned it, perhaps in the introduction, or Mr. Bayode himself, talking about his championing the AI plan for INEC. Is there any significant impact that that would have, or that INEC is planning to impute in the 2027 elections? I mean, as part of your AI framework or AI plan?
Thank you. Thank you very much. I think we've had wonderful comments from the audience. So we now want to hear from Dr. Bayode. After that, we'll hear from Mr. Wole Ozi, and then we'll take the final comment from Mr. Tigwe.
Thank you again, Mr. Chairman. I think I will start from the question about electronic voting. In 2002, like I said in the course of my presentation, that was the time the commission started leveraging technology to support its electoral process. And at the time, the commission came up with a framework. And in that framework, we have what is referred to as electronic voting system. And that is the system that the commission is running with up to today, as I speak. And that system, the electronic voting system of the commission, comprises of four components. Number one component is the voter registration. Number two is the accreditation of voters. Number three is result transmission and collation system. And number four is the electronic balloting, or what people refer to as electronic voting. And since then, we have successfully implemented two of these components. We have successfully deployed technology to support the voter registration. We have successfully deployed technology to support the accreditation of voters. Currently, and we have perfected all this system. Our voter registration, the technology is perfect, and even though we are improving on the system, I think it was just yesterday when the chairman met with some people and he mentioned about online registration, where you can start and finish your registration. You don't need to go to any of our centers to have your biometric captured.
Bayo, the main question they are asking you is, can we have full electronic, or is there justification for having both manual and electronic?
I just want to do this history so that the one who has that question will understand and they will appreciate what the commission is doing. It's not just jumping into electronic voting. We need to build the foundation. And that is what the commission is currently doing. Like I said, we have perfected voter registration. We have perfected voter accreditation. We are currently perfecting result transmission and collation system. And when this is done, these three systems will be wrapped together and put into a box. And that is when the commission will say we are ready for electronic voting. We can't just jump into electronic voting. All these other components has to be perfected. We are still perfecting the result transmission and collation system. And it is this IREF that is dovetailing into the result transmission and collation system. Maybe in 2031, maybe the commission may be ready for electronic voting, but we just need to take it one at a time. Thank you.
Thank you very much, Bayo.
Yeah.
So, Wole, you have heard from them. Everybody says they want a good election. So what are your last thoughts on this?
Okay. I think the most important takeaway from this is that technology is not a silver bullet. It cannot cure all that ails the process. On the contrary, it is susceptible to being manipulated. And I'm sure because of time, Dr. Bayode, and I agree with what he has explained, and he probably will tell you that it's so easy. What he didn't tell you is that severally in the past, our systems have been brought down by hackers. So it's easily susceptible. So you don't throw away a process and think, okay, when we introduce technology, it'll be hunky-dory, everything will be perfect. No, not at all. Not at all. And he in his paper established some of the challenges. Infrastructure is one and things like that. And those of you asking for electronic voting, first of all, the law does not permit it. The law as it stands now says you go there, get your ballot paper, mark your ballot paper and put it in the ballot box. And it doesn't even allow absentee voting. So all those things, unless, even whether INEC is prepared or not, unless the law is changed, when INEC is ready, when the country is ready, then maybe the law will be amended, will be repealed. And it has to be a complete repeal, not an amendment. And that's that. As for those asking for, I think two people mentioned the issue of voter education, voter enlightenment. Yeah, I happen to have been director of voter education for quite a while, a couple of years. A lot was being done. We collaborated with the NBA. NBA had a voter education committee. I think it was Modu Kasim Momodu who chaired that committee. We worked together closely, but that committee is moribund. I don't think I ever heard anything again. So what I'm trying to say is that it's a responsibility of everybody. It's not okay for us to sit down here and say, I need to go and do this, I need to go and do that. The political parties have their role. Civil society, NBA has its own role. You'll be shocked how many lawyers need enlightenment about the process. I go everywhere and people ask me questions, and a lot of the time, lawyers don't even know a lot of what is happening. We're educated, we're elite and everything else, but so much so. If you take a census now, how many people have their vote PVC, how many people have voted, or how many people know that ongoing is the process of transfer of registration for fresh registrants, and it's ongoing, and in a couple of weeks' time, it's going to stop. If you don't vote, if you don't register or do your transfer in next, I think it's how many days by a day? I think it's about 12 days or 13 days in July. If it stops in July, if you don't stop, then you are not going to vote in 2027. So yes, all of us have our roles to play. Thank you.
Thank you very much. I will call on Mr. Tigwe to give the last comments. Our time is almost up, but I have graciously been granted extension of time for 1 more minute.
Thank you. I think there needs to be a conversation amongst the elite and the political class. We need to determine what we want as a country, what we want for ourselves, what we want for our children. Having elections that work is not difficult. Technology will aid it. Technology is not the only thing. has to be a willingness on the part of the political class to legislate the right laws, to support INEC, and to ensure that we have a credible electoral system. Where we are today as a country, we're in dire straits. There's insecurity everywhere. There are all kinds of problems that we have, that we see as Nigerians. So we need to determine whether we want to continue in this trajectory of winner takes all, where the prize or the gain of public office is so huge that people can kill, people can do anything for it. We need to determine whether that is where we want to go. And it is in the enlightened self-interest of the political class to do something now. If we don't, a hurricane is coming and it's going to consume almost everybody, starting with the political class. Thank you very much.
Thank you very much. It's been a wonderful audience. I hope we have all had some benefit to take from this session. But I think that electoral matters of such an important nature that just one session at the Law Week will not be sufficient to deal with all the ramifications and everything everybody wants to say. But I believe we have said enough today. We have lit the fire and it will keep burning everybody. Thank you very much. You've been a wonderful panel. Thank you, Mama, for staying true. We are very grateful that you stay true with us. And I want to thank Mr. Dr. Bayode, who came all the way from INEC headquarters, for making our time to come and support the bar. Extend our warm regards to our colleague, the chairman. Let him know that we are praying for him. We are offering prayers for him that he succeeds. Elections are never easy. To my brother, Tigwe, thank you very much for taking out time from your very busy schedule to come and discuss an unfamiliar terrain, really. Election matters. And I hope that your encounter with the politicians going forward will yield better results. Mr. Wole Ozi, I know you are based in Benin and Abuja, but for you to have come all the way, it shows that you have commitment. Thank you very much. We have enjoyed your contribution and we'll continue to call on you when we need you. Thank you, everybody. I hope you had a good session. I thank those who are coming after us, and our apologies for keeping your session a little bit late. The rain caused the delay. As they say when you're in the airport, your flight has been delayed due to technical reasons. So your session has been delayed due to technical reasons. Thank you very much. Have a wonderful time. Have a great day. I'll call on Lagos Branch Chairman of the Law Week Committee, and Mrs. Harriet Balogun to please join the panelists to take a photograph on stage, as well as our session coordinator and the coordinator of the Law Week. Let's take a photograph on stage before we leave. Thank you very much.
Yes, sir. Mr. Chair, if I may, sir, we have a token to appreciate the panel. Well, we're hoping we could take the pictures along with that, sir, but as the chair pleases. So can we have the branch chair and committee chair and our respected Mama to please come up to join the picture. Thank you very much, sirs. And to appreciate our panel, we have a token to be presented to the members of the panel. And I would respectfully invite AIG Simeon Akpanudom to please help do the presentation to our panelists. AIG, sir. Can we give him a round of applause as he comes up?
Good morning, all. On behalf of the chairman, MBA Lagos branch, and the organizing committee of Lagos Law Week, I present this plaque as a token for a well-coordinated session. Congratulations, sir. Sir, on behalf of the chairman, MBA Lagos branch, and the chairman organizing committee of MBA Lagos branch Law Week 2026, I present these as a token of appreciation for a well-articulated job that you did up there. Congratulations, sir. Sir, it is a privilege to meet you in the flesh. I've been following you online, and you've been doing a great job. Right from when you were at INEC until now, your conversations are always very articulate, and I want to present this as an appreciation for the sacrifice you've made to come out here today. Congratulations, sir. Dr. Lawrence Bayode, on behalf of the chairman, MBA Lagos branch, and the chairman organizing committee of MBA Lagos Law Week 2026, I present this plaque as a token for being on this panel today. Congratulations. Thank you.
Thank you very much, AIG, sir. Can we have a round of applause one more time? And I'll now hand over to China, sir, to continue proceedings. Thank you.
Thank you, Mr. Femi. I think that round of applause was not well enough. They deserve more than that. Thank you. So yesterday we had a very remarkable opening ceremony, if you would agree with me. And we had the presence of the Chief Justice of Nigeria, the Governor of Lagos State, represented by the Secretary to the Government, and the Attorney General of Lagos State, and so many other distinguished speakers. And today we also have a representative from INEC. And I cannot imagine all the work that went behind this stellar event. Please, a round of applause for the planning committee of the MBA Lagos Law Week 2026. To appreciate the members of the executive team and members of the planning committee who has made this possible, I will now invite the chairman of the MBA Lagos, Mrs. Uchenna Ogunedo Akingbade. Please, a round of applause for her while she makes her way to the stage. Please, I need you to do better than that. Thank you so much.
Good morning, my lords, life benchers present, senior advocates of Nigeria, good morning. I just want to take a minute. We'll be taking breaks intermittently to appreciate the people who have made this Law Week a success, made it possible, made it a success. And first and foremost, I want to appreciate members of the Executive Committee of the branch. Please, if you can have members of the Executive Committee of the branch, please come out. Please. They have been the backbone, the soul, the visionaries of everything that has happened so far with this administration, with the support of the members of the branch. Any EXCO members, I know that they are busy coordinating, but for those who are in the hall, please can you come out and take a bow, please? Members of the EXCO, they are all around, I know. For those in the hall, please. Okay. The remaining are all around. Where are the men? At least he's represented. He's represented. The men are all around. Everybody else is all around. They are busy. So the executive committee, I must say, they have been the best teammates. They are very cooperative, very supportive. You know, I couldn't have asked for better. And they've made the work easy and much more tolerable. It's not just the head. When you have teammates that are cooperative and share your vision and even bring in their own creativity, that is all that you see in this administration. Is a product of everything that has been coming from the executive committee and from your good selves. So thank you very much to the executive committee. We'll appreciate them again when we're in our full numbers. Thank you for now. Please, where are the photographers? I think they've stepped out. We're actually supposed to introduce members of the Law Week Planning Committee, but I think we'll move straight into the next session because, yes, they've gone out to coordinate some things. So at the next session, thank you very much. Compare.
A round of applause for Madam Chair as she goes back to her seat. Make that better. That's my superstar chairman there. Thank you so much, Ma, for making the bar remarkable. A round of applause for her. Please make that better. Yes, thank you. Now we're moving very quickly because we have to get to our next panel session. How many of you enjoyed this panel session? How many of you enjoyed the first panel session? A round of applause for them one last time. Really, really insightful. I hope you all have your PVCs and you'll be voting next year. You all have your PVCs. You have your PVCs. All right. Now, we are set for the 5th panel session. Hot topic. It's called a hot topic. The Cyber Crimes Act and freedom of speech. Justified derogation or overreach. And in this panel session, you get to hear from distinguished panelists who are experts on cybercrime, data protection, and law. But doing the honors of introducing the members of this panel, we have a member of the Law Week Committee. Just one moment, I'm trying to pull up his name. Okay, what I will just do will be to hand over this particular session to the moderator of the committee. A hot topic. All right, please put your hands together for the session coordinator, Yemisi. Make that better, make that better, make that better. Thank you.
Good afternoon, everybody. Distinguished learned senior advocates here, members of the bar, and our guests.
Thank you.
This is the next session, and you can see there is a power-packed. Look at the members already. So this topic is clearly a burning issue, and we're ready to dive into it. The discussion will be on the Cyber Crimes Act and freedom of speech, justified derogation or an overreach, with a question mark. And we have seasoned panelists that are here to dive right into the topic, and I would waste no further time. I'll be starting with Mr. Ikenna Okoli, SAN. He's the chairperson and the moderator of this session. Let's make him welcome. He's the principal partner of IOLA Services, and is a distinguished legal practitioner and litigator. The next panelist I'll be introducing is our AIG, Mr. Simeon Akwanodom. Thank you very much, sir, for honoring us on day 2. We really appreciate you, sir. He is a distinguished police officer with over 3 decades of exemplary service in the Nigerian police force. And he's done extremely well in criminal investigation, intelligence, operations, and administration regarding this area. So we thank you very much. The next panelist I'll be introducing is Dr. Olumide Babalola. Dr. Olumide is a lawyer, scholar, a leader in privacy, data protection, and data rights law. He's definitely wearing lots of caps, and we are happy to have you, sir. The next panelist I'll be introducing is Ms. Chineye Orago, the power-packed woman. Look at her, right in the middle. I love that, gender balance. She's the founding partner of Calm Hill Partners, and she's a seasoned legal practitioner as well, with her expertise in technology law, data privacy, and protection. You're welcome, ma'am. Next panelist I'll be introducing is Mr. Olurotimi Aju. He's a partner and deputy head of dispute resolution at CLP Legal. He's a fellow of the Chartered Institute of Arbitrators, and he's also equipped to deliver on this topic. You're welcome, sir. Let's make him welcome. The next panelist I'll be introducing is Mr. Kolade Olawuni. Mr. Kolade Olawuni is a partner and head of intellectual property, privacy and data protection at the law firm of Babalaki & Co. Mr. Olawuni has technical expertise in this area as well, looking at development, implementation of comprehensive data governance. So he's definitely one of those that should be on this panel. You're welcome, sir. And last but not the least, Mr. Jude Igbanoy. He is the GH Legal and Compliance. These day newspapers, I mean, we can't discuss this topic without having someone from the media, because it's a media-related, you will all understand that. So Mr. Jude is also the co-founder, or rather he co-founded the MBA Lawyers in Media Forum. You're welcome, sir. And that's our panelist for today. So I'm going to hand over the mic, of course, to our session moderator and chairman, and we'll get right into it. Thank you very much.
Thank you very much, Yemisi. Good morning, distinguished colleagues, distinguished guests, ladies and gentlemen. Our discussion today focuses on a question that sits on the intersection of constitutional democracy, technological advancement, national security, and civil liberties, which is basically to say, does the Cyber Crimes Act represent a justified limitation on freedom of expression, or has it become an instrument of regulatory overreach? The issue is particularly significant given that digital platforms have become the modern public square. Citizens engage in political discourse, investigative journalism, activism, business, and social interactions. But of course, these same platforms have also become vehicles for cyber stalking, misinformation, identity theft, and other harmful conduct, as it were. Now, the challenge before us is therefore not whether regulation is necessary, but how far regulation can go before it begins to undermine the constitutional freedoms it seeks to protect. Section 39 of the Constitution guarantees freedom of expression and freedom to receive and impart ideas. But that freedom is not absolute. The Constitution itself recognizes derogations, and which may have to do with defense, public safety, public order, public morality, and the protection of rights of others. The question, therefore, becomes, where should the line be drawn? This discussion is particularly timely in light of the amendment to the Cybercrimes Act and the ongoing debate over cyber stalking provisions, prosecutions for online speech, judicial oversight, and the future of digital governance in Nigeria. And as you can see, I have a most distinguished and eclectic panel to dive into these discussions today. I will start off by throwing a question to the panel, and I expect each panelist to give us his or her own view or answer to this question. So, to the panel, do you believe the Cybercrimes Act in its current form strikes the correct balance between cybersecurity and freedom of expression? Why or why not? I will start with Mr. Ibanoy and take it from there. Thank you. In 1 minute. Yes. Do you want me to repeat the question?
Oh, is it me?
Ibanoy.
Oh, me.
Yes.
Yeah, thank you, Mr. Chairman. Thank you, audience, and MBA Lagos branch, of which I'm a member. Like I said during the press conference, when I saw the loaded program of the Law Week, I said this can easily pass for a mini MBA annual general conference. And I commend the committee that put this together. I will make my comments strictly from the perspective of the media, because my secondary constituency, the law is my primary constituency, but I will not be happy if I don't speak for the media. Actually, it's a two-edged sword looking at the Cybercrimes Act. Like the chairman already said, there are no absolute, there's no absolutism, the freedom of speech as provided in the Constitution. But there are worrisome developments that we have seen, which is one of the things I'm going to speak about. It will surprise you to know that Nigeria has one of the most comprehensive laws on cybercrime, despite the fact that we came late. I will probably speak more on that when it comes to the question about comparing USA, UK, India, and Nigeria. But we have a problem in implementing the provisions of this act. What is the problem? The security agencies that investigate, arrest, and prosecute. Now,
Mr. Banoy, I'm sorry if you don't mind.
when we get, or as we move on, I just need you to, because I said you just have 1 minute. Do you believe the Cyber Crimes Act in its current form strikes the correct balance between cybersecurity and freedom of expression?
Yes, absolutely, I believe.
Very well. Thank you. If we can hear, yes.
Okay, thank you. I'm sorry, I'm going to disagree with Mr. First of all, thank you for the invitation. And I think this is a very timely conversation, looking at what is happening in the country. I think before we answer that question, we should just go look at Section 24 of that Act. Incidentally, I've been litigating this thing since 2017. We are at the Supreme Court right now, and we went to the ECOWAS Court. We got judgment at the ECOWAS Court. Now, does it strike a balance? Section 24 of the old Act, as well as the repealed one, criminalizes any speech that is grossly offensive. Those two pieces of legislation do not define what grossly offensive means. That is one. Also, in that provision, it criminalizes any speech that contains insult or annoyance. These terms are nebulous, because what is insulting to you might not necessarily be to me. So if the law does not clearly define what it means for something to be grossly offensive, then that means it's not really striking the kind of balance it should strike. We agree that freedom of expression, like all other rights, is not absolute. But everybody should know the limits of what you are meant to say and what you are not meant to say. And if you look at the antecedents of these things, that's why I would say it doesn't strike a balance. The way that provision has been weaponized.
Thank you.
When I speak next, I'll talk to that.
We'll get there. The AIG, sir.
Thank you, Mr. Chairman. Thank you, MBA Lagos Branch. Yes, I acknowledge that the Cybercrime Act strengthens Nigeria's cybersecurity framework. I must mention the offenses that justify that. Cyber fraud, identity theft, cyber stalking, which has remained the most debated offense because of the concerns over broad wording and the possible misuse. But I want to state clearly here that the police objective is not to suppress speech, to respond to genuine criminal conduct online. So my view provides a very strong foundation that this act needs to be clearly enforced, and also the guidelines should also be clearer. Thank you.
Very well. Ms. Arago, can we have
Thank you. Good morning, all. I stand on existing protocol. My view is that the Cybercrime Act is one of the most significant legislation that has been enacted to govern the digital age, because it's very important that citizens and also critical infrastructure is protected from cyber crimes. However, the question is, does this particular act, cover that constitutional provision that guarantees freedom of expression? I will start to say that the previous act, that is 2015, which was amended, was really draconian, and even the ECOWAS courts made a ruling on that Section 24 breaches the constitutional right to freedom of expression. Now in the new act, as amended, Section 24 was amended, and it took out all that thing of offensive, insult, injury, and now replaced it with this provision that says it is a crime if you make a statement that you know is false with the purpose.
I'm sorry to interject. Sorry. I'm really sorry.
Yes.
I just need.
Okay.
In this current form, do you think it strikes a balance between cybersecurity and freedom of expression?
I don't think there's a balance, because there still needs to be clear provisions that protect freedom of expression. Respect especially for the press, they are not covered.
Thank you.
Thank you.
Thank you very much, everyone. I align myself with Dr. Olumide Babalola to say the current form of the law, the current enforcement procedure of the Cybercrimes Act is an erosion of the guarantees of freedom of expression guaranteed to every human being in Nigeria as enshrined in the Constitution. And I would read a phrase from the judgment of my Lord. I will do it in 30 seconds. My Lord Honorable Justice Ogunwumiju, JSC, in a decision in Avioma and State, I think it settles the issue. My Lord said, not every offensive or reputationally damaging online publication amounts to cybercrime. Where the gravamen of the complaint is injury to reputation, the law of civil defamation ordinarily provides an adequate remedy. The use of criminal sanctions in such cases raises concerns about proportionality, freedom of expression, and the potential, underline, potential misuse of prosecutorial powers. The implementation today, everywhere you go, has been an expression of misuse of those powers. Thank you.
Thank you very much.
My view is that from where we're coming from in the 2015 iteration of the Act, the current piece of legislation is an improvement, and to that extent, it is work in progress. Most of the subjective provisions that relate to annoyance or most of the provisions of the old Act have been taken away. And to that extent, I would think that it's an improvement. It is still work in progress, and there's still a bit to be done in the area of gaps in the place of even the drafting of the legislation itself and the resultant gaps that gives in the area of enforcement. It's not a perfect law, but it's work in progress.
Thank you. The next question is for Mr. Aju. So, given the constitutional guarantee of freedom of expression under Section 39 and the derogations permitted under Section 45, do you believe the Cybercrimes Act, particularly its speech-related provisions, meets the constitutional threshold for a justified derogation?
Thank you, Chair. Section 39 of the...
You have 3 minutes.
Section 39 of the Constitution guarantees the right of every citizen of Nigeria to freedom of expression. This constitutional guarantee includes the freedom to hold opinion, the freedom to disseminate and receive information and ideas without interference. Section 45 then comes to say circumstances in which derogation is permissible. In section 45, we have broad-based instances. In instances where in instances of defense, public safety, public health, public morality, and even public safety, or for the purpose of protecting the rights of other people, which are guaranteed by that same constitution, there is permitted derogation. And I must say that these laws have been interpreted rather broadly in the interest of citizens. Right, so we now move to Section 24 of the Cybercrimes Act. In Section 24, Section 24 attempts to take from the Constitution the restrictions imposed by the Constitution on when rights can be derogated from. For example, where it talks about in the interest of public morality, Section 24 of the Cybercrimes Act criminalizes the dissemination of pornographic material. And pornographic materials go into the area of morality. So to some extent, as I've said with that example, there is the effort and the attempt by the drafters of the law to align the provisions of the Cybercrimes Act with those of the Constitution, especially in the area where derogation is permitted. However, as I had said earlier, there are gaps that make abuse, especially in the area of enforcement, rather inevitable. Whilst there has been growth, there has been progress in the area. I mean, from where we're coming from, which made offenses absolutely subjective until the present age now. There are still gaps in terms of the ambiguities and the vagueness of some of the provisions of Section 24. If we look at some of the case laws that have emerged from regional courts, like the ECOWAS Community Court of Justice, and even our own Court of Appeal, these rights have been, these certain provisions of this Act, especially in Section 24, have been held to derogate or to not align with the constitutional guarantees in Section 24.
Okay, so thank you. I will move to you, Ms. Orawu. From a technology policy perspective, are constitutional principles alone sufficient to regulate today's digital ecosystem, or must they evolve to address modern online realities? You have 1 minute.
Okay, thank you. I think constitutional principles are sufficient. And what you need to have is to have legal framework, a detailed legal infrastructure that surrounds some of these elements. When we talk about the digital age, it evolves rapidly. We cannot change our constitution all the time. It would not meet up. So what happens is for the National Assembly to enact future forward laws. And when you enact such laws, it's now for the courts to interpret it to ensure that there's constitutional principles are kept in line. So that is what is supposed to happen, not that we have to amend our constitution all the time. These enduring principles in the constitution, like fair hearing, dignity, all that are enduring principles that every legal system is built on. We should just interpret the laws to ensure that we go with these principles and that the National Assembly enact laws that go with the times in digital space. Thank you.
Thank you very much. Mr. Adjo, I will come back to you. So, should online speech enjoy the same constitutional protection as speech expressed through traditional media?
Well, my simple answer will be yes. The Constitution does not make a distinction between platform in guaranteeing the the freedom of citizens to expression. It doesn't matter whether, it should not matter rather, whether the opinions expressed are contained in a tweet or in traditional media platforms like newspapers or something. So my simple answer would be yes, it should be the same level for both digital and other forms of communication or expression.
Thank you very much, Mr. Adjo. Now I come to you, AIJ, sir. So from an enforcement perspective, do constitutional concerns sometimes underestimate the real harms caused by online abuse and digital misinformation?
Thank you, Mr. Chairman. First of all, let me begin by affirming that there are constitutional rights. These are fundamental, not absolute. I also want to make it clear that online harm is not abstract. It can destroy reputations, incite violence, fuel ethnic and religious tension.
Now, even upon the amendment that we litigated at the ECOWAS court, in 2024, a journalist was detained and prosecuted for reporting corruption, even upon amendment. That same 2024, another one was, about 3 of them were detained also for reporting corruption. In 2025, another one was prosecuted for reporting governance-related stories. So the law itself is problematic. And if the law is not clear, whoever is prosecuting will just take anything to court. But before we even get to the bottom of the matter, the person has been detained, the person has been prosecuted for years. Before you come back to say the High Court decides, he goes to the Court of Appeal. So the law itself needs a proper refining so that it is clear from the beginning when lines will be crossed. Now the amendment says speeches that can threaten life, and there is even a part of the amendment that's not even complete. And I'll urge you to take time to also read the Cybercrime Act. Do you know that Cybercrime Act criminalizes passing off? Section 25 criminalizes passing off. That if you use another person's business name, then you have committed a crime. These are things we really need to look at, because if the law itself is jaundiced, there is no way the people prosecuting will not misprosecute. There is no way they will not misarrest and incarcerate people on the ground of. So the law itself has a problem, and as well as the enforcement. Thank you.
Thank you very much, Dr. Babalola. AIG, I'll come back to you. So, law enforcement agencies maintain that these provisions are necessary to protect citizens from harassment, blackmail, and harmful conduct. How do investigators distinguish criminal conduct from legitimate criticism?
Thank you, Mr. Chairman. The investigators will distinguish between criminal conduct and legitimate criticism by looking at the elements of the offense, not the status of the complainant. Legitimate criticism will include fair comments, public interest reporting, satire or harsh criticism of public officials. But the criminal conducts include blackmail, extortion, persistent and targeted harassment, incitement, identity theft, doxing. A lot of personal information are put on the public space, unlawful disclosure of private data, or deliberate falsehood designated to cause harm. So investigators ordinarily will ask, what exactly was posted? Was it a fact, or an opinion, a satire, or a threat? Earlier, public interest, journalism, satire, robust political commentary should not be treated as criminal or merely a civil reputational dispute. Thank you.
Thank you, AIG. I'm still staying with you. So, where should investigators draw the line between a robust attack on public officials and criminal cyber stalking?
To start with, the line is very clean. It is between criminal conduct and no criticism. That's where they draw the line. And there are also internal safeguards to that. The first is the Constitution. And there is the fact that there must be evidence. There is also supervision, legal review, and court oversight. So we have to always put these safeguards in place. And the line is, as I've said, between criminal conduct and no criticism. Thank you.
Thank you very much. I come to you, Mr. Banoy. Do comparable jurisdictions face the same criticism of over-enforcement, or is Nigeria's experience unique? I said, do comparable jurisdictions face the same criticism of over-enforcement, or is Nigeria's experience unique?
Well, I would say Nigeria's experience is unique in the sense that there are certain provisions of the Act, like the battles that Dr. Olumide Babalola is fighting right now, about the ambiguity, opaque provisions of Section 24. He probably didn't mention some of the cases he has done. Even when you look at the cases he's doing now, he has done, I do not see him landing. Well, let me not be guilty of sub judice. The Okedara and Attorney General of Federation, I don't know if you were in that case. The Court of Appeal still has not addressed it. He lost at the High Court, lost at the Court of Appeal. He still has not addressed it. But why I think Nigerian's case is unique, because number one, we are not too clear as to the specific agency that's supposed to investigate and prosecute. You have the DSS investigating and prosecuting. You have the police and all of that. It doesn't all go away. It makes it unique. In other jurisdictions, it's not like that. Look at the case for which Showore is being prosecuted for. Is, as we speak, is at Kuje prisons. Now, the challenge or the uniqueness of our situation, or the peculiarity of our situation, is that 80% of the crimes under cyber crimes are that media people are arrested and prosecuted for are purely civil cases, libel. Now, the challenge that these security agencies have who are prosecuting is that they grab somebody for a case that has all the characteristics of libel. They don't know what to do with it. Like Showore's case, he was accused of cyberbullying President Tinubu and other people. Yes, it's between him and Tinubu. Tinubu can take him to court for libel, but the Constitution provides at Section 308 absolute immunity. That immunity clause placed DSS in a quagmire. Tinubu cannot sue Showore for libel because of immunity clause. Because the immunity clause
isn't the immunity about suing him. If he wants to shed his immunity to institute an action, nothing stops him.
No. The Supreme Court has decided in Gani Fahimi and Inspector General of Police that you cannot waive your immunity.
No. We are saying two different things here. Whether you want to waive your immunity, from what you're saying, are you then saying that if a governor, for instance, wants to institute an action that he cannot on the basis that he is covered by immunity, as different from you then suing him and the court saying, oh, he cannot even waive his immunity upon a suit coming from you? I think there are two different things, but let's not get into that. So I take it, well, you've basically said that the Nigerian situation is unique so that we don't overdwell on this issue and move on to something else, if you don't mind. I will come to you, Mr. Olawuni. What role should the courts play in ensuring these provisions are not used oppressively? In 1 minute.
Okay. So I'd mentioned earlier that the Constitution affords us certain rights, particularly as it relates to the conversation here, the freedom of expression, and the likes of it. But the same Constitution goes ahead to state, and we know that those rights can be curtailed for a reasonable cost, and one of those reasonable costs in the course of which statutes. The statute that seems to curtail that right of expression in this instance is the conversation we're having today, which is the application of the Cyber Crimes Act. So the question you pose to me is, what should the courts do so that their interpretation and subsequent decisions of cases coming before them, criminal cases coming before them, charged under the Cyber Crimes Act, do not overreach the should I call them the salient provisions of the Constitution? Well, the first thing, and I think the first invitation for any court in Nigeria is they have a duty to distinguish between genuine cybercrime offenses from common disputes concerning reputation. I will cite an example. The chief executive officer of a big institution in Nigeria, was alleged, there's an allegation from him that a particular blogger wrote a false and erroneous blog or statement on his blog against him. What did we see? This person was charged at the Federal High Court for cybercrime offenses. This person was remanded at the correctional center. The first thing you should ask yourself, or I would ask myself if I was a judge, is yes, there's a law that sets out criminal liability for this alleged offense. The first question is there any civil remedy? The answer is in the affirmative. So, the mere fact that a statement is published online should not transform a civil wrong to a criminal offense. Like I said, application. Finally, I have several points, just for 1 minute. Courts should adapt interpretations, and this is the duty of the court, that preserve constitutional freedoms rather than expand criminal liability. Enforcement of the Cybercrimes Act as it is would reduce our contracting freedom, freedom of expression, and erode the ground norm. That is the Constitution. Thank you.
Thank you very much. What you're saying, I imagine, is just basically maybe the same argument about, so-called criminal defamation, where most jurisdictions in the world have done away with. If somebody defames you, that you should go to a civil court and ventilate your grievances. Now, I come to Ms. Orago. One of the greatest challenges globally is distinguishing harmful misinformation from protected expression. Where should the line be drawn?
Press your
Okay. So this is Okay, so this is one very difficult question that you get in the digital age, because we have two compelling constitutional values. One is the right to freedom of expression, and the second is the right for the state to protect the citizens from danger, from harm. We have Section 39, and it says that you're free to express yourself, impact information, impact ideas, but it's not an absolute right. We have Section 45 that brings about all the restrictions, and we know all the exceptions where there is danger, public health, public order, where there's going to be a breakdown. Now, let me give you a live case that just happened. Somewhere in the east, very close to my town, someone did a video, I don't know if many of us saw it, and said that there's a helicopter flying, and it has landed, it was bandits, and they were, throwing down guns and all that. I'm in a WhatsApp group for women in my town, and I saw the chaos that happened from that information. So you can imagine what happened in the surrounding area where the things were supposed to have, landed. And people, swung into action. They went, they found the man. And when they interrogated him, guess what he said? Oh, that someone told him that he actually saw the helicopter, but he did not see it land. And someone told him that something was dropped. So that is a breakdown of public order. And that person has been handed over to the police. We have to draw that line. But in drawing that line, where should we draw it? There will be falsehood. People are going to exaggerate. So is it that we want an internet or online communication that is free from lies? It's not really possible. So in talking about how to draw the line, we should look at three things: legality, necessity, and the proportion. If the law enforcement agencies and the courts look at these elements, then they will not go above board. Also, another thing we need to look at are three things. Check if there's deliberate falsehood, malicious intent, and identifiable harm. So it's when you notice these elements that you're now able to now draw the line. so that we don't have a situation where we just have arbitrary censorship. Democracy is founded on robust conversation, participation. We need to talk. We need to ventilate. Where you see a situation where somebody comes in and says, oh, the vaccine is contaminated, people should not take the vaccine, that is a breakdown of law and order, public health is being injured. In that kind of case, that person should be picked up and asked, where did they get that information? But where a normal citizen comes out and says, I do not agree with the policy of this government and all that, that person should not be arrested. Interrogate it. Look at all those approaches that have been stated and find out if those elements exist. Thank you.
Thank you very much, Mr. Algo. You have to. Now, I come to you, Mr. Lawoni. Should false information always attract legal consequences, or should the law intervene only when actual harm can be demonstrated? Quickly, in 2 minutes, please.
Okay, thank you. Like I said earlier, I think false information has been dealt with, or is being dealt with in civil law. And civil, as I know it, particularly received English law, particularly law of torts, brings up issues of defamation, libel, slander, or which are types of wrongs or injury against the person of a national, which are maybe statements in either written form and increasingly now electronic form, which is what the Cyber Crimes Act now seeks to put on the front burner. If there is a wrong, what are the sanctions? I believe that the laws of defamation are set out, cater very adequately for these wrongs. We know that the implementation of defamation itself, or defamation can be both a tort and a crime. That's why Mr. Chairman had mentioned criminal defamation and the likes of it. And it is clear that criminal defamation is now being expunged from our laws because, like I explained earlier, once you have a remedy in civil law, why do you criminalize the effect as well? Criminal law should always be, and I said that it should be an instrument of last resort. Where the remedies exist, you shouldn't go for the punitive one when you can damnify the conspirator or the offender, either in damages, costs, awards, and the likes of it. There's the last part is the fact that criminal defamation seeks to live and is on its way out of the Nigerian legal jurisprudence shows you that there's a problem with that particular, and I've heard people say it here, in Section 24 of that law, which seems to say that even you and I, when you compose a text message on your WhatsApp, before you send it, I would ask you to read it a second time so that you don't land yourself under the wide interpretation afforded to it by Nigerian prosecutors and increasingly by the Nigerian courts, so that you don't wind up in Kirikiri Correctional Center. Because prosecution, from what I have seen so far, is largely at the whims of the prosecutor. I believe that the judges, even though in several instances, have held, and of course there are several judgments that we can reference here, have held that the provisions of Section 24, in fact the entire Cyber Crimes Act is in line, is an effective law, is in line with the Constitution and does not erode from the Constitution. But I believe that that is not a standalone by itself. The way offenses are being investigated, those offenses are being charged, and even though the outcome is not very prevalent, those processes that lead to maybe a sentencing or the thereabout erode the sacrosanct constitutional provisions. Thank you.
Thank you, Mr. Olawone. Now, I would, to the panel, there's a hypothetical scenario. So a citizen post allegations of corruption against a public official on social media. The allegations later proved inaccurate. Should this amount to a cybercrime, defamation, protected speech, or something else entirely? 30 seconds each. I will start with you, Mr. Aju.
So public officials by nature, I believe, enjoy there's a higher degree of scrutiny in respect of actions of public officials. Falsehood in itself cannot be basis for prosecution as a cyber crime. It must meet the standards prescribed in the Constitution and also under the Act, for it to qualify as a cybercrime offense. So my answer would be that in this hypothetical scenario, there are civil remedies that are afforded to the public official. He can deal with it in defamation, where he has to prove the falsehood of that allegation, and perhaps go ahead to prove what damages he has suffered. Certainly, it doesn't fall within the remit
Thank you very much.
Cybercrime.
Mr. Laguni.
I'm not going to say that the implementation of the Cybercrimes Act is largely for victimization of the oppressed, largely. We know the reluctance of law enforcement agencies to prosecute capital offenses, armed robbery, culpable homicide, and the likes of it. How is it not curious? They are very, very eager to file charges for online abuse. I answered that question in the negative. I believe it's an instrument of oppression. The only recourse to any online abuse that is not a type that has national security connotations by the provisions of this law should be remedied in civil court. Thank you.
Thank you. Mr. Arabu. 30 seconds.
The person cannot have recourse to the courts for cybercrime-related crimes because Section 24 specifically states that when you made the statement, you must have known that it is false. So proving that will be an issue. Therefore, I would recommend that the way the person should go is by way of defamation in the civil courts. Thank you.
Thank you. Jason.
Yeah, thank you, Mr. Chairman. The poster in itself is very explanatory because you say the allegations were further proved to be inaccurate. In the first place, you have to be sure of what allegations you are laying, because it's not just enough to make allegations of corruption against someone without evidence. There must be evidence for that. And in the course of investigations, it's not just enough that you walk into a police station and make allegation and it's accepted hook, line, and sinker. It's not. You have to give enough evidence for the police to act. And if you can't provide such, there's no way the police will act. So if the person fabricated whatever allegations he's making, the law criminalizes that and he should go in for it. But if actually the man is proven to have been corrupt, the relevant laws are there to handle that. That's my take on that. Thank you.
Dr. Babalola.
Without sounding controversial, Cybercrime Act is for the rich. We all know that. We have written petitions many times up to the Inspector General of Police. When they look at the complainant, when they see you don't have the kind of status that people who use that law, you just find out that your petition does not even see anywhere. So we've seen situations many times that it is used to oppress the poor, the journalists, the downtrodden. So for me, if we interpret the provision of that act or whatever fact we are being laid, if we interpret it properly, we see that it's not every case we should have prosecuted. So for me, no. I don't think it's something they should prosecute.
Thank you very much, Mr. Banoy.
Well, we all seem to agree, basically, at least most of us, that the scenario you painted is strictly has the characteristics of a civil offense for which you cannot prosecute and criminalize unnecessarily. That is the situation we are facing in the country now. I believe very strongly. Dr. Gowala just said that it's for the rich. Yes, the rich, I'm sure, in my interpretation, would mean the president, the vice president, the governor, the deputy governor. Section 308 protects them. But the dilemma, the quagmire we are in right now is that the security agencies or investigative agencies like DSS, SSS, and police are confused or are stuck with, okay, you have said this kind of statements about this person. Because of immunity cannot sue you, we are suing on his behalf. In fact, the DSS made a very careless and irresponsible statement recently where they said we are prosecuting Sowore on behalf of Tinubu. It's online. I was shocked when I saw it. How dare you prosecute on behalf of another? Because in law, libel is an action impersonal. It's only the person, strictly the person, not his child, not his wife. And when that person, if anything happens from matters I've been directly involved in, General Musa Bani,
Mr. Banoy, I'm sorry I have to cut in here. I'm really sorry. Okay, so I will enlarge your time for another 30 seconds. So finish round up.
Now, if somebody is standing trial for libel and somewhere along the line the person dies, that action ends automatically. His child, his wife, anybody cannot come for, okay, my father sued for libel, he died, I will continue. It's not a land case. You are not disputing ownership of a company. If the person dies, the action dies. It happened in the case of Chidebo Akonde, SAN, General Musa Bami, SAN, which I was directly involved in this day. When they died, the matter died immediately. So what is going on now, which is a little bit more worrisome for me, is that our security and prosecuting agencies are not yet well deepened and well informed about the provisions of the Act and who is supposed to be brought in on the provisions. They are arresting people for libel and say it's not. It cannot be. It will further worsen the whole case.
Thank you very much. Are you giving our security agencies the benefit of the doubt, or is it a case where they know, but they decide to choose to
Absolutely. For instance,
do what they want to do?
Yes. In the Tinubu case, Showore's case, they admitted that Sowore did not offend anybody apart from Tinubu. They recognized, their lawyer advised them, look, the president, because of immunity clause, cannot sue Sowore. They now went to arrest him.
In addition, even when the law was amended, even after it had been amended, prosecuting agencies were still prosecuting on an amended law. I mean, on the repealed one.
Very well. That's interesting.
It also happened in the Dele Farotimi case. They didn't know that law for which he was grabbed, abducted, had been repealed in Lagos, in Ekiti, and everywhere. They arrested him in Lagos. The law didn't exist. They took him to Ekiti. The law didn't exist. I mean,
very well. Thank you very much. Now, Mr. Aju, I will come to you. Should the constitutional limits of the Cyber Crimes Act continue to be developed incrementally through judicial interpretation, or has the time come for the National Assembly to revisit the Act through legislative amendment? 2 minutes.
Okay, thank you. I must commend our courts. They have been quite liberal in interpreting provisions that seek to curtail the freedoms guaranteed in the Constitution and from which the Cyber Crimes Act derives its force. As far back as 1993, the Supreme Court had held in SSS and Agbakuba that the freedoms guaranteed under Section 39 of the Constitution include the freedom to criticize government, including its policies. And you will think that such bold statements from our courts decades ago would have built up into a body of laws that would allow for certainty, in this era of cyber crimes regulation. But again, I would also say that it was a recommendation by one of the regional courts, I believe the ECOWAS court, that led to the amendment from the very subjective 2015 Act to the Act which I have held, to the current Act, which I say is still work in progress. So our courts have done their own bits. But I think the time has come where, for certainty and to cure some of the vagueness and ambiguities that this panel has identified in the existing law, we must go the way of legislation so that we cure once and for all. The courts can only interpret what is put before them, no matter how liberal or how broad-based they would like to make those interpretations, but there must be certainty. The courts must define for us, the legislation must define, like if we borrow from America, the First Amendment has language like clear and present danger, So we must know exactly under what circumstances are prescribed by law for cybercrime offenses to ensue. Thank you.
Thank you very much. Ms. Aragu, I would do a follow-up on this. So technology evolves much faster than litigation. Can the courts realistically keep pace with emerging digital challenges, or is it ultimately the responsibility of the National Assembly to enact legislation that can adapt to technological change? In 2 minutes.
Okay, so I don't believe the courts can keep pace, and we all know why. Before a matter finishes from the High Court to the Appeal Court, and probably the Supreme Court, the technology that gave rise to the subject matter, that is dispute, what I was in dispute, would have either been obsolete or has evolved in many cases. So it's very unlikely that the courts can keep pace. But is it a function of the courts and the National Assembly, trying to meet up? I believe that each arm of government should do what they are supposed to do. So for the National Assembly, Section 4 of the Constitution vests with the right to make laws. Now, when it comes to technology, they should make laws that are technology neutral and principle based. So when they do that, what happens is that it regulates conduct and legal consequences instead of the technology itself. That way, even when it changes, you still have a good law. Then for the parts of the courts, Section 6 of the Constitution vests them with judicial powers, which includes the power to interpret both the Constitution and the legislation. So what should they do in this case? They should interpret it in line with constitutional principles, and they should be bold, as they would say. Because we all know, look at common law. It has evolved over time. Torts, evidence, all those principles, due to what judicial activism, have been expanded. The digital era cannot be different. Therefore, the courts should ensure that in interpreting it, they interpret it in line with the current realities. Thank you.
Thank you very much, Mr. Aragu. Now, to all the panelists, if you could amend one provision of the Cyber Crimes Act tomorrow, what would it be and why? I will start with Mr. Banoy.
I strongly believe that Section 24 is still not well settled until probably Dr. Babawala goes to the Supreme Court and the Supreme Court makes definitive. I believe that that section still needs further amendment because he is arguing that the provisions of the section are too vague, opaque, and all that, yet they are carrying on in that. That section, in my view, needs further examination, further amendment. Let's have a clear cut definition of what the various provisions like he enumerated Otherwise, we'll still be carrying on the way it is now.
Thank you very
and
much.
I urge everybody to, as much as possible, read that case, Okedara and Attorney General of the Federation, and if you can, try to access the book, Contemporary Law of Thought in Nigeria by Uche Valu, BSN. It's so very, very well detailed, chapters 10, 11, and 12. If you read it, it will address all these things we are talking about. He cited a plethora of cases, Zirim, Anuzirim, Access Bank, and Abubakar, so many, that if you read the book, all these things we are discussing about are clearly settled. In fact, one aspect of that book which will come up soon, which people will be, many people here are not aware, that WhatsApp is very, very dangerous if you want to implement the provisions of this. Ordinary sharing a message. You are not the author of that message. You didn't create the message. You received it maybe in a WhatsApp group. Oh, it's interesting. I sent to Babalola. Oh, it's interesting. I share with people. You can be arrested and prosecuted for that. The way the law stands now. If that post you are sharing is under the act like pornography, like you talk about slander and all of that, if it sharing alone can put you in trouble.
Thank you. Dr. Babalola.
So because many people will be talking about Section 24, I won't talk about that. I'll talk about Section 25 and Section 17. While I was preparing for this, I discovered that under the Cybercrime Act, and I hope some heads of court are here, under the Cybercrime Act, the law actually forbids digital signature, electronic signature for affidavits. I discovered that yesterday. So Cybercrime Act says we cannot sign affidavits and some other court documents electronically. Yesterday, CJN was here, the admin judge of the Federal High Court was here. Lagos State has been doing e-affidavits for a long time. Ogun State has joined the bandwagon, River State. And we have an act that says we cannot sign. I actually tried it last year. I was not in the country. I went to file a process, my personal process. I signed it electronically from the UK and I sent my office assistant to go. The assistant registrar or deputy registrar rejected the process that because I didn't sign with blue. We are in 2025, 2026. So for me, I think that provision, we need to take a second look at it. And because we are lawyers, someone will go to court and challenge all the e-affidavits we've been filing. And of course, the courts might possibly agree with them. So we might want to look at that provision. Thank you.
Thank you very much. AIG.
Yeah, thank you, Mr. Chairman. I think cyber stalking has, thrown up a lot of controversy and conversations. So if I may suggest, the cyber stalking should not be removed, but it should rather be, clearer, proper, distinction has to be given, and a clear cut at that. But what worries me most is the penchant for people to abuse freedom. Why do we need to publish something is injurious to some other person? That's morality on one side. But if the law says you should not do a thing, that's what it is. Why do you want to do it? I believe the spirit of the law was not to suppress freedoms, but rather to have a civil and a peaceful society. That's my thinking. Thank you.
Thank you. Mr. Arabu.
Okay, for me, I would say there should be Section 22 should be further modified to include freedom of expression for the press. So there should be press exemptions, because even when the press, they engage in investigative journalism, they are still picked up. And yes, we also know that we have an issue with training the enforcement personnel. And when you get them to do their work, they just go overboard. Like one of the speakers said, they are even still using the old law in certain cases. But if it's in the act, it sort of takes it out.
So they are not going to now pick up these people because it's already stated in the act. Because when you pick them up, is when after you pick them up, you now realize, okay, this person investigated, it was not done with the intention that it will cause harm and all that. So I think that should be included in the provision of the act. Thank you.
Thank you very much. Mr. Lawani.
So I agree with the other speakers. Section 24, even though by the 2024 amendment seems to have narrowed down the intendment of the lawmakers, I think a lot of work needs to be done on that. There's a lot of laxity in the, sorry, I take that back. There's a lot of broadness in the usage of language in the Cyber Crimes Act, which are the reasons why you will see that law enforcement officials are able to frame a charge under any of those sections of the law. I think it should be tighter. The first half of the law, which deals with national security, cyber crimes, fraud, and misuse of national security apparatus, I think that should be the focus of the law. Watering it down and delving into existing scope of the law dealt with in civil law, particularly section 24 and 27 and the likes of it, I think we should do those sections. If you ask me, if I sat on the bench really and somebody brought an action for me where they are seeking a striking down of section 24, I would do so.
Thank you very much. Mr. Ajo.
Yes, section 24 is the notorious section. We should also take out those provisions that criminalize or that can be interpreted or viewed as criminalizing defamation. We can also, in sections 38 to 40 of the Act, allow for more judicial oversight in amendments as they come going forward. Thank you.
Thank you very much. At this time, throw the floor open to the audience for questions. If you have a question, please let me see your hand up. Okay, let's identify 1, 2, the lady, 3. I come to this side. My Lord, Justice Iwo. So please, quickly, I am getting an indication, even though by my own time, we still have a few minutes, but I'm getting an indication that our time is up. So quickly, please, if you ask your question, if it's for any particular person in the panel, please indicate to who. If not, quickly, please.
Mr. Moderator, please, I want you to rehash back a question you threw to Mr. Ebanoi and Dr. Babalola, where you talked about jurisdiction and whether it was Nigeria specific. I hope I heard something like that.
We can. Sorry, if you have a question to any of the panelists, you can ask.
Okay, this is my question.
Yes.
I would have loved Mr. Ebanoi to a bit differentiate between rude thoughts and fighting words given American jurisdiction. What's the name of this guy? Shore. Then for Dr. Babalola, I would want.
Sorry, you can only ask one question, so you choose what you want to ask. There's no time. I'm sorry.
This one is
so that other people will be able to ask.
So
please.
This one, I so much love it. Please, I'm sorry.
Okay, so you ask. Please. It's okay.
Yeah, please. Yeah. So, to the doctor, Babalola, please, I would want you to reconcile section 24 of that Cybercrime Act as it concerns United Nations Human Rights Council Resolution 32/13 passed in July 2016, explicitly affirming that the same rights people have online must be protected offline, particularly the right to freedom of expression. It declared that digital rights apply regardless of frontiers and via any media. To you, sir, particularly. But, sir, on rudeness and fighting...
Sorry, we are just taking one. Dr. Balavola, can you please respond to his question? And then we'll move on.
Grateful, please.
Please.
Most grateful.
Even though you said you like me or something, this question is a damaging question because I have to go do research. But ordinarily, yes, digital rights are the same expression of fundamental rights online. So every right we have offline, we have the right to express them online. But the only problem is we are more focused on some few rights. A couple of years ago, we approached the Federal High Court in Lagos here to declare that the right to own digital assets, they are part of fundamental rights. Some courts actually struggled with it. But yes, you have actually answered the question. The exact right that everybody has offline, digital rights also allows you to express them online.
Thank you very much. To the next person, sorry, please. Yes, you can ask your question. Please.
Good afternoon, sir.
Yes.
My question is for the AIG.
Yes.
AIG, sir. I'm trying to understand something. You were talking about persecution of posting false news and all of that online. So my question is, how would the police prosecute a parody account? A parody account that comes on social media and criticizes the government, says a lot of things. How do you get to that person? Take, for instance, Gistlover, Cute Juice. How do you get to meet that person? We all know this person is a human being, but it's a parody account. So how do you all persecute such persons? Thank you.
It's for the AIG, sorry. The question is for you. How do you prosecute parody accounts? Anonymous accounts.
Now, before he says something about it, interestingly, we just got 2 judgments from the High Court in Lagos State, but I mean, we've not made it public because we are also trying to enforce. So there were people who also used parody accounts on Twitter but it was privacy, actually. I mean, they altered somebody's picture, they altered the timestamp and everything. We went after Twitter, we went after Xcorp, and of course, by law, by data protection, Nigerian Data Protection Act, the court can actually enforce, can compel such platforms to reveal the identity. There is nothing like anonymous, there is nothing like parody. The person has an IP address, the person has metadata, the person has some other identifiers connected to it. So, I mean, I don't expect the police to openly tell you.
Thank you very much, Dr. Babalola. You've answered the question for the AIG. Thank
Yes,
you.
sir. Thank you very much.
Last person on that side. Or do you still want to say anything in AIG?
No, actually, you know, my colleague has helped me out. It is a very technical thing. It's not something I will tell you here. It's very technical.
Very well.
Very, very technical. But
So,
if you wish to join the police, you are welcome.
Thank you. So,
thank you.
Quickly.
No, it's not.
Section 39 provides for
Who is your question for?
I'm directing to the AIG.
Okay.
Yes. Section 39 guarantees for freedom of speech. That's for the Constitution. Now, Section 24 of the Cyber Crime Act, if we look at it constructively, provides that there is no guarantee after freedom, after speaking. And hence, I will say that that section, to a large extent, is undemocratic and criminal in nature. Now, this is my question. Given that Section 24 of the Cyber Crime Act has often been accused of being used for political purposes and objective criteria, for political purposes, what objective criteria should the police apply when they receive a petition, upon receiving the petition, when they receive a petition alleging cyber-stalking or online defamation? Specifically, how should they determine whether the fact disclosed in the petition satisfies the legal requirement of Section 24 before commencing an investigation or prosecuting the accused person? Now, the purpose of this question is based on the grounds that at times they don't further prosecute. They will arrest you, detain you, even with a court order, and maybe after some weeks, after maybe the period of the court order, now release you, as though you have now suffered what? Necessarily not that the person is guilty. So how can police carry out this? Thank you.
AIG, is for you.
Mr. Chairman, thank you.
Actually, he asked the question and tried to answer it. It's a very simple thing. Whatever complaints the person makes has to be evidence-based. And personally, I've prosecuted so many people for that offense. So there is no reluctance in prosecution. You must do a thorough investigation. The safeguards are there. There are legal advice. At the end of the day, we test it before the courts. So I would rather, before you push anything online about a person, you should be sure. I've had cause to get people from various parts of this country, and I arraigned them in courts, and they were convicted.
Thank you very much.
How I do it should not be your problem. But I assure you, diligence is the key to it. For the National Assembly to sit down and enact a law, it means there are reasons for that. And Mr. President has assented to it. It means we have to enforce it. Law enforcement is not just to suppress rights, but it's also to protect victims of those online threats, harassment, and what you call cyber stalking. It is very important you conduct yourself properly, but if you infringe any aspect of the law, there are points to prove. And I will assure you, you will be convicted. Thank you very much.
Thank you very much. Please, to His Lordship.
While I sat in Ekiti, a gentleman was brought before me for one thing. His girlfriend said he was not doing again, that the relationship was off. The man refused. What did he do? He now took the picture of the lady while sleeping naked and posted it on Facebook. The police brought the matter before me. I convicted him. Two things. I fined him also, jailed and fined. But the fine was paid into the coffers of the federal government of Nigeria. And I had to say, please permit me to read my last paragraph. I said, it is unfortunate that this court has no power to compensate the victim as the law does not permit same. I think those who drafted the law should amend same to allow for compensation to be paid to any victim in cases like this.
Thank you, my Lord.
I don't think that has been done.
Thank you very much, my Lord.
Thank you, my Lord.
So please, finally, the lady, you don't, okay, then we can wrap up here. So, to my panelists, one last word each. One last word each. Brief, quick. Mr. Ajua, start with you.
Okay. This is what I said from the beginning. We have a law which is not perfect. From where we're coming from, it is progress. With legislative intervention, I believe we will have a more certain law which deals with some of the vagaries or with some of the vague provisions of the existing law that we all can be proud of. Thank you.
Whether we like it or not, the Cyber Crimes Act is extant law. It is being used to charge non-compliant or non-conforming citizens of Nigeria. This is a gathering of lawyers of the Lagos Bar Extraction. I said earlier, any post that you put out, any documentation that comes from you should be given a second look. Take your time to read the provisions of this law very clearly. It is a dragnet to shorten and silence free speech, in my opinion. I'm sure you can see how I feel about this law. However, we shouldn't be caught by it. As a legal practitioner, I'm doing the best I can, including personal actions against the implementation of this law as it is. But that is what I can do as a legal practitioner. So you shouldn't be caught by it. As to whether or not the law will be amended, of course, on this side of the divide, we are doing our very best to ensure that the offending sections of that law would no longer continue to see the light of day. But currently, it is law. Let us conform ourselves within the modest and standards of decorum.
Thank you. Mr. Arabu.
For me, it would be that the enforcement agents should be well trained. Even the best law, if you have something that is so good and you're not able to implement properly, or the courts are not able to apply it properly, it still causes hardship. There'll be breach of fundamental human rights. So enforcement agents should be well trained to know what the law says. And also the National Assembly should be up to the task of coming up with laws that will stand the test of time and involve stakeholders when they are coming up with these policies that ends up being the law. Thank you.
Thank you. AIG. Yes, final word.
Yeah, my final word is that the Nigeria Police is committed to enforcing the Cyber Crimes Act with all due respect to the Constitution and the rule of law. Thank you.
In case you didn't hear him, he said the Nigerian Police is committed to enforcing the Cyber Crimes Act.
I will invite you for training.
Yes, Dr. Babalola.
I don't know why I always have to speak after the police. But lawyers, we are the ones who draft these petitions. It has been my own crusade for a while that part of the reasons we draft, part of the reasons rich people would rather use police to prosecute is because most cannot afford to do libel. You know, if you do libel, your reputation is on trial. And there is no human who is that clean. So the alternative I have given lawyers, which we have tried and we have succeeded, of course we failed many times, is where you can't use libel, use privacy. For example, you can, because part of the elements of privacy is where somebody publishes something that is false or paints you in a false light. We've gotten judgment for few celebrities in the past, and I think lawyers should start using that. And it's a better alternative than criminalizing free speech. This is not even a country where we should be afraid to talk. We suffer a lot in Nigeria. So we can't afford to have a law that won't allow us to talk. That's mine. Thank you.
Thank you. Thank you. Mr. Banoy.
Yeah, my just last words. There should be clarity on which agency should investigate and prosecute, whether it's the DSS, SSS, or the police. Why do I say this? We understand the challenges. The DSS may not have the capacity to prosecute and all that, but we know what the EFCC is doing. They have a lot of cases. They just bring in lawyers from outside. They hire SANs, come and prosecute these cases for us if they don't have the capacity. The DSS, I believe, can do that. Now, we all should pay attention to this Okedara and Attorney General's case that is going to the Supreme Court. Why is it important? I think their lordships decided, further complicated the provisions of that section 24. If I were them, if I were in their shoes, what I would have challenged, what I would have said is, Okedara, where is your locus? Why? He challenged the clarity of the provisions that, the Constitution said, the Act said, there is no clarity and all that. How are you affected? Were you arrested? Did you suffer any loss of punishment based on the non-clarity of this provision? For the lordships to just say, they are as clear as anything. You should have, first of all, challenged his locus. So these are my shorts.
Thank you very much. So today's discussion has demonstrated that debate is not just about regulation against protected speech. So it concerns the role, how a democratic society can protect both liberty and security in an increasingly digital environment. There appears to be broad agreement that cybersecurity is necessary, but freedom of expression remains the constitutional cornerstone, and that effective safeguards, judicial oversight, and clear statutory language are essential to maintaining public confidence. The central challenge going forward is ensuring that the law punishes genuine cybercrime without criminalizing legitimate criticism, dissent, or democratic participation. On behalf of the organizers, I thank our distinguished panelists and our wonderful audience for what has been a thoughtful and engaging discussion. Thank you very much.
Thank you very much.
I guess before we close, we'll borrow from the other panel and take pictures on stage with the leaders of the bar.
No, we actually have a token for the panelists.
Mr. Etigwe and Mrs. Balogun.
We have Mama Irat Balogun to OON to assist us in presenting the token. I'm sure, okay, let's all come down, yes. I'm sure we'll all agree that it's been an interesting session and there's been a lot to take away. It doesn't end here. We'll continue to ensure that we enforce justice and we know the boundaries of our constitutional rights. Pardon me.
Special thank you from the no speech, no speech. This is from the week. Thank you very, very much for sharing this. Very much.
Please, can we play this? Yeah.
I do. This is a note of thanks from the committee. Thank you very much. Thank you very much. NBA Lagos appreciates you. Thank you. We are very delighted. The only lady there. Thank you so much. God bless you.
Okay, so
It's in me.
should we, what we have is just 5 and 15.
You, my friend. Well done. Thank you for your time.
Thank you, ma. Please, Leonard Silk, Etigwewa, Planning Committee Chair, EXCO members, please come, let's take a quick picture, please. Branch EXCO members, please.
Please, a round of applause for them while they are making their way to the stage. These are the people that made this event possible. Please, a round of applause for them as they go back to their seats. We can all agree that this panel session was indeed a hot one. Do we agree? And I think we now understand where the trending word allegedly came from, because nobody wants to be prosecuted. Please, a resounding round of applause for this wonderful, insightful panel session. Before I introduce the coordinator to invite the members of the next panel session, I'd like to take the following announcement. Please pay attention. The owner of KWL 886FL, Silver Mazda, please go outside. I've been told your indicator is on and has been on since morning. Then we also have medical personnel at downstairs, and you can go there to check your vitals. The medical personnel we have is Evercare, and they have been with us since yesterday. We also have the Experience Center where you can go if you want to send that quick email before you get back to the office. Now, to invite the next panel session and members of the next panel session, I would be calling on Ms. Bisi Olu Yewande, who is a regulatory and compliance professional. She is currently the legal officer or senior legal officer at the Federal Competition and Consumer Protection Commission, FCCPC. Please, is Ms. Yewande in the hall? So this next panel session is also going to be interesting, so I urge you to sit tight and pay attention. The topic is going to be on data protection. We're going to be discussing from compliance to crisis management, also an interesting topic. And I believe the members of this panel are already seated here. We're waiting for the coordinator to join us on stage. Okay, while the members of the panel make their way to the stage, please can we give them a round of applause? And another round of applause for the coordinator, Ms. Bisolu Yewande. Thank you.
Good afternoon, everyone. Good afternoon, distinguished guests, learned colleagues, ladies and gentlemen. Please permit me to stand on existing protocol. I want to warmly welcome you to this afternoon's session. This session is particularly an exciting session for me because it is for our in-house and government council forum. Our compare did not quite introduce us very well because we are very special people. And we're happy to have you here this afternoon. In today's digital world, data is one of the most valuable assets an organization possesses. Yet, as technology continues to evolve, so do the threats. Cyber attacks, data breaches, and ransomware incidents have made it clear that data protection is no longer just a compliance obligation. It is a governance, business continuity, and legal imperative. And this is why our topic, data protection, cyber security, and incident response from compliance to crisis management is very important. This session challenges us to move beyond compliance and explore how organizations can build resilience, respond effectively to cyber incidents, and strengthen public trust. This afternoon, we're privileged to have with us a distinguished moderator and an exceptional panel of experts whose experiences span regulation, public policy, privacy law, cyber security, corporate governance, and digital transformation. Our moderator for this session will be Mrs. Tomi Bodude, who is the Director, Community Service Unit at the Lagos State Ministry of Justice. She comes with an accomplished career in legislative drafting, law reform, and public sector governance. We're delighted to have Mrs. Bodude here with us. Thank you. You're welcome, ma'am. Joining her are our esteemed panelists. We have Mr. Alexander Onwe, who is an assistant manager at the Nigerian Data Protection Commission. He's bringing the regulator's perspective on data protection and compliance. Following is Mr. Hanoba Etomi, who is a head data privacy and digital infrastructure department at JEP Law, that's Judge Etomi and Partners Law. Mr. Dojisarumi, our next panelist, is the Chief Fixer at TechHive Advisory, an international privacy and digital governance advisor with extensive cross-border experience. Then we have Ms. Lanre Komolafe, who is an assistant director. She heads the ministry's data protection team and serves as its data protection officer. Ms. Lanre Komolafe, I'm pleased to have you, ma'am. Finally, we have Ms. Sandra Eke Okaka. She's an experienced senior consultant for cyber security and privacy at KPMG Nigeria. She has extensive experience in advising organizations on cyber security, privacy governance, and regulatory compliance. You're welcome, ma'am. Please join me in welcoming our distinguished moderator and panelists. I encourage you to listen actively and save your questions for them later. Thank you.
So, good afternoon, distinguished guests, members of the bench and the bar, distinguished panelists, and ladies and gentlemen. It's my pleasure to welcome you to this important plenary session on data protection, cybersecurity, and incident response from compliance to crisis management. We live in an era where data is often described as the new oil. But unlike oil, it can be copied, stolen, manipulated, and transferred across borders within seconds. And as we cyber threats, as organizations become more digitized, cyber threats have become more sophisticated, more frequent, and more costly. So, for many organizations, the question is actually not what if a cyber threat or incident will occur. It is when and how prepared are we or is the organization for that incident. So to guide our conversation today, we want a realistic, viewpoint. So we're going to have a scenario. And that scenario will go like a hypothetical scenario, but realistic. Let's say it's 8 a.m. Monday morning, and there has been a cyber incident. Okay, the customer database has been, compromised, and customers have started calling. The news is on all social media platforms. Journalists are calling. The board of the organization is sitting, and there's panic, more so to speak. Even the Nigerian Data Protection Commission is likely to be involved. So, my question goes to my esteemed panelists. Let me start from Mr. Onwe, the regulator. What should happen next?
Okay, thank you very much for that question. So, like you said, it is not really a matter of if, it's a matter of when. So, when data breaches occur, such as you stated in the hypothetical scenario, the first thing we expect from the Nigerian Data Protection Commission and under the NDP Act is that, we want to really see evidence of prior preparedness. How prepared were you already before even the incident occurred? That's what we'll be checking for at that moment. So we'll go into, have you been able to notify the Nigeria Data Protection Commission within the stipulated time frame, which is within 72 hours? Have you been able to implement your incident response plan immediately? Have you put it into action at that particular moment in time? And of course, when we start asking the questions, when we receive evidence of this breach, we start looking at some of the questions we'll ask you are, what is the nature of the breach? What are the categories of data subjects and the number of data subjects that were affected? What have you put in plan to mitigate, to contain the breach at that particular moment in time? So really, what we're looking for is evidence of prior preparedness, if you were prepared for this from the on-go, or, you are just acting out of panic at that particular moment in time.
Okay, thank you very much. Mr. Sarumi, your role is advisory to companies concerning organizations, this kind of thing. You heard what Mr. Alexander said. Do you agree?
Hi, good afternoon. Thank you for having me here. Yeah, I do agree. But I would say whenever such incident occurs, right, it usually is the touch point of where it starts from, right? So for example, you wake up in the morning, you say there's a breach somewhere. The question is, okay, where did it come from? Let's say it started from the customer care side, right? So the customer service or experience team then reaches out to the necessary team member or team lead involved, right, who then escalates it to the next level. So, but everything pinpoints to there being a procedure or a protocol in place to address such issues. So, what usually typically happen? I'll give you an example. A previous with the client, right? The customer care service member had to inform their team lead, who then informed his or her team lead, right? Who then took it over to the incident report team, headed by the DPO, for example. So then the DPO then communicated with other members of the team. They had a huddle quickly, had to come physically to the office, and they began to troubleshoot the matter. Before they now also brought the management into play as well. So the team itself that handled that escalated the matter was the incident response team, right? Before then, bringing every other member involved, and then finally also the board was also informed about. And I think within a few hours they were able to quell because the issues are quite enormous all around. There's the part that involves the regulator, of course, which I think in the NDP is a 72-hour window, right? But there's also the part of the technical part as well, because you need to stop the bleeding as well, right? And discover what's happening, document everything, and ensure that you are following the right protocols that you put within your team, right? And that's where you see your incident response policy being tested, if you actually have one in place. Because generally speaking, you find out that a policy is only as good as how it is used, and a policy is only a paper until it actually is tested, right? So I do agree with him, but usually it would be the touch point of where the incident came from and what you follow through before you then get to then contact the regulator about it as well.
Okay, thank you. I think I'll move over to Mr. Itomi. From your viewpoint, legal practitioners, what do you have to bring to this?
Thank you very much for having me here. I agree with what is said. So the only difference that I'll point out is it really depends on the type of breach. So yes, the regulation states that you report a breach after 72 hours, but there are actually some breaches that can be handled internally. So it's important to speak to your data protection officer or your outsourced DPO to recognize what type of breach, the level and the severity of the breach, and then you then decide what next step to take. So you don't actually want to stress the regulators if you don't have to.
I appreciate. Ms. Eke Okaka, you work with KPMG. Can you also work in this space advisory? Can you bring your expertise to view concerning this issue? What happened? What should happen? You've heard the views of your...
All right, thank you very much, and good day, everyone. I'm sure you've been having an insightful time, as I have. So this scenario is very interesting for me, particularly because it's actually something that happens in real life. You have lots of organizations that actually, have this as a crisis presently within their, organization, particularly when they have this category of breaches. But what should be the first thing that the organization should do? Or what would you, as the consultant, advise such an organization? The first thing I would say is don't panic, because most times people make the poorest decisions under pressure or when they're anxious or, just having anxiety feelings or the likes. And it could impact on the general business of the company in general, because how you manage or handle or respond to a data breach incident will determine how quickly you are able to recover. It's also determine how the company or the organization on its own is able to rebuild trust back. Right? So the first thing they should do, or the first thing they should be looking at is, first of all, the crisis management team should come together. And of course, that team should already be in existence before the happening of that incident. It shouldn't be something that should just be formed, impromptu, because that would also affect how they are able to respond to the incident in question. So the crisis management team comes together, and of course, they get the relevant stakeholders as part of, their meetings. For example, during crisis simulation exercises, for example, you have the ones we organize for the strategic management, or let me say the strategic team, and another one you exercise for the tactical team. That's those that deal with the data itself, the technical teams itself, right? So in this scenario, the crisis management team wants to be sure that you have the right stakeholders within the organization and the right teams involved. These two teams, the strategic team, which comprises of the C-level executive management of the organization, and also now the C-level and top guys within the organization needs to be part of that, decision-making process, and also the tactical team too. That's those in charge of the infrastructure and the processes generally. They also need to be part of that meeting, if possible, whether they can join in virtually, even if they are not in the country. That meeting has to happen. And then a decision needs to be taken during that meeting, because you have to ask some certain questions. Do we even have enough information about this breach? What kind of data has been exfiltrated? So do we need to conduct an assessment to determine the particular data elements that were actually involved in the breach? Do we need to get external stakeholders involved, external consultants involved to help us carry out some certain level of assessment? Then again, within that team as well is also the communications team. They deal with the affairs with the media, managing communications with external stakeholders and the likes. And also you also have the team responsible for managing communications with the regulatory body as well, because of course there's a regulatory requirement to also report certain kinds of breaches if it poses a risk, to the rights and freedoms of data subject. So I would say, it just has to, that first meeting has to happen, and then the crisis management plan or the incident response plan will be invoked, and then the company follows through with that plan and then helps, of course, fix the issue at hand in question. I'll just, hold my thoughts here and allow my other panelists.
Thank you very much. It's over to Mrs. Komolafe now. You're a data officer, you are public, as in organization, Ministry of Justice. What perspective would you bring to bear on this scenario?
Okay, thank you very much, and good afternoon, everyone. So I'll be addressing that issue from the perspective of a data protection officer. So when an incident like that occurs, from my end as a public servant, we have a structure in place whereby there is a steering committee, there is a technical committee on data protection. However, we need to first ascertain that the risk is very high before such escalation as required by the Nigerian Data Protection Act. So depending on the level, like Mr. Onwe said, of the exposure, the data subjects that are involved, and all those intricacies, that it's not in all cases that you have to escalate to the regulatory body. If there are situations that can be internally managed, it may not be necessary to go by the 72 hours requirement of the Act. However, in situations where the breach is on a large scale, yes, the law requires that we escalate within 72 hours, and the data subjects would also be contacted to tell them the implication and then even advise them on steps to take to mitigate the effect of that breach. So those will be the immediate response that we will take in that situation. Thank you.
Thank you very much. So I will go over to Mr. Sarumi now. Organizations are increasingly investing in compliance programs and digital transformation. So from your experience, where are organizations still getting it wrong?
Hi, yeah, thank you for that. So yeah, in the recent years, you find organizations invest a lot in technological measures and tools within organizations. But some areas where I think they're still getting it wrong will be understanding the difference between compliance and governance.
Compliance and?
Governance.
Governance.
Right, yeah. So a lot of times compliance is put as a checkbox exercise, right? I have these policies, I have these documentations, I've complied with the law. I'll give you a typical example, right? A lot of organizations, right, in Nigeria, once they conduct the statutory audits, right, put the caption of the trust mark on their websites, and the posts were fully complied with the Nigerian Data Protection Regulation, which is not the case. The audit's trust mark signifies compliance with just that area of the regulation. There's still a lot of things to comply with as well, right? So, and a lot of organizations, when they reach out, it's, how to do NDPR, how to build audits, that's all they care about most of the time, right? They're not very proactive in understanding that compliance is beyond just that itself, right? Which then comes into the issue of governance. Now, what is governance itself? So governance is understanding that the real issue here, right, is operationalizing privacy, security, right, as a culture within your organization from top to bottom. It's understanding that the board must be involved. The understanding that, for example, when you're doing any high-risk processing, right, you need to involve security and privacy teams. It's not just about conducting a DPIA, right? It's not just about having a nice document sent to the regulator that yes, DPIA. Understanding that all the teams necessarily must be carried out across, must carry along cross-functional within an organization, and it's not a checkbox exercise. So a lot of organizations get the right policies, they have the breach register, they have a lot of access control policies, but they don't use them. And you find this out when a breach or incident occurs, right? When you do an audit, a post-incident audit, you find out that a lot of organizations have this policy, right? But they don't actually have the right system in place, which is the governance itself. And that cascades from the top to the bottom. Understanding that policies are good. Beyond policies, you need to have controls. And beyond controls, you need to have assurance reviews, which is done from the board itself. So it cascades from the top to the bottom, ensuring that from every board member to the lowest member of the organization, they have to understand why privacy, security, and incident readiness should be a culture within an organization itself. That particular area is missing in a lot of organizations in Nigeria, in South Africa, in Kenya. Everywhere we've been practicing so far, you find out that that is quite missing. A lot of people think that compliance is just having policy and ensuring, and but the policy is only as good as the actual of the people.
Yes, I see. Thank you very much for that. Mr. Itomi, many organizations still see data protection as a compliance exercise. That's speaking precisely to what he has just said now. So how can leaders move beyond that mindset and embed, privacy into the organizational culture?
Thank you. So, firstly, I strongly agree with what was said. There needs to be a focus on a privacy-centric model within an organization. So, compliance is not a tick box. It's actually an ongoing exercise. So, I work with a lot of tech companies, so companies that operate in the crypto space, digital payments, whatever space, and these are they have some of the smartest minds, but then they have this mentality of, oh, we'll cover the compliance aspect when we get there, we're just focused on building. So my advice to companies, founders, those who are building, especially in the tech space, is build alongside your privacy policies. So essentially, whilst you're building, ensure that data privacy is embedded in what you're building. So I'll give 2 reasons why. The first reason is regulation always moves slower. So as a founder, as someone who builds, as an engineer, it's important, or it's a responsibility to ensure that you're ethical about what you're creating, and as such, you're thinking about the best privacy-centric tools. So it's essentially known as privacy by design and privacy by default. So privacy is just automatically talked about at every single stage, from the design stage, the planning stage, down to the operations. And my second point is, whilst you're building early, it helps you avoid certain penalties that might come along the way. So the regulation says that within your first 9 months or so, you don't need to perform an audit. But for example, if you set up and you performed your audit, then when the time comes around, you're not looking at, oh, what have we left behind? You're actually focused on, this is what we built so far, and these are the remaining gaps that we need to fill. It's a lot easier that way than a client comes to you, they've been operating for 3 years, and they're like, we need a DPO, we want to perform an audit, we need to submit that audit next week. There just isn't enough time. Like, a DPO cannot do magic. They essentially need to review all your policies from scratch, all your end user agreements, your agreements with your different third parties. So it's important to be privacy centric. So that's the key word for me, privacy centric.
Thank you very much. Please, let's clap for these panelists. They are giving us key points. Thank you very much. Mrs. Komolafe, let me ask, at what point does a cybersecurity incident move from being a regulatory issue to becoming a criminal matter? You're from the DPP, right?
Okay, thank you very much. In responding to that question, I would refer to the provisions of the Nigerian Data Protection Act. Now, sections 47, 48, 49, 50, and even 51 provides respectively for compliance orders that the Commission can make. Section 48 speaks to the enforcement orders that the Commission can make to enforce those for non-compliance and any of those breaches. Then Section 48 creates an offense. It criminalizes non-compliance. And Section 49, Section 49 criminalizes the offense. And Section 50 now talks about judicial review, that where the decision of the Commission is unsatisfactory to a person, they can, apply to the court for a review. Now, Section 51 provides that anybody who has suffered an injury or a loss or by the omission or act of another person can seek remedy through a civil proceeding. So the whole essence of this is that the law does not envisage a criminal prosecution of breaches, of data breaches. However, at the point where elements of crime or elements of an offense that is known to law is found in the acts or omission of a particular person, organization, data processor, or data controller, then the prosecution will swing into action and go for the kill. So offenses, for instance, like deep faking, like cyberbullying, under the Criminal Act and the Cyber Crimes Prohibition and Prevention Act would be taken up, and prosecution can take its course at that point in time. Thank you.
Thank you very much. I think I want to ask a follow-up question. Would you view this as an omission that needs to be rectified, like a lacuna, a gap, or it's fine?
Well, what would have constituted a lacuna is if there is no prosecution at all. The law already identifies, and I know for a fact that I think Section 50 speaks to, is the only offense that I find in that act, and that is not about breach. It is about when someone refuses, despite all the orders and decisions of the Commission, to still comply, then the person can be charged to court, and that particular section also states the punishment, and it can even be imprisonment or both. So it is not that there is there is a lacuna, so to speak, because the offenses can be charged under the Cyber Crime Act, like I said earlier, and the Criminal Act. And I think that is the standard generally. So regulatory sanctions and remedial fees, fines, and all that are the administrative measures that have been, implemented to act as sanctions in that regard. Thank you very much.
Thank you very much. Please, can we encourage our panelists? It's not easy. Sitting up here. Okay, so I want to move to the beyond compliance, one of the things, building a culture of cyber resilience. So, let me start from where many organizations believe that they are strongest, compliance. Many proudly, publicly display privacy policies and NDPA compliance certificates, but they continue to experience serious cyber incidents. So, and in fact, I can say that from the discussions we've had here, we can say that compliance has become a box-ticking exercise from your experience. So, let me go to Ms. Okaka. From a cybersecurity perspective, what distinguishes organizations that recover quickly? Oh, did I? Yeah. that recover quickly from those that struggle for months after an attack?
All right, thank you very much. Quite interesting. When I want to talk about recovery, I want to dimension it in two ways, because there is recovery of infrastructure. That's, are you able to recover back, your data and certain other things that has been, affected? And also recovery of your trust, which is actually very, very important, and maybe even the most important, because it is possible for you to recover infrastructure and you are not able to recover back your business. You've lost your partnerships with your partners, you've lost your credibility before the public, you've lost your customers, but you are able to recover the infrastructure, right? So looking at it from these two angles, I would like to now dimension the responsibilities of the two key stakeholders within the company that I feel should be responsible for, recovery. Generally, the board and the top level management should be the primary, persons involved or responsible for recovering back the brand reputation and the business generally. And rather than just focusing on, just leaving it as, or treating it as an IT incident alone and not really concerning themselves with it, but also making sure that they are also involved, because there are certain factors that also play out when, data breach incidents or cybersecurity incidents actually happen. When it comes to recovery of infrastructure, which is usually core functions or the core responsibilities of the tactical team or the technical team within an organization, you want to be sure that even prior to that incident happened, you actually had the right infrastructures in place. You are prepared for something like that. You've carried out simulation exercises before. The board has been stress tested, with all these scenarios playing out. And then you've been able to implement your policies, your incident management plan, to actually see how effective they are and how they are able to help you overcome such an incident when it happens, right? So I'd like to give this scenario, for example, just to bring it home a little bit. I'll give two victims of a robbery incident. The first victim, for example, maybe prepared before the incident. Let's say the victims are victims of robbery of their mobile phones, right? Before I purchase my mobile phone, certain choices inform my decision. One, maybe the ability for this phone to be able to back up my data. Two, maybe the ability for the phone I want to get to be able to help me to track the device when it gets lost or stolen. All those things guide or inform my decision in purchasing a particular tool, right? And then the second victim of a robbery, maybe just a carefree person that just is fine using any device as long as it can make and receive phone calls, right? So when they suffer that robbery incident, who would recover quickly, right? In most cases, it will be that person that paid more attention to what things they need, what technological device that they were purchasing that had those features to help them to recover back their data when such occurrence can happen. Because it's not a question of, is this data incident going to happen to me? Or maybe because maybe our systems were not so secure. That's the reason why this incident happened to my company. Even for the most secure organizations, they still experience breaches. But how well they are able to manage the entire breach incident during that process, it goes through several layers of steps that they ought to have taken. For the infrastructure point of view, do the company have the right infrastructure to help recover back their systems, the data, when it gets lost or when it gets stolen, right? Is the tactical team trained enough to implement these policies? Are they trained enough to also know the right controls that needs to have been put in place prior to that incident happening? And then the other hand, which is the most important part, is the part of the recovery of the business, the brand reputation. And I'll give an example, a real life scenario. There's a particular case study, not necessarily a cyber incident, but a crisis incident. I'm sure many of you may have heard about Johnson & Johnson, sometime. That was a case of a pharmaceutical company suffering a major crisis. One of their capsules or one of their medications was laced with poison, right? And that didn't even happen from their manufacturing process alone, but of course they are the company, they will bear responsibility. So when people took those medications, they had a lot of deaths happening from that incident. And in that kind of a situation, you'll be wondering, oh, is this company going to ever regain back the trust of people? Who would want to still patronize such a company in that kind of instance? But guess what? In less than a year or two, that company was able to rebuild back trust within the market because of the steps taken by the C-level executives in managing such a situation, what they had done and how they had tried to build back their trust. They recalled millions of their drugs which were out there in the market already. They took necessary steps informing stakeholders that were involved, of all the affected parties, about every step that they were taking towards managing such incidents. And then they were even the champions of even this tamper-proof medications and material now that helps patients or helps people not access easily access a medication, access a drug without going through some level of destruction of that particular material, right, used to wrap that particular drug. But in essence, what I'm trying to just say is that recovery has to do with the top level management paying more attention to taking all these things I've said into consideration so that they are able to recover back the business beyond even just recovering the infrastructure alone. And this is what will differentiate a company that has taken steps from a company that did not take any steps prior to the occurrence of that incident in question. Thank you.
Thank you. In fact, thank you so much. I think she does deserve a round of applause for that. I'm going to come ask this question. It's off what she's saying. From the regulator's point of view, Mr. Ram, do you think you have adequate provision for ensuring that the kind of training that is required from organizations for building resilience, is it provided for? Do you have such powers to ensure that at least they give such trainings?
Okay. Well, one of the requirements in the guide for organizations, especially to...
Sorry, you didn't get the question. I'm sorry, pardon me. I was asking him if, based from what has been expressed now, does he feel that there are adequate provisions in the Act for the required training that will enable this kind of resilience, recovery of infrastructure, maybe not recovery of trust, but at least recovery of infrastructure?
Oh, of course, there is, to some degree, but it largely depends on the organization also. The law has made its requirements. It's now left for the organizations to implement these requirements. And one of the requirements under the guide, a guide is that's GAID, refers to General Application and Implementation Directive, which is a document issued under the Nigerian Data Protection Act. And under the guide, you are required to train your staffs continually on data protection and privacy. They are supposed to have adequate knowledge of it on a regular basis. And if you're able to implement this, if you have a data privacy culture in your organization, and you have a privacy policy that works, not just the one that is just aspirational in your organization, yes, it is possible to quickly recover your infrastructure when incidents like this.
Thank you very much for that. Just a follow-up question to that. How do you enforce that? Are you able to?
Yes, we do enforce that. Okay. On our own, we can decide to probe into your activities as an organization if we feel you are not compliant. But also, when incidences like this happen, when there's a data breach and all, when it gets to us, it's part of the thing that we are going to check. We have what we call pre-action conference at the Nigerian Data Protection Commission. And this pre-action conference is where we investigate organizations who are, are going through data breach at a particular moment. So one of the things we are going to ask you is the evidence of training of your staffs on data protection and privacy. Is one of the things that we look out for. And if that is not in place, we'll take it that you don't take data protection and privacy seriously in your organization.
I believe it deserves a round of applause. That at least gives us some confidence that we are adequately, our regulators are at least doing something that is in tandem with what needs to be done concerning building resilience in our organizations. So this is a cross-panel question. You know, can an organization truly describe itself as compliant if it has never tested its incident response plan? So I'd like each of you to speak to that just briefly. Yes, no? If yes, why? If no, why? We start from the lady. I'm not partial, but...
Okay, very briefly. You said, your question is that should an organization classify themselves as compliant if they've been able to test?
They've never.
If they've never tested
their incident response plan.
Okay, I know from my co-panelists discussions during today's session, they had mentioned something very important, that most companies see privacy compliance as a tick-the-box approach. They want to just do it, comply with regulatory requirements to, okay, do you have this policy? Yes, I have a privacy policy. Do you have this thing, right? And, you know, as long as they satisfy that requirement, they feel like they've actually complied with the law, particularly as it pertains to that particular, you know, regulatory requirement. But it should go beyond that, really, because the spirit behind that provision is actually to test the effectiveness of controls within an organization beyond just the existence of those controls, right? So the idea behind a regulatory provision or directive saying, okay, get certain technical and organizational measures in place is because they're trying to mitigate a particular risk. And you just leaving it alone at documentation without going forward to test it, right, creates a loophole or creates a serious risk within your organization, which, you know, can result into several breach incidents happening to your company subsequently, right? So for complying with the regulatory requirements, yes, rarely will you see any law or regulatory directive detailing different steps on how, you know, to go about complying with that particular provision. They will just tell you, oh, comply with this, have these measures in place. They'll give you some examples, but they may not go that granular into telling you to go ahead and test. I think there's even a provision in the NDPA now that even talks about, you know, companies or requiring companies to go ahead to make some kind of test of their, you know, security infrastructure in that regard. But for me, it even goes beyond the testing, because that you've done a test does not mean that you are even secure. What was the result of the test, right? What were the elements that were factored in when you conducted the test? So all this learning should help the organization to, you know, to improve its cyber or data maturity levels generally, when it's not focusing on only just complying with, oh, I have this policy.
Your viewpoints.
Thank you. It's only when your procedures have been put to test that you can say, oh, we have gone through the process, we have put it to test, we have found that we need to improve on certain areas, like Mr. Onwe said. So it's not just about documentary compliance and your operationally deficits. But when you have tested the procedure, you can bring out the loopholes, areas where improvements need to be made, and then, you know, capitalize on those to prepare for an actual attack in case anyone comes. So I think that it is important that a test is carried out, the procedure is put under such pressure, and be actually prepared for any upcoming attack. Thank you.
Thank you. Mr. Otomi?
So I think there's this saying that goes, as a privacy lawyer, you want to be a pessimist as opposed to be an optimist. So the reason why is you want to assume the worst case scenario in every case, right? And the reason why is because you're talking about people's data. So another thing, for anyone who works in AI or you've done any sort of regulation, there's this term that they use a lot in AI development called red teaming. So red teaming, R-E-D teaming. And it's essentially when you get an ethical hacker, yes, they're ethical hackers, and you get them to run a hack through your system or through whatever you've created. And this is meant to bring up potential flaws within the system. And as we discussed earlier, the regulation moves slower than the creativity of the AI or the development of AI, right, as a whole. So if in the AI practice, it's common practice to, have a red teaming exercise, then it shows that this is something that's important, which is kind of an answer to your last question, which is whether or not, founders or directors should be involved in things like this. So yeah, so red teaming, so this shows that you should do a test, you should run some scenarios to ensure that, your system is adequate. And then the last point that I was going to make is responsibility. So if you're drafting, so again, looking at it from a legal side, if you're drafting an agreement between a developer and a third party, so someone that does something on behalf of the company, if that third party then loses information or there's a breach from the third party side, who's responsible for that breach? So again, it's important to run that test so that as it is documented in that agreement, that is what comes to pass. So because it's documented that in a case where I give information to you and that information is leaked from your end, you are the one responsible. But if we haven't tested our agreements, if we haven't reviewed these policies we have in place, when something like that does happen, all of a sudden you could find yourself taking on the liability for something that really isn't your fault just because the product comes from your company. So yeah, to answer your question, it's very important to do a test.
Thank you very much, Mr. Atu. Mr. Sarumi, over to you now. What's
Hi.
your take on this?
Yeah. Has anyone seen The Office, the US show called The Office? Has anyone watched it? The
What?
Office.
The Office.
Yeah, so whenever we're doing tabletop exercises for clients, for example, scenario that we always play is a video play. So now in that particular video, the setting guy, the guy with the glasses, yeah, he decides to light a fire in the office. So apparently the week before, he's been advising them about fire drills, responsibility. They had a plan in place. Then he decides he books all the doors, he puts the windows, and he sets a fire. And he sits down, and everybody goes bonkers. Everyone is jumping everywhere, and it's like, what do we do next? What do we do? What do we do? And everyone is breaking ceilings, breaking windows, destroying everything. And it's like, sorry, let me just read this. Sorry. Hello?
You know what? Let me get this one.
Hello? Yeah. So after 5 minutes, he decides to say it's all a test, and they want to kill him. But you see, that video, we play it for almost every client when we do tabletop exercises, and it emphasizes one thing, right? You're only as ready as the plan that you have. You're only as ready as you are when the thing actually occurs. So, and the point is, they had a plan in place. He had taken them through various drills. In previous episodes of that show, they were sleeping during those exercises, right? Some of them will pass it on to the next person to get it done. Now, why do I say this here? It applies here as well. We found out that a lot of times, clients sometimes delegate even simulation exercises to their juniors, right? Board members don't have time, the CEO does not have the time, head of the department doesn't have the time, head of practice doesn't have the time to actually do these things. So they have a good document in place, incident response, crisis response document, but they don't actually know what to do when the time comes, right? And the question he kept on asking was, what does the document say? What's the next step? What do we do? And they were all just breaking everything everywhere because they never actually understood the plan, right? So you see, having the right document in place is good, right? But you're only as good as how you react when the time comes, right? I've been in different panic rooms when these things occur, and it's really crazy. So you see, there's something called the Kubler-Ross 5 stages of grief, right? And we apply to cybersecurity. Kubler-Ross 5 stages of grief. So whenever a cyber incident occurs, 5 things really occur, right? There's first of all, anger, right? Someone's angry. Who caused this? It's you. It's me. It's you. Then there's denial. No, it can't happen. It's not me. It's not me, right? Then there's betrayal. Like, oh my God, what's happening here, right? Then there's depression, right? Then you're like, oh my God, I was going to go down. Finally, acceptance. This happens even in grave regular. If you lose someone, for example, something's wrong, right? And it happens in cyber incidents also, wherein you go through these 5 stages, right? Till you finally accept that, okay, you know what do we do next? And it all comes down to the final point. They're not ready. They may have documentation, they may have the compliance checkboxes, but they're not ready. And compliance only works when you are ready. You have to be ready. We have a saying in my organization, ready to go, ready to go. And it basically points that, are we ready to go? If something occurs now, what do we do now? When we do team and red team exercises, like he said, right, they're usually very brutal. We do it across different organizations, across different countries. We don't tell them we're about to do it. And when we do it, it's very brutal. And you find out that a lot of teams are not ready, right? And you have to be ready. You have to be ready at every time because you are just one click away from an incident or a breach. So that's why having documentation is not the key. What needs to be key is that you need to be ready. And readiness comes from so many things, including awareness, having the right policies in place, controls, and also the right assurance in place as well. Thank you.
Thank you very much. I believe he deserves a very, very big round of applause. They all do. Thank you very, very much. I'm looking at our time is fast spent. So I think I'll just move on to 1 minute parting shot. What would you like to say each before I move on to questions from our esteemed audience? So, because you spoke last, let me start with you.
1 minute.
Yes, a parting shot. Yes, on anything concerning this issue. What's the most important thing? What would you like to say?
Okay, yeah. So I think what I would say is this. So I'll tell you why I say this. Cyber incidences has taught me that privacy is not a legal matter particularly. I keep on repeating it, right? I found out that a lot of organizations, particularly in Nigeria, you see, in Nigeria and Africa, our privacy landscape is very nascent. It's growing. It's still quite young, right? But we look towards the West for a lot of things. And we don't really copy the right things where we should copy some things. And I'll tell you why. The average data protection officer you find in, say, an Australian or European organization may not be a lawyer, could be an engineer, could be a privacy technologist, right? Folks that have spent time in privacy operations deep into it, they actually understand how it works. So they're able to work cross-functionally across different departments. Over here, we have a tendency to delegate it to legal particularly and leave you there. Now, the reason why that doesn't work a lot of times is that a lot of times we focus on just the law itself, the letters, not how it resuscitates in real life, how it appears in real life. Yeah, and there's a gap in between. And you see, this gap in between reality and the law is where risk sits. And that's where a lot of organizations have issues. The risk we find a lot of times sits in between what the law is and the reality on ground. And it's now more apparent now that AI has become a really big thing. So as long as we continue to prioritize privacy, particularly as a legal function, which it shouldn't be, it should be cross-functional, and we should encourage lawyers to think beyond just the legal side of things when it comes to privacy and cybersecurity incidences. So my mind, what I would like to see is a group of legal professionals that are more embracing of privacy as a broad concept beyond just the legal side of things.
Thank you very much for that. That's interesting. It should be all inclusive, not just legal. It should meet reality because there's a gap between the law and the practice, how it affects everybody. So over to you, Mr.
I actually had a different point, but that point was so good that I'm just going to stress on that again for 10 seconds, that privacy is different from like legal practice. So when even law firms that offer privacy as a practice or data protection as a practice, you need to differentiate and make this clear to clients as well. So a lot of clients try to like get you to put everything under one bill, and it's like, is it not all legal? So you're almost doing yourself a disservice if you just accept that, and you'd be doing the rest of us in the privacy space a disservice as well, so that we can all, charge adequately as well. So, so now onto my main point. For those who work with, tech founders, engineers and whatnot, what I'd say is that, again, back to the point of privacy-centric, building a privacy model along with building your product saves you money, saves you time, and saves you a lot of trouble. So that's one thing that you'd say. A lot of clients believe that they're spending more money than they otherwise would be spending on data privacy and getting a data protection officer. But actually, if you do it right and you get your policies in place on time, you actually save yourself money by avoiding expensive fines, especially if you're operating across different borders.
Thank you. Thank you very much, Mr. Tommy. Please permit me to be partial. I'm from Lagos State, she's from Lagos State. And we all know that Lagos State is the commercial nerve center of the country. It's the center of excellence. So, Mrs. Komolafe, what is Lagos State doing concerning this very, 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 very important issue? Can you brief us?
Yes. Well, I would say that Lagos State is doing a lot. And I will start by referring to as far back as 2020, we started with the executive committee setting up. I mentioned earlier that there is a steering committee on data protection in Lagos State, and their mandate is to see to the affairs of anything data protection, to ensure the implementation of the then NDPR, the regulation, the 2019 regulation that metamorphosed to the Act in 2023. So, and beyond that, Lagos State has gone ahead to, circularize policies. We have operational in the system data protection policies like clear desk policies. We have privacy policies. You will see if you go to any MDAs of Lagos State, most MDAs, except those that are yet to be inducted, have privacy notices at their receptions and entrances. And you would also notice that for Lagos commuters, we have signages with regards to CCTV cameras where they are installed all over Lagos. So those are part of the policies that Lagos State is putting in place to ensure that data protection is entrenched and properly implemented. We have about 140 DPOs that have been, inducted, trained and retrained, and to ensure that data protection policies and doctrines generally are embedded in the system and implemented by all MDAs of Lagos State. So we also have the technical committee for data protection in Lagos State that carry out these operational activities on behalf of the steering committee because of the busy nature of the people who comprises of that committee. So Lagos State is doing a lot. We partner with the NDPC on a lot of fronts to ensure that trainings are done, conferences, a lot of things are being done. For want of time, I would want to stop here.
Thank you very much. I don't expect any less, quite frankly. So if I should move over to Mr. Onwe, please, your parting shots.
Okay.
Concerning
Thank you
this.
very much. I'd like to say that privacy begins with you and I. Privacy begins with you and I. And if there's one thing we've constantly seen in the Nigerian space is that people don't take the issue of privacy seriously. Both individuals and even organizations, if I were to ask some of us in this room now about some certain things, practices that you do that expose you online, you see that almost all of us here are at fault. So at the organizational level, it's almost the same thing. They don't always take it serious. So, and for us at the Commission, we always recommend that privacy should be a board level discussion. It should be something that should always be discussed at the board level, because we can't achieve the digital economy we are looking for in Nigeria without privacy, because privacy is one of the cornerstones of a sustainable digital economy. So I just want to advise each and every one of us, take the issue of privacy seriously, compliance seriously, and not just compliance on paper, but operationalize it in your organizations. That's what we need to build. Thank you very much.
Thank you very much. Our time is up, but we will still take Miss Okeke.
Okay.
Okaka, pardon me.
No problem. Thank you very much. Interesting conversation so far. one thing I would just like to just leave with the audience is this, right? Particularly because we are speaking to lawyers, right, and learned colleagues who have at different points have had to advise clients on data privacy issues. One thing I will say is don't be too quick to tell a company or a client that they are compliant just because they have the privacy documentation alone, right? Even though that's, for most clients who always try to be evasive, really, of actually doing what they need to do to demonstrate compliance, they want it to just be, oh, we have ticked this box, we have this document, we comply, please, leave us alone on this privacy topic. Don't be so quick to just advise clients that, this ends here. Let them know that compliance is a journey, particularly achieving maximum, the maximum or 100% compliance is a journey that is not achieved in just one day. And they have to know that they have to build themselves enough to get to the level whereby they want to get to, meaning that they have to go beyond having these policy documents alone to actually implementing them, putting together the right governance structures in place to help ensure that these policies are effectively implemented within the organization, and also ensuring that different mechanisms are in place that can help them demonstrate compliance, because this is one key thing with accountability, which is one of the core principles of data protection, generally. So for you to say you're accountable as a controller or as an organization, you should be able to demonstrate compliance beyond just having just the documents alone. What other steps have you taken to actually make sure that, you have done everything that you need to do in that instance to ensure that, whatever risks that can come out of that particular operation is being mitigated effectively. Thank you very much.
Thank you very much. Thank you very much. I have been given the letter. Okay. Can we ask for questions? Because our time is up, maybe limit it to just 2 or 3. Okay. That gentleman, that lady. That's it. Thank you.
Good day, ladies and gentlemen.
Good afternoon.
Okay, my name is Femi Alonge. Permit me to stand on the existing protocol. So my question borders on your advice regarding the marginal line between risk and compliance when it comes to startups and early startups. So startups are just, targeting pre-pilot phase, just looking to complete their MVPs. So they are not really big on budget and also have a very strict timeline. So what's your advice on that regarding how they can ensure compliance with the NDPC while not breaking their budget and also, meeting their timeline? Thank you.
Thank you. So who wants to take that question? Would you like, Mr. Etomi? Startups, you understand? Knowing their limited budgets and all that, how do we ensure that they are still compliant?
So thanks for that question. It kind of takes me to my last point, which was, I think if you build side by side or you try and do the compliance aspect whilst you're building, it's actually cheaper for you. So when, for example, like in my firm, we work with a lot of startups, and not every startup is going to have the funds of an organization that has been operating for 15 years or 20 years. So we take this into consideration and we let you know, okay, this is how you can still comply. So for example, if you get a privacy lawyer or officer, right, and they say, okay, usually a company like yours would require 3 days a week of attention where we come to your office and whatever, but then to help your budgets and whatnot, we'll try and do this in 1 day per week. So those are the type of things. So it's important for you to explain your situation, meet someone who properly understands and can help you navigate. So that's my advice.
Thank you. Or get his contact. The next question, please. Yes, ma'am.
Good afternoon. My question is to Mr. Sarami. So I want to ask, where an MVP of a product is out and there's a breach during the beta testing of that MVP, will you say that the founder or the builder of that product will be held liable for data non-compliance?
So your question is when an MVP, a company's product, yes, is currently being beta tested, and there's a breach, yes. So I'm assuming it's a serious kind of breach, for example, right? So my answer will always first of all be it depends, right? But I'm assuming the organization also probably has not carried out all the necessary technical and organizational measures that the regulations are put in place. So I'll say yes, because they are the controllers of the data, right? So they will be liable. The company will be liable. Now, bringing it down to the founder, maybe not itself, right? But the company will be liable, right, for whatever breach occurs, especially if the breach is telling in itself. So I'll give you an example. You do know that in some instances, right, CCing certain people in the mails could be a breach as well. But, you know, we treat those things minorly. Privacy is very nimble, right? CCing certain, for example, if I CC him and I CC you, when I shall be CC'd you, when you don't know each other, for example, in some places it is also a breach in itself, right? It's lighter a breach, but it's still a breach regardless. So the organization in question, right, has tested a particular product. Yes, you've tested the product and it's led to a breach. So you'll be liable for it. The company will be liable for it. Sorry? It's an MVP, yeah, but it's your product regardless. Especially if, for example, there's the breach. You're saying a breach, meaning there's actual live data in it. So the question now becomes, is there actually the data, the personal data in it? I'm assuming there is from your scenario. If it's test data, right, that's a different thing. Then you now know there's an issue. But once there's data involved, yes, because it follows the data, right? If there's personal data involved in this particular thing, so you tried actual live data of certain individuals or citizens of a country or a particular place, yes, there will be liability involved for the company before it then maybe cascades to the directors. But usually to get to the directors, there's a long process for that. But the company will definitely be liable because the company is actually the controller of that particular data set itself. But a lot of times you find out that during MVPs, a lot of folks use test data first of all to test it and to ensure that they do a lot of pen testing and to ensure that it's actually sound before it goes live itself. But once it goes live with actual data, yes, there would actually be liability and consequences, which the company will be responsible for as the controller of that particular data set as well. Thank you.
Thank you. You could also meet up with him later on if you want more explanation concerning that. And the final question. Yes, ma'am.
Good afternoon. Yes, my name is Oluwatobiloba. I know that as lawyers, primarily client confidentiality protects your client's data basically, but I am not a data protection officer. I don't work with organizations that are prone to these risks. So at the base level, for lack of a better term, how does this concern me as a person? What are areas that we should focus on? Basically, thank you.
Thank you. Who would like to answer that?
Okay.
Okay.
I can answer that. Okay, so your major question is to just know what you should know about basically from an individual point of view. Okay, let me just say from a data subject point of view, which is typically you and I, who can be identified with our personal, information. What should you do? There are steps you can take as a person when it comes to protecting your own information, and there are also steps you can also take in respect to also managing information of other persons within your custody, right? So even though you may feel like, oh, I'm not a company, I'm not a large organization, I may not be, I may not process a lot of personal data. On your own, there are certain responsibilities that, that you are supposed to actually, take personal ownership of. Things like ensuring that, that you have certain, basic security measures in place to protect your information. Like I gave an example previously of how when even purchasing a device, the kind of device you decide to go for in terms of holding, what kind of device can hold your information securely, what kind of device has the ability to help you recover your information in case it gets stolen, and all these certain measures that you as a data subject can actually take on your own without having to even engage any professional. And these days, even in the age of AI, if you even want to know some basic things about how to protect your information or how to stay safe online, you can even just ask these questions to some of all these AI generative technologies that are in play, of course, without imputing any personal information into them, just to get some basic understanding about even what are your expectations, how can you even be safe. And another thing also is, another important thing also you should focus on also is also when it comes to accepting cookies. That's like, a serious issue right now. And one thing you should pay more attention to as a person when you're managing your preferences is to go through the options or the preferences. You want to select the right ones that you know that you want whatever company to have. You want to select a cookie, an optional cookie that you know that you want the company that is about to process your information should have about you. For example, you want a company can ask you to consent to processing your data for profiling purposes and the likes, or to learn about your activities across different applications. These are things that are within your own control, steps that you can take personally. But before you can take those steps, you have to be informed about even the risks. Go through the privacy policies of these organizations to be sure that these are companies that you can actually feel safe sharing your information with before you even consent to some of all these optional cookies settings on your mobile devices. So these are some basic steps that an individual can take to safeguard their own personal information, even beyond even going a step further to talk about how you can safeguard the information about other people that you come in contact with, or maybe that comes into your custody by virtue of whatever relationship you have with them. Yeah, thank you.
Thank you. With that, we have come to the end of this panel session. I would like to appreciate the organizers of this program. Thank you for picking such a very important and timely subject. I want to say thank you to my panelists. You are wonderful. Thank you for your experiences and what you've brought on board discussing this topic. And thank you to our esteemed guests. Thank you for listening. Thank you for participating. I would like to end by saying that from what we've discussed, it's apparent that privacy issues need to be paramount in our consciousness. It goes beyond organizations, it moves to individuals. It starts from individuals, actually, because individuals make up organizations. It's individuals that work in organizations. And if you are privacy-oriented as an individual, I'm sure it will reflect in the workspace. So compliance will not be an issue. We can be severely impacted by privacy issues. If you have a phone, you are on social media accounts, you've applied for something online, I mean, you can be impacted, especially organizations too. So we've learned that we need to move beyond compliance checklists to making sure that privacy is institutionalized. It becomes an organizational culture. And I'm very glad to have been given the opportunity to be here. Thank you very much. We appreciate you so much.
Please, one more round of applause for the in-house and government council forum packaging and putting this together. Thank you all so much. You may please rise for your picture taking and to present the plaques and tokens to our distinguished panelists. May we please have life bencher Lady Debbie Obodoku. Please, a round of applause for her. Thank you so much, Ma, for honoring us with your presence. will please love you to present tokens of appreciation to our distinguished panelists. Please, a round of applause for her. Thank you so much, ma. After Bukito.
In appreciation of what you have done, on behalf of Nigeria. Hello, can you hear me? On behalf of Lagos, Nigerian Bar Association Lagos branch, I hereby present this award to Mrs. Komolafe Latifa, Assistant Director, Director of Public Prosecution, Lagos State Ministry of Justice. In recognition of your invaluable contribution as a distinguished panelist at the MBA Lagos Branch 2026 Law Week, we appreciate you. Thank you so very much. Okay. On behalf of Nigerian Bar Association Lagos Branch, we hereby present this award in appreciation of all you've done for them and the excellent way that you answered our questions with smiles on your face. Thank you very much. I need to take you on a walk. On behalf of Nigerian Bar Association, Lagos Branch, I do hereby present this award to Ayodeji Sarumi, CIPM, for whatever degree that you have put there, in recognition of your invaluable contribution as a distinguished panelist at the MBA Lagos Branch 2026 Law Week. In appreciation of this, thank you so very much. We appreciate you for all that you've done. Okay, on behalf of Nigerian Bar Association, I hereby present this award in appreciation of your invaluable contribution as a distinguished panelist at the MBA Lagos Branch Law Week 2026. Thank you very much. That's a private discussion. On behalf of Nigerian Bar Association, Lagos Week 2026, I hereby present this award to Hanover Etomi in recognition of your invaluable contribution as a distinguished panelist at the MBA Lagos Branch 2026 Law Week. Thank you very much.
Can we have the chairman of the branch and members of the Law Week Planning Committee on stage for a quick photo op with the panelists? All right, a round of applause one last time for our 6 panelists. Please make that better. Do that better, do that better. Encourage them as they get back to their seats. All right. That was our 6th and penultimate panel. Who is ready for one more? Are you all ready for one more? Are you ready for one more? Okay, but before we have our last, our final, and the most exciting panel session for the day, please put your hands together for former chairman of the MBA Lagos branch, Mr. Yemi Akongbe, Senior Advocate of Nigeria, as he comes for his goodwill message. A round of applause for him.
No. Respected life benchers, Lady Debbie, respected seniors, my elder sister, Mrs. Etomi, members of my Lord, the Honorable Justice Taiwo retired, members of the Lagos branch. It is with profound delight that I felicitate with the chair of the branch, Mrs. Uchenna Akingbade, an executive committee member of the branch. As a former chairman of the branch, I appreciate the continued, the sustained culture of excellence and professional leadership that distinguishes the Lagos branch from other branches of the Nigerian Bar Association. I also would like to register my commendation for the chair of the planning committee, Mrs. Obosa Akpata, and a wonderful team. The theme of this conference is not only timely but compelling, as technology redefines and reshapes the practice of law. This theme reminds us of the need to brace up, and be able to lead confidently in this unprecedented technological era that we're in. So I hope that the deliberations have inspired fresh ideas. I hope that the deliberations have waking us up, has kept us awake, and we are all alive to the responsibilities and the things we need to do as a lawyer to be able to compete favorably in the world of today. So once again, I thank you all for being part of this engagement, and I look forward to seeing everyone on Thursday at the Town Hall at the Muson Center. Please make it a date. Thank you so much.
Please make that better for the Leonard Silk. All right. I like to call him the dandy Leonard Silk because he's always looking so dashing and so great. And I noticed it was only the ladies that were clapping for him. Men in the house, what's up? All right, Leonard Silk, you are loved. Now, just a quick announcement. We'll be having our raffle draw. So, can we have the hall silent? Want to have our raffle draw? If the hall is not silent enough, we will not proceed with the raffle draw. I'm sure you all know some persons won laptops yesterday. Okay, we will proceed. But before we have further announcements, I would just like to give notices of the remaining events we'll be having during the course of this week. Tomorrow, we'll be having specialized master classes, trademark, tax, AI. I'm sure you would have got. How many of you have gotten your emails? Have you gotten emails? Your emails? Okay, I'm sure they will be out by this evening or this night, hopefully. So you know the venues for your various master classes. Tomorrow, we would also be having the Elders Night, sponsored by George Itomi and Partners. A round of applause for the sponsors of our Elders Night, George Itomi and Partners. On Thursday, we'll be having the town hall meeting for all candidates. So come one, come all at the Muson Center. You get to hear from all your favorite candidates that have graced this particular stage or that you support. And then Friday, someone say Friday. Friday. What's happening on Friday? What's happening on Friday? Mrs. Obosa Akata. What is happening on Friday? Friday is the grand closing party. Make some noise. Okay, on Friday we are going to be having the grand closing party. Are you all tired? Are you tired? Are you tired? You still want one more? One more session? Okay, yes. All right, now this particular session is an exciting session, and because it talks about, young lawyers in particular. Young lawyers, are you in the building? All right, now every election cycle, we get to hear young lawyers deserve to be paid better. Oh, there's a new remuneration order. But what has been done? What steps have been taken? What challenges are young lawyers facing? And how can our remuneration be done better? Now, the title of this session is Beyond Paying Dues. Beyond Paying Dues. Fair remuneration and sustainable growth for young lawyers. And doing the honors to introduce our panelists, we have on this panel Emeritus Branch Chair, a partner at one of my most favorite law firms, and the chairman of YLF. But doing the honors of introducing this panelist on stage is my brother, my friend from way back, Esosa Gabriel Irabo. Please put your hands together for him. Make that better for Gabriel. We've come a long way.
Good day, distinguished guests, live benchers here present, my learned senior colleagues, my colleagues, ladies and gentlemen. My name is Esusa Irabo and I'm the coordinator for this session. It is my singular pleasure to welcome you all to a highly anticipated panel session titled Beyond Paying Dues, Fair Remuneration and Sustainable Growth for Young Lawyers. The legal profession has long been built on the notion that young lawyers must pay their dues through hard work, sacrifice, patience, before attaining professional fulfillment and financial stability. While dedication, discipline, and perseverance remain essential virtues, an important question confronts us today. At what point does paying your dues become exploitation? As the profession evolves, there's a growing need to re-examine the realities before young lawyers, especially with the rising intervention of digitalization and its accompanying costs. Issues such as inadequate remuneration, poor work-life balance, limited mentorship opportunities, and the increasing cost of professional development continue to impact the well-being and retention of young practitioners. Today's discussion seeks to move beyond merely acknowledging these challenges because we all know it. It aims to explore practical pathways towards creating a legal profession where young professionals do not only survive, but they thrive professionally, financially, and personally. Sustainable growth in this profession requires deliberate investment in young talent, fair compensation structures, supportive work environment, and a shared commitment to preserving the dignity of this noble profession. To guide us through this very important conversation today, we are privileged to have with us an esteemed panel of professionals. First, we are honored to have and to welcome Mr. Adeleke Alex Adedipe. Please, a round of applause for him. He is an accomplished legal practitioner and thought leader, the managing partner of Duale, Ovia and Alex Adedipe, DOA Law. If you know them, you know they are not just good with the law, but they are solid footballers, as they won the last football league. Joining on this panel is Mrs. Tolulogbe Adebayo. She's a partner and head of corporate commercial and ADRO practice group at Foundation Chambers. Please, a round of applause for her. We are equally delighted to have Ms. Olivia Okoyocha, the legal officer at Chemical and Allied Products subsidiary of USC, and if I may add, she's my best friend. Please, a round of applause for Olivia. Last and in no measure the least, we have Mr. Gideon Idem, an astute associate at Aluko and Oyebode, and the current chairman of the Young Lawyers Forum Lagos branch. Please, a round of applause for my chairman. Moderating and directing today's discussion is no other but the very renowned Mr. Olabisi Makonjola, partner at Olaniwu Ajayi LP, and the immediate past chairman of the MBA Lagos branch. A louder round of applause for him. Thank you for warmly welcoming our guests. I have no doubt that this session will challenge existing assumptions, inspire meaningful reflection, and provide practical insight on how we can collectively build a profession that balances patience with fairness and tradition with sustainability. Mr. Olabisi, over to you. Thank you very much.
Hello. 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 Yes. Good evening, everyone, and thank you for waiting for this session. Out of respect for our young leaders, please to sit. Can I please ask that everyone standing, please find a place to sit, or you exit the hall if you're not interested in this session, please. There are still some of us milling at the back of the room. We say that the young lawyers are dear to us, so let's put that into action. Can we please find a place to sit? This is the session for the young lawyers, and it should be a very, very interesting and interactive session. So we have a full house, and for me, that is very personal, because I am one person that believes a lot in the young lawyers, as it should be. And so whether you're a managing partner or whether you're an associate, this conversation is for you. This evening, we're not here to complain. We're here to be honest. We're here to have deep conversations to move things forward. And I'm not doing that alone. I'm doing that with 4 extraordinary people from 4 diverse backgrounds. I have Otumba, I have Gideon, Olivia, and Tolulope, representing different backgrounds. But before I turn to the panelists, I'd like, by show of hands, right? How many of us have at some point felt that we're not getting what we desire in this profession, and you've thought of either leaving law or jackpotting from Nigeria? By show of hands, how many? Did I see the hand of my Lord Justice Taiwo? So that is the situation we find ourselves, where your take home can hardly take you home. And for me, that's where we begin the conversation. I'll begin with the chairman of the YLF, and I believe that you represent the demography of the young lawyers in this room. When you hear fair remuneration, what does that mean to the young lawyer? Gideon.
Thank you very much for that, and I appreciate the leadership of the branch for this opportunity to be here. On the issue of fair remuneration, I think it goes beyond high salaries. I know when we have discussions about remuneration, the first concern is how much am I earning? But I think for the purpose of this conversation, we should look beyond the salaries. We should look at the dignity of living, the fact that your employers give you that dignity and respect as a person, they value your time, and even beyond the pay, they give you as much as you deserve. So the fact that you put in the work and you see the level of, let's say, resources coming into the firm as well, you should be able to feel appreciated based on the value of the work you had put in. A lot of people in the room, a lot of young lawyers put in long hours just so that the work would get done in a way that would leave very little time for review. And at the end of the day, when the money's coming, sometimes they don't feel like they're being carried along as much. So for the conversation about failure, I know that this legal profession thrives on precedents, but unfortunately, low pay, low salary has been one of the precedents that we've had in the profession. So I believe that in this conversation, we'll be able to challenge those norms and move beyond salary and focus too on justifying dignity of persons and also the value of the work that we do. Thank you.
Okay, so I'll come back to you on dignity of persons and I'll quickly jump to Olivia. You have been on both sides as a young lawyer, first at a private law firm and now you are in-house. When you were starting your career, what did fair pay mean to you? Was it just a number in comparison or a feeling? What was fair play to you? I know now you're head of legal, but at that time, what was fair play to you?
Okay, so at the start of my career, I would say that fair pay was more than just a number. I mean, it was a number in addition to a couple of other things. Financial security and also considering the consideration of my value. I needed to be in a place where I would feel like my value was being recognized and also where I was being given an opportunity to grow. And I know that at the beginning of your career, it's very important to be a bit realistic about your expectations about, when it comes to fair pay. We shouldn't expect to earn as much as someone that is 10, 15, 20 years in the profession. However, there are some figures that you should be able to recognize would be, for lack of a better word, insulting, and some figures that you would recognize as fair. So I would say at the start of my career, fair pay was a combination of the numbers and the feeling.
Okay, thank you very much. Now, talking about being realistic, and I'll jump to Otumba. Big fish, may I? Okay, so, I mean, from where you sit as managing partner of DOA, arguably one of Nigeria's leading law firms. By the way, you didn't win the last Lawyers League, so I'm just correcting the MC. So, but when a young associate walks into your office and says that he's not being paid fairly, what goes through your mind? And would you like to share the internal benchmark for fairness that you've adopted this while at DOA?
All right. Thank you very much, everyone. All right. For those who don't know me, my name is not Otumba. My name is Adeleke Alex Adedipe. And like everyone else, I work at a law firm somewhere here in Lekki called Duale, Ovia, and Alex Adedipe. And I'm extremely happy to be here speaking to both young lawyers and senior lawyers who decide the pay for the young lawyers. I mean, I'll start with... I could rightly say that the concept of fairness in itself could be somewhat of a myth, right? Because it depends on who is talking about fairness. And that comes from the perspective of multiple things, right? So one of the things that I would look at would be who is asking for fairness and why is the person asking for fairness. But before we even get to that point, one of the things that we do as a firm is that we try to create a benchmark. I would not say fairness, but a benchmark, whereby, for example, at the beginning of the year, and at least once or twice within the year bracket, we'll conduct surveys, right, across different brackets of law firms, top tier, mid tier, and even low tier firms, just to understand what the market is paying. Unfortunately, data is some of the things we struggle with in Nigeria. In some other jurisdictions and climes, these are things that you find readily available. What is this law firm paying? What is that law firm paying? But then we have to do some kind of trade wars here, whereby you give some information to some law firm and they will give you some information. I mean, I hope what I get is true, but I have to work with it, right? So you use that to create some kind of benchmark and you see where you want your team to sit at. once you've done that, you also need to ensure that, I think there's also a misconception about remuneration and compensation, right? I think that, and my brother here has mentioned something about, fairness, where you work, the dignity at work, right? But I think that today, if you are not careful, every time your salary is increased, sorry, I hope there's nobody from NRS here. Every time your salary is increased, right, the taxman takes a huge portion of it. So you are getting an increase, the taxman is getting an increase, right? I'm not saying that we should not pay taxes, but I also think that we don't want to erode what the purpose of that increase or that remuneration or compensation is. So there are multiple ways you can compensate your staff for hard work and for the things that they do, right? And we've adopted many measures, whether it is healthcare, whether it is gym membership, whether it is feeding, different ways, whether it is overseas travel, just multiple ways that we can pay directly to a vendor and they get compensated for those things. But I always would remember when I was on the other side, right? And I think that it's always good for one never to forget where you're coming from, right? So I remember when I was there, even though I didn't ask for fair compensation many times, I guess I was somewhat duly compensated. But I think that everyone deserves to demand or ask for what they want. And if those things are genuinely fair and you feel that you've contributed well enough towards the bottom line, then you can have conversations with your superiors. And I guess for it to tell at that point whether you deserve to continue to work there or take a leave. Thank you.
Okay, thank you, Otumba. And again, I'll come back to you. And this is for you, Tolu. You wear two hats at Foundation Law Firm. You are senior counsel and you're also business manager, which means that you are responsible for bringing in work. Now, I understand that those two hats don't always agree. As business manager, what does fair look like to you versus what it looks like to lawyers in your law firm? Do you want to share?
Thank you very much, Mr. Makonjola. Good afternoon, everyone. And thank you, NBA, for the opportunity that put me on this table. I'm going to be a bit practical. What fair remuneration means to a young lawyer. I've been a much younger lawyer. I started my practice in Ibadan. When I finished law school, I went for NYSC. And I practiced in a law firm that paid me 5,000 naira as my take home.
$5,000?
5,000 in naira.
Oh.
That was as an NYSC graduate. I remember that, just like every other lawyer, I had just done 6 good years of hard work in school. I was coming out to to join the workforce, earn my money because I believe that I had been trained as a lawyer and I know what I'm doing. However, so many times I hear about the precedents, like somebody else had mentioned. The precedent is that our seniors came into practice and they had to learn the hard way. They had to go through pupillage, and for that you should even be grateful as a young lawyer, even if they are paying you peanuts. And so at that time, it was easier for me because I'm not a Gen Z, I'm a millennial, and everybody will know that millennials carry a lot on their shoulders. We have been trained to bear a lot of burden. We have been trained to just enter into the system and align with the system. At that time, it was almost okay. Nobody was complaining. But now we have a new generation of lawyers who are not millennials, who understand that they had gone to school and they want to earn. Whether they are going through pupillage or you are teaching them anything, these are people who are going to transport themselves from wherever they are coming from. These are people who pay rent. These are people who see people who are in banks that probably did 4-year courses and are driving cars already after 3 years. And so I'm a young lawyer. I have to go through pupillage. I understand that that's how a young lawyer thinks. I want to earn money. I want to be able to take care of myself. And I want you to know that I am an adult who is feeling the impact of the high cost of living. So, as a young lawyer, I want a remuneration that will not look like an insult to me. That was what I understood then. But 7 years later, I came to understand another side that every young lawyer probably did not see. I became a senior counsel, I became a partner, I became a business manager. And then so many things became clear to me. My boss or the firm probably rents that building and needs to pay rent every year. Salary is not the only thing that takes cost from you as an entrepreneur or as a law firm. Salary is just one head of cost. The cost of running a business is a lot. I'm telling you, a law firm, in fact, people who are now young lawyers, I believe some young lawyers, 3-4 years, enter into their own practice, are doing their own things. And from the moment you start that, you realize that it's not as rosy as we think. So seniors, yes, they pay dues and they go up, and then they start earning money. But then there's so many things that go into running a law firm. It's heavy cost of operation, cost of salary, the tax and pension. And so many lawyers measure, young lawyers now, they measure income in terms of the net that comes to your hand, your take home. Meanwhile, there are a lot of tax issues, pension issues, healthcare issues. All of these don't directly come to you, and then they don't consider it as part of their remuneration. These are things that will put me on, as a partner and as a lawyer who understand that a young lawyer wants more money. I'm rooting for you, but then I'm also torn apart. So when he said those two hats, a business manager and a lawyer, those two hats sometimes we're not on the same side, we're not aligning. But there are ways which, at least for my own firm, we have been able to manage it, which I believe we'll come back to.
Okay, thank you very much for sharing that. And I like when you said that as NYSC associate, you were earning 5,000 naira. I mean, in 2006, when I was in NYSC, I was earning 25,000 naira. My mates were in banks. Those banks are folded up today, but that's another conversation. We can't talk about the remuneration of young lawyers without talking about the remuneration order. And this is for you, Gideon. There's a school of thought that the remuneration order, however well-intentioned, it only sets aspirational minimums that are simply detached from the economic reality on the ground. They also say that in a market where young lawyers are competing for jobs and where firms are managing cost pressures and where clients are pushing back on fees, it is the forces of demand and supply that determine fees. In terms of the young lawyer's expectation, what is your view on the remuneration order?
Okay, thank you very much. I think that it's important, that's a very important piece of legislation. It's important that we have that order, but I think that it still leaves more to be desired, especially with the implementation. A lot of young lawyers, like we know, the realities are different. And for a profession like ours that values excellence, it is very important that the people who deliver this excellence should be, given a lot of, they should be given what they are due. About the implementation or the remuneration order, as much as it is an important piece of legislation which provides the minimum standards, we believe that there should be more, especially with the way we call out even law firms who do not follow through the process. I know that I've had these conversations even with the chairman of the branch who has asked, what are the expectations of young lawyers there? And for some reason, I know that some young lawyers in the room, as much as they might not really place a value as per this is how much I should be paid, but sometimes they compare it with what other firms are doing. For instance, a friend could call me from Banwani Godalo, what are we doing? And all that. And if they hear that, oh, your bonuses came in and this was what, or the range of the bonus, immediately I'm disgruntled. Immediately somebody else is disgruntled and the rest of it. So you get to see that we do not really value our remuneration based on what we think we deserve, but really what we think others are earning or what others are getting. So I believe that we should, beyond setting a minimum standard, we should have a process where the firms that are doing well, the entities that are doing well, they get recommendation or they get, we can have a process where we speak about, these are the firms that are following the order and they're doing well and we give them the applause. Young lawyers would go and we say, this is a good place to work. But the firms that are not doing well, we don't get to spotlight them or to highlight them. And it does not end with these firms sponsoring events like this, because the firms can sponsor events like this, get the good name and all the reputation that it involves, but the people working in these firms might not have what is required or what they need. So it's important that we call out and praise the people who do well, and also call out the people who are not doing well. That is the expectations of young lawyers in the room, and I hope I'm speaking your minds. Thank you.
Okay, thank you, Young Lawyers Chairman. And before I ask Olivia for her view, let me jump to Otumba. I refuse to not call you Otumba. DOA is known for acting, and I'd like you to be very honest with us. Does the remuneration order actually drive what you charge your clients and in turn pay your associates? Or is it the market forces that do that work for you?
I mean, I would like to be very truthful, and I would say that it's pure market forces. I don't think it's really got anything to do with remuneration order, right? And I'll be again, I need to tell you the truth that I don't think I've read much about what it is, because the reality is that legal services is like any other business. It's a function of demand and supply, right? So I think that the order is good to create a base, but I think that what you still find in the market is people will price according to their immediate wants or their immediate needs, and I mean, imagine you can't be bigger than the sovereign, so you can't be bigger than the country. What is the size of the country? What is the size of the economy of Nigeria as a whole? What is the GDP of Nigeria? And when you look at the number of lawyers against not against the number of people, but against the amount of wealth that is available, then you see that we still have a long journey to go, which is why productivity is extremely important, right? I think that for the young lawyers, if we look at what the remuneration order says, I would have priced way higher than what it says. I'm not in doubt about that, because I'm competing against the best that I see in the society, and I'm trying to get the best hands. So if I'm trying to get the best hands, then I have to focus on getting the right set of people. And again, I mean, the world is really changing. There's too much extreme, and we have to be very realistic with ourselves. There's so much dynamism in the world today. Like, what really do you consider the best hands in the world today? If I'm to hazard an answer or ask anybody to answer, they'll tell me the smartest person, the first-class graduates from law school, right? Isn't that the best hand? That is the best hand. But the problem is artificial intelligence has democratized everything. Your best hand is not in the next couple of months or years, will not be the guy with first class. My first class tomorrow or in the next couple of years is actually going to be technology. That's who can give me the work faster, right? So even for us, as we're discussing things about remuneration order, we also must continue to educate the young lawyers on skills that are very important, skills that are yet to be captured by technology, that keep them extremely relevant in the society. Those are the things that will matter in a couple of years or in the couple of months, depending on the speed at which things are happening. So do we seek the best hands by market forces? Yes, it's market forces. But I also don't want to say that making young lawyers get excited and go home and believe that if I get the first class, then I'm going to be the best person that they would choose in an interview. Maybe not. Maybe not in a few years. Maybe it will get to the point where your personal skills, I will not be asking you about law questions anymore, because something else can do that law work for me 1 million times faster than you can do it. There is no lie about that, right? So I need somebody who can manage my clients. I need somebody who can respond to emails early. I need somebody who I can live with a client while I go and do something else. Now, those interpersonal skills, those things that come between those those pillars, are the things that you will need very soon, right? So don't leave here believing that you need to be extremely smart. Yes, you should be okay, you should be brilliant, but I think that even your ability to use technology very soon will be what is needed of you, right? I guess I'll just pause there. Thank you.
Thank you very much, Otumba. And I echo the points you make. And for the young lawyers in the room, I think it's not enough to think that your first class will open the door for you. I tell you personally that I've sat in interviews where persons with 2-1 or even sometimes pass were preferred to the first class graduates. But that's not for this debate, for some other time. I'll come to you, Olivia. Well, you were a young lawyer in the market not too long ago, before you blew up, as they say on the streets. Did you even know about the remuneration order? And if you did, has it in any way protected or guided you, or is it just a number? Bearing in mind your current role as legal director in one of the topmost pharmaceuticals in Nigeria today.
So I would say that I knew of the remuneration order, and I think many young lawyers knew of the remuneration order, but in the context of a lawyer-client relationship. So since we were not the ones doing the direct billing, we're not able to fully appreciate the order. So that being said, I think, and as Gideon said, it's a bit more theoretical, and the order would only be as effective as the willingness of employers to actually enforce it and for young lawyers to insist on it. But I still think that the remuneration order is important because it has sparked conversations about minimum standards. However, I think the conversation should go further, not just benchmarking and using the remuneration order as is, but we can try to go beyond the minimum standards set in the order.
Okay, so let me be a bit personal. I'll still stay with you, Olivia. Your story is quite instructive. You moved from private practice to an in-house company. Now, this path is, I believe, is the path many young lawyers feel or desire to take. Now, when you were choosing between opportunities, particularly at the start of your career, what were you weighing? Was it salary? Was it the work? Was it the culture? Was it the name on the... And what will you tell the young lawyer in this audience who right now is trying to make a similar decision? What's your advice to such young lawyer?
Okay, so when I was trying to make this decision, or the decision to move in-house, it was not just about the salary. It was also about my goals, primarily, actually, my goals and aspirations, what I wanted from the profession. And then, to be honest, the salary was also part of it because you need financial security to take care of yourself and fulfill obligations. So I thought of the salary, the culture of the organization I was going to get into, the kind of people that I would work with, the kind of work that I would be trusted with, and again, my goals. And I would say that to any young lawyer who would be thinking of transitioning in-house, we would have to be honest with ourselves and understand that salary and prestige would not be the only currency that we would accept. Salary is important, and I will say that again because we need financial security. But we should also consider and ask ourselves other questions like, what are your goals? What kind of lawyer do you want to be 5 years from now or 5 years before making your decision? Who are the kind of people that you'll be working with? The organization you're thinking of getting into, what is their culture? And yeah, you can make your decision from there.
Okay. Now, Osumba, once an associate at Alupani. Hello. Now, what attracted you to Alupani back then? And do you think that the same factors that would have drawn a young lawyer to a firm 15 years ago still hold out today?
Yes, I believe so 100%. I think that I think a lot of those things have not changed, even though the world is changing, right? I think I can tell my story in less than 2 minutes. I was also NYSC in Standard Chartered Bank. I worked there for a bit, and I thought that...
You want to share how much you earned there?
Sorry?
You want to share how much you earned as NYSC?
The only good thing is that my own NYSC salary was 5,000 naira more than yours. So I was earning 30,000 naira in Standard Chartered. But of course, I knew I wanted to be a practicing lawyer, and I thought that that life wasn't... let me put it this way. I thought it wasn't stressful enough for me. I like to put myself under a lot of pressure. You would close at 4:30, and I didn't think that it was ideal for a young man in his 20s to close at 4:30. What would you do when you're 40 and then you have too much idle time in your hands? So I wanted to practice law, and I thought I could move into the actual practice of law. So I'd moved into Paul Osoro & Co., where I'd worked. I'd worked for slightly over a year. But I think that I also wanted to taste another side of practice. I had a good time there, but I wanted to work in Alukwane Bode, and I'm glad I did. I think of most of the lessons that I would say would be that I was able to learn the business of law in itself, right? So with the business of law is what a lot of people don't see. People see law as a practice. People don't see the business of law. The business of law is that I need to have a budget at the beginning of the year, and I need to ensure that I'm spending according to my budget, and I need to have I have a balance sheet like every other business. I have a profit and loss account like every other business. I'm spending accordingly. I don't take money and just dip my hand into it and spend it. That's not how it works. If you want to run a proper business and you want to build a legacy of a business, right? And I think that if people see those type of traits in a law firm, it will endear them. They would want to go there. They want to work in those organizations. It would shock you to know that at the end of every year in DOA, for example, when we have our annual retreats, which we haven't missed in 10 years since we've been in existence, right? We would have on a screen the entire income of the law firm, every penny that we made during that year. Associates can see it. They know what it is. They will see the line item that shows staff salaries, and they will see that that's gulping 40-50% of the entire revenue. So I don't need to lie to you. You already know that whilst you are writing those fee notes, the chunk of it is going into paying you back, and in paying myself and paying everybody else, right? Then you start to see other line items. So there's kind of mutual trust between us, right? And I think that we don't build. You have to build a law firm where. Okay, sorry. Permit me to tell this short story where I saw something where it was saying that there are two types of people in a vehicle speeding at 80 miles per hour. The driver that is driving the car that is going at 80 miles per hour he actually feels safer to himself because he knows when he's going to slam on the brakes, he knows when he's going to press the gas, he knows when he's going to swerve his steering, he knows exactly what he's going to do. He's in control. But you see, the person on the passenger side, half the time, is afraid, right? Because the person is not in control with you. So the concept of that for me really is the concept of carrying people along. So you must always feel that let the person by your side understand what you're doing. And that's exactly the culture that I've been through. And I'm happy that I worked in an international bank as well. That culture has been a part of me since I've been working. And it wasn't a fluke that we decided to incorporate that same culture in DOA. And I believe that that's enough in itself would endear people to want to work with you, to come to work in your organization, and even when they leave, they're not leaving bitterly. They continue to come back for your events, and they're just a part of you. So those things will not change, regardless of what it is. Thank you.
Okay, I mean, it's nice to hear the DOA perspective. So let me go to Tolu. From your position at Foundation Law Firm, what are the patterns you see in why people join your law firm, and more importantly, when they leave, why do they leave?
Okay, thank you very much. For my law firm, our core is maritime. We do more of shipping and admiralty practice. For some reason, I believe people think that there's a lot of money buried in blue waters, and some secret law firms are mining it. So I will say
that's the truth.
I will neither confirm nor.
No, but that's the truth. Admit it. We know.
So people tend to come to law firms for, I think first thing is maybe your area of expertise. A lot of people don't know what maritime is about. And then when they see that you are into maritime and people continue to work with you, they read a little about maritime and everybody tells them, oh, there's money in shipping. And then they apply. So the money, I would say, that's the first thing. And then maybe the expertise. The second thing about my law firm is I make bold to say that we're a very peaceful law firm. There is no toxicity in my firm. My associates are around, they can confirm. So the second thing is when your law firm is not toxic and you can have rest of mind, there is no senior who is looking at your first draft and is screaming down your throat and telling you you are mad, tearing it into pieces, banging the table. These things happen in law firms. You look at your phone, you see your senior counsel calling your partner, and you are even scared to pick it. Your heart is palpitating. There is a lot of toxicity around, and young lawyers are suffering it. But then when the news of your law firm goes out there, there is no toxicity, it's peaceful, you are corrected properly. My senior partner is also here. He's one of the finest I have seen. There is nothing you can do that will aggravate Mr. Chidi Logo, Senior Advocate of Nigeria. It's calm.
By the way, Chairman, please send a note to the law firm.
A client, sometimes a client comes around and tells you this your lawyer is not doing well, or clients have a way of just having some issues with you. And then you see his reaction. I always wonder how he does it. So second thing is when your law firm is not toxic, people come around. And lastly, I think maybe this is personally for me. When you work in a mid-level law firm where you are seen, where you can go to court and actually argue your motion by yourself, you are not just carrying the files and following a senior, when you have opportunity to do trials, when people actually encourage you, where you are mentored, and you are allowed to actually take the reins yourself. People come in because that way you learn. That's the legacy you're actually getting out. Your salary might not be able to take you there, but when you have a law firm that exposes you to the real work and mentors you, I think people will come. Then second, the second side of your question is why do people leave? People leave for the opposite of all of these reasons that I have mentioned. When your law firm is toxic, I cannot stay with you. I have had to, hear stories of young lawyers who work under not just pressure. It was more like they were terrified out of the law firm. So many people go through things that they cannot even begin to say. And you have senior lawyers who maybe they have their own personal issues that they bring from home. They just bring it straight from home, bring it to the firm, and transfer the aggression directly to you. And then you don't even know whether you are doing well or you are not doing well, whether it is you or not. It's just somehow the atmosphere is toxic. And then you have a lot of people, maybe this happens more in larger law firms, where you have a lot of people scrambling for briefs, trying to satisfy one partner and get in front, All of these things are things that will make a young lawyer, feel discouraged. You want to do your job, you want to do it clean and get your money and be recognized, your value and your worth is recognized. But when there is a lot of toxicity, sometimes the senior partners don't even know. There are so many mid-level people who also make the work toxic, who also think that they have graduated into maybe managing counsel, and then they have 2 or 3 young lawyers working under them, and they begin to terrorize the lawyers, and they begin to pass the bulk of the work that they are supposed to do.
So hold it there, because that's where I'm going to next. What nobody wants to talk about: mental health, burnout, and the like. And let me start from mental health stigmatized in Nigeria circles. How do you create a space where lawyers can actually say, I'm not okay? And when a lawyer says, I'm not okay, whether young or old lawyer, what do they do?
Thank you. I'm just going to proceed from where I stopped. So let me give a practical example. I have a young lawyer that I work with. She's very good. She does her work diligently. Apart from these excesses that come with mental health everywhere, somebody is tired, his mental health, not those issues. I'm talking about really people are going through things. This is someone who dots her I's and crosses her T's, and when she does the work for me, you know that you're just going to make minimal corrections. And so one day I was going through the drafts that she had prepared for me, and from the very heading, I started seeing not even sentence error, like, spellings and things that were very unlike her. And I looked at it, the second line, the third line, and it continued like that. I stopped and I had to call her because it was very unlike her. And then she told me, I insisted because she was like, oh, I'm fine. But I knew that this was very unlike her. So from that alone, I was able to see that there was something wrong with her. So I would say that if you're a line manager or you are a team lead and you're waiting for maybe your associate to come and tell you that I'm not okay, you have already waited too long. You should be able to know when you work with someone if that person is not okay. You should be able to sense that this associate that works under me, this is unlike her, this is unlike him. So sometimes you need to maybe decongest our workload or his workload and take some things off. There are some things that can be delayed. When you are giving timeline of 4 hours, 5 hours, some can be extended, some can be transferred to other people. So yes, I think that a team lead should create a relationship where your lawyer, where your associate should be able to walk into your office and, in fact, without walking into your office, you should be able to tell. There is mental health issue. People are going through stuff. Female young lawyers are going through stuff. I remember when I had, I don't know if my time is up, when I had I was a first-time mom, and I went through a lot. I had to put my baby in creche at 6 a.m. I had to go down 3rd Maynard Bridge, and I had to be at work by 8. At that time, we were not working from home. There was no hybrid. You had to be in the office every single day. And sometimes you even have trial in court. I am looking at my baby who is running temperature at night, and I'm looking at my case file. I have trial the next day. And then I walk into the office, somebody is screaming down my throat. Tell me how I will not have mental health issues. These are real issues that a lot of lawyers go through, but I'm not going to go into my boss's office every time because I don't want to be stigmatized as that person who asks for permission all the time. So some of these things are not going to be said, but as a team lead, as a partner, as a senior lawyer, you should be able to know when something is going on with your associate.
Okay, so I understand that we have 2 interventions from select young lawyers in the room. I have Nimi and Solomon. Yeah.
Okay. Good afternoon, everyone, once again. So I'm not wearing the hat of a compare now. I'm wearing the hat of an interventionist, if that's the correct word. So the topic, beyond paying dues, fair remuneration, and sustainable growth for young lawyers. I think there are 2 sides of the same coin. So we're talking fair remuneration. How much should a young lawyer actually earn? And I love what Tolu, yes, I love what Tolu said about working somewhere. I'm not going to call the name of that city because I also worked there before I moved to Lagos. And I'll wear my suit in the morning, go for an interview, and when I reach there, they'll say, can we pay you with this kind of suit you're wearing? I'll say, sir, that was because I was just called to the bar 2 years ago. Yes, that was 2024. And they'll say, can we pay you? I'll say, just tell me anything. Tell me, I'll say, we'll pay you 40K. I say, 40K? Is it for a week? Or is it for a week? Or no, if they were being generous, maybe for a week. They say 40K. And when I calculated transport cost then was about 70K, and you are paying me 40K. And you tell me, oh, you will learn, you will work. And I tried that one time. I tried to work at one place, and the only work I was doing was going to buy akara and kuli, pun intended. But yes, I was going to buy food, I was going to buy. So when I say two sides of the same coin, if I had gotten maybe mentorship and guidance from that particular office, that would have been better. So when I say mentorship and guidance, if maybe they were intentional about my career, maybe I wanted to attend an event, or I wanted to attend a conference or a seminar, or they were able to push me to say, take this certification. We know we are not paying you much. We know what we are giving you is quite small. Which is why, please, shout out to Lagos branch. Put your hands together for the MBA Lagos branch. When I came to the MBA Lagos, I'm not even trying to praise her, but Madam Chair, Gideon Edem also, even Mr. Olabisi, these are people that have been very, very intentional about my career. At a time, I wanted to leave law and focus on MC. And I spoke to Madam Chair. Madam Chair, for an hour, she was on the phone telling me, okay, Nimi, apply here. She had not even gotten into office then. Can you remember, ma? She would tell me, apply here. Okay, what's this one? What are you going to be doing there? And in my mind, I just want to do MC. This woman, leave me alone. But with her help and guidance, I was able to take that job, and I really enjoyed it. Even when I wanted to take a job more recently, and I spoke, I know he took me out for lunch. He's a big boy, Gideon. And then we got talking about it, and Gideon was able. So I think young lawyers need more than just remuneration. So you might not be paying so well, that's for law firm owners, but are you providing the much needed mentoring, the much needed guidance, the much needed counseling? I think that's just my 2B. Thank you very much.
Thank you, Nimi, for sharing your story. So, before we come back to the...
All right. Good evening, everyone. My name is Ekoma Solomon Ogun. I serve as the head of policy advancement of the Nigerian Bar Association Young Lawyers Forum at the national level. I'm so glad that we're having this.
Speak up.
I'm so glad that we're having this conversation. This is because last year, because of so many complaints we had from young lawyers across Nigeria, we had to carry out a survey. And this survey, we had a report. And I'm going to show the data that we were able to compile last year. We had about 5,000 responses, over 5,000 responses. And we asked a question: what actually is the problem or problems faced by young lawyers in Nigeria? And as you can see there, the first is remuneration. And that is 57.57% of the responses that we received. And the second there is lack of career opportunities. Now, when you look at these things, you'll come to understand that the problem young lawyers face actually is the problem of remuneration. And I would like to correct an impression. The remuneration order is not in respect of the payment of lawyers. It is in respect of the relationship lawyers have with their clients and the baseline for them to get their fees, not necessarily on how they can pay lawyers or what lawyers are supposed to earn. And for a young lawyer who is just starting off, and I've heard it a lot of times from our senior colleagues that tell us, we can't pay a lawyer. There is no money that can compensate the work a lawyer does. But the problem is that as a young lawyer, I would need knowledge, I would need experience, I would need expertise. And I can't get these things if I don't have money. I would need to go into some kind of places to meet clients or potential clients. I would need to speak to some people. And if I don't have the funds to go to those places, it becomes a problem. If I don't have the funds to advance my career, to even have that expertise, to get the money, then it's a problem. So our key takeaway is this, that, okay, we had to also ask the baseline that we have to pay lawyers. So because we have the rural areas and then the urban areas, for example, Lagos, Abuja, and Port Harcourt, that's the urban area, then KB, Enugu, and Ebonyi. So we had a baseline, and the baseline is for urban areas, 200,000 to 300,000, at least, for young lawyers that are starting off. It can give them that edge to carry on. Then for those in the non-urban areas, 200,000. So we had this conversation again with the chairman of the Remuneration Committee, Chief Obigolu SAN, and he promised us that the NBA is going to look into this. And I hope that we look into this fully. It shouldn't be like a jingle every election year. We are talking about the remuneration of young lawyers. And I hope that with the data we have, that the NBA will have to work with that. Thank you.
Thank you, Solomon. I mean, I like your data. I was looking to see. I'll just take this last. I'll take this last round of questions, and it's on mentorship, and then I'll take interventions from the floor. So, I mean, this is about mentorship. And I'll begin with Otumba. You lead a law firm, DOA, we've established. What does mentorship look like at your firm? Is it formal or informal, deliberate or accidental, and is it working?
I mean, mentorship would take two sets of people, right? It takes the mentor and it takes the mentee. So both parties must be willing. But we do have, to be very truthful, I would say what would be an accidental mentorship structure, and people pick on those that they would like to have most times as mentors. We don't try to force anyone on any other person. But I've had associates come to meet me and say that they would like me to mentor them. And I've said to them that I hope they don't sleep early at night. Because it can be that demanding in being mentored. But I mean, that was just a joke. But the reality is that we have a structure that works. And we've also had people, even from outside, reach out to say, oh, I'd like to be mentored. Some people don't live up to it. Again, sometimes you must also realize that, particularly for senior lawyers, they're very busy, right? So getting that time or getting that window sometimes could be very difficult. But I think that as young lawyers, they need to put in the work. And the work also means that being persistent and insisting on what you want. If you want that person to be your mentor, if it comes at the cost of constantly disturbing the person and ensuring that you build that relationship such that the person then finds it a lot easier to call you on a drive to the airport or have a chit chat with you that is nothing so formal, then I think that is also something that everyone should try to work towards. But it doesn't lie on one side or the other. I think it requires both parties to try to make it work. But in DOA, yes, we do have, and generally I think it has worked, and it has worked very well. Thank you.
Okay, I'll quickly go to you. Well, let me come to you. You had a mentor, and what did that look like? And if you had known, again, how did that look like? Oh, yeah.
Okay, so I've been fortunate to have mentors and people that have invested in my growth. I would say that mentorship doesn't always have to be professional. Yes, most of the time it starts in a professional setting, but I believe that you can absolutely have mentors that guide you as regards values and ethics. And again, you can have mentors from afar. Basically, they will be like role models, people that you look up to and you learn about their daily habits, and it's in a way shapes your own life and your habits and your ethics. I would say that, just like Mr. Alex Adedipe said, mentorship is a two-way street. It takes the mentor and the mentee. As a mentee, you would have to remain teachable. You have to constantly ask questions and seek knowledge. The absence of mentorship, I think, would mean that a person will be navigating their professional life alone. While this can help in some cases, in the sense that you learn how to be more observant, you learn how to be resourceful, and you learn how to trust your own instincts. In a way, you make certain mistakes that you could have avoided, and you arrive at certain realizations a little bit later than people who have had mentors and people guiding them. So I would say that, yes, I have had mentors and it has greatly shaped my life, both in structured and formal sense of mentorship and also the informal sense of mentorship. And I would say that to any young lawyer who is thinking about an older lawyer that you want to be a mentor, again, like Mr. Alex Adedipe said, most of the times these lawyers are very busy. So while you may not have a structured mentorship program with this particular person, you can just learn about the person, follow them on LinkedIn, read about their works. It doesn't also have to, the mentor doesn't also have to be in the legal space. I
for instance, have somebody like Mrs. Ibukun Awoshika as a mentor. I have never met this woman before. But just from watching her videos, seeing the way she speaks, and the things she speaks about, I have learned a lot. So I absolutely believe that it is important to have mentorship, and it doesn't have to be in a structured and formal sense.
Okay, thank you. Now, I'll go to Tolu, and then I'll ask the last question from Gideon, and then throw the conversation to the members. Tolu, people management, I suppose, is a core skill that you've built over the years. What would you say to a young lawyer whose firm offers great pay but zero mentorship?
Thank you. Great pay is one win. So
Can you speak up, please?
take it. Yeah, I said great pay is one win. You should take it. I'll advise you, absolutely. You have great pay, there's no mentorship structure, formal mentorship structure. I will say you will still take that job. Great pay is not negotiable. You don't find it everywhere. And then I'm going to proceed from where Olivia stopped to say that it's not all law firms that offer you structured mentorship. You know, I always say that as a lawyer, you are a business person, and your career is in your hand. It is your responsibility to grow it. It is your responsibility to grow your business. So in growing your business, you need clarity, you need people who will help you. So you don't need to look for your mentorship where you work. There are so many people who can mentor you, formally, informally, structured or not. Mentorship is now everywhere. Some time ago, we didn't have the consciousness of all of this mentorship thing. I mean, if I knew about mentorship earlier, I probably would not take, some decisions, or I would have taken some decisions differently. But now, you can actually walk up to a senior if you are serious, and they are ready to help you. Mentorship gives you like a foot in the door, creates opportunities for you, gives you clarity. What you don't know that you are lacking, they are telling you, they are pushing you forward. So yes, by all means, you need mentorship. But then, if you don't get it, a structured mentorship where you work, it's still not a loss. Get mentorship outside, get your great pay, and move on with your career. Thank you.
Now, Gideon, this question is to you. And you are answering this question on behalf of all the young lawyers in this room and perhaps in Lagos branch. The national elections are coming. What is the expectation of the young lawyers of the person they would like to be the president of the NBA?
Wow, thank you very much. I know that during elections, a lot of people speak to young lawyers and make promises to young lawyers.
And let me just say this. The reason I've asked this question of young lawyers is because there's a perception that most senior lawyers use young lawyers as their campaign stooges, but don't take care of them. So what are you saying to the would-be president of the NBA?
All right, to the would-be president of the NBA, I'm hoping that when you become president, that this would be about the last time. I know that this conversation will continue, but this would be about the last time that we'll have to sit down and keep discussing the fact that people are being paid low. There should be an intentional effort to ensure that young lawyers get a seat at the table. There is actually a committee that I learned of where people sit to discuss the role of young lawyers, and I heard that even in making up the membership of that committee, sometimes young lawyers are not brought in or nominated to be on that committee. So there should be an intentional effort. Let every appointment be seen to reflect the national spread. Let us see that young lawyers are represented. Let them have a real say. And by the next election, let the campaigners, let the people who are campaigning have other reasons to look at other areas beyond just speaking to young lawyers or making young lawyers the focus of attention. And beyond all, just make the NBA proud. Thank you very much.
Thank you, Chairman. So, questions from the audience or interventions? One, I see none, so one. There's a hand there, 2, 3, and 4. 4 of you, please. There's a microphone here.
Good evening, everyone. My name is Nonso Aze.
This is indeed an interesting topic, and just by the side, great accolade was given to Foundation Chambers. So I am proudly a product of that firm. And I can
Chairman, send your letter. Oh.
I can confirm that the culture of a firm being toxic is really something that dampens the enthusiasm of any young lawyer. Foundation Chamber was a good place. But that's by the way. Talking about remuneration, what I just have to say is that it goes beyond money. There's this argument, yes, I have to take myself from point A to point B and all that. But there are some things you can't change. When you're a young lawyer, you can see a firm. I think what young lawyers should begin to look at is, what kind of law firm do I work in? Not necessarily the size of the firm, or necessarily the prestige, so to speak. Are you working in a firm where the principal partner is interested in you growing? I mean, I make bold to say it. I can actually refer myself to a maritime lawyer because of Mr. Chidi Log, SAN. It's as simple as that. While I was working there, yes, I was being paid a living wage. It may not be the best, but the reason why I stayed there for 3 years, almost 4 years, was because I found value. There was never a time someone, talked to me in a way. You can speak hard to a young lawyer, but you don't speak negatively to someone. I give you a typical example. There was a time I was going to Nemasa. I was working in a firm, not Foundation Chambers. I was a young lawyer. I was in a taxi, the yellow taxi. There was traffic in a Papa. I came down from the taxi to take bike so that I would meet with the person in Nemasa on time. I had an accident. By the time I got back to the firm could not give me a day off. I was wearing sandals to work. So these are the things that you look at, you see, beyond paying that person, if you have an interest in that person. I had an associate who every time she comes to work...
Please, can you round up?
Okay, I'm rounding up, yes, because I wish I had all the time, but I don't want to ask a question, but it's an intervention. This associate, every time she comes to work with a long face, I said, like, XYZ, what is the problem? You have to be able to know the people working for you. It's not just about deliverables. You have to send the opinion by 4 p.m. Until she opened up to me that there was something, I don't have to give the details. And I saw that in that week, at home. So beyond that, I've been a young lawyer doing an MC like Demi Edime. My madam came to me on the stage and said, by the time you are done gallivanting, I want that opinion by 5 p.m. All the jokes I was about to say in that wedding vanished from my head. I was lucky that I had an assistant.
Maybe I did without the consent of your principal. But please, can you round up, please?
So at the end of the day, young lawyers, please, money is good, but there is no way you won't survive. My first salary at Ikeja was 35,000, but I used that 35K to go to Kano when my brother was getting married and I bought souvenir. I don't know how I did it. You will always survive. But what you will not survive is to spend 10 years in either a big firm, learning nothing, or just getting money.
Thank you, sir.
Thank you so much. Yeah.
Thank you. Second person. Yes, please.
All right. Good evening, panelists. My name is Joseph Olabi. My question is to Mr. Alex Adedipe. So you had mentioned something regarding young lawyers and AI, and you had said the way technology is going now, maybe grade may not necessarily be a big thing soon enough. But young lawyers also get criticized these days. Maybe you get an assignment and your very first thing to do is to consult maybe an AI platform. And it's always like, oh, can't you even think first, or can't you use your brain? So I'm like, where is the balance between that? And then you had also mentioned learning other skills. You had said client management, responding to emails earlier. So I just wanted to ask that, what are the other skills? Because this can't really be what a lawyer would be limited to. Thank you.
Thank you very much. We'll take all the questions and then they'll be answered together. The third person. Please raise your hand. Yes, it's...
Okay, thank you very much. It's been an amazing session. Thank you very much. My name is Sopuruchi Rufus. My question is, how do you reach out to your partners if you're not fairly compensated? So I know that there's a thing where when you're applying for a job and they ask you what's your salary expectation, it's kind of like a trap because they want to know how much you think you're worth. And you're always stuck between, should I tell them how much I think I'm worth or how much I want to be paid, and then you eventually say an amount, and then they start paying you that amount, and you come in and you find out that your fellow colleagues in the same position are being paid higher than you are. And maybe you're doing your best, you're putting in the work, they are giving you accolades, oh, you're stellar at your job. But then you find out that someone that is on the same position as you are is earning like 50K or 100K more than yourself. How do you approach such a situation? I think I will address the questions to any of the partners on the panel.
Thank you. Then the last contribution. Sorry, I must take the chair before I'm sent out of this place. Okay, then, yes, after you, then the chairman. Yes, please.
Thank you very much, sir. My name is Bruno Ibebunam, and I am an associate at Kena. I genuinely believe that the hard questions in this discussion and this topic have not been addressed, honestly. I understand that young lawyers must have competence in order to request proper and adequate remuneration. But then we can't take away the fact that many young lawyers are still grossly underpaid. I've been in a situation, in a public setting, where a senior lawyer, just like Solomon was saying before, said that he does not genuinely believe that a lawyer can pay another lawyer, and that in fact he believes that young lawyers should pay senior lawyers for what they get to impact in young lawyers during the very early years. And I genuinely believe that sessions like this, when we come to sessions like this, it's almost as if it's an opportunity for management and employers to present their perspective on why young lawyers are underpaid. So you hear things like, you are paid a little amount, manage it, you will survive, I was paid this, I was paid that. I'm not going to go into all of that, but I want to ask a very direct question to every single person on the panel, minus Mr. Adeleke, because at some point he said, there's something at DOA where they are very transparent and they project the numbers for the year. So I'm going to excuse him from this question. So I'm going to ask everybody. My question.
Thank you very much.
Okay, thank you very much. So my question goes to everybody, including Mr. Moderator. Do you believe that young lawyers are underpaid or inadequately remunerated? And if yes, what practical steps and methods and sanctions do you believe should be put in place to properly protect young lawyers from professional exploitation, inadequate or no remuneration, and issues surrounding welfare of these young lawyers?
Thank you.
That's my question. And I just want to make a very small comment. Please permit me.
Please, can you just wrap it up?
Thank you very much.
Yes,
thank you very much. I just want employers and managements and senior lawyers to know that on the issue of remuneration, young lawyers who are building competence and capacity in the profession in your employment will keep seeking better opportunities away from you as long as you are paying below what is desired. And so that ultimately also affects your establishment, and you see issues as to talent retention. Thank you very much.
Thank you very much. I'll just summarize your question to be, why are lawyers underpaid? That's my... Chairman, you have the floor.
Thank you to everyone who is still in the hall by this time. Thank you very much. Mine is response, intervention, suggestion. I'll start from the question that he just asked. Are young lawyers underpaid? Yes. Are lawyers generally underpaid? Yes. See, there's a state of emergency on the legal profession and the way we earn. And in case you're in this hall and you don't already know, legal services, I have given it the classification of essential service at this point. Nobody wants to pay you as a lawyer. Even your sister does not want to pay you. If a client has a choice not to pay a lawyer, they will go with that option. If you look at a transaction, maybe a commercial or other kind of transaction, and you look at the various professionals that are earning, lawyers earn the least. Lawyers earn the least. Look at it. Even this our real estate that we are fighting for. Lawyers earn the least. Do young lawyers earn little? Yes. Do senior lawyers earn little? Yes. Now the conversation for remuneration may have begun, oh, young lawyers are earning pittance. And then it's moved on to the bigger picture. Why are they earning so little? Because their employers are earning little. Now, in the white paper, they talked about, they made recommendations as to minimum payments. This white paper, by the way, was what? During Olumide Akwata's time, president. So how many years ago? And as at then, for Lagos, there was a baseline of 150. The truth of the matter is, even today in Lagos, there are lawyers that earn less than 150,000 naira. So, how do you expect an employer, and again, different categories of law firms. You have the big law, where our moderator and past chair work. You have mid-sized law, whether by virtue of numbers or by virtue of the monies that you bring in. Mid-size, where they have a lot of lawyers and they earn a bit more. But the truth of the matter is that majority of the law firms in Nigeria are small law firms. In terms of number of lawyers, and also in terms of the revenue that they bring in. So, who are the majority of the employers then? They are the small law firms that their earning capacity is not so great. You see, what I always say is, and I also trained under that system of, I cannot pay a lawyer enough. But I enjoyed it. This is my own story. It doesn't have to be everybody else's story, and it doesn't work for everybody. I enjoyed it because straight out of law school, I developed an entrepreneurial spirit, and I was looking for briefs.
Chairman, I think based
Sorry,
on
sir.
the pass
Just
you've
a
given
moment,
me,
sir.
I'll have to stop you.
So, just a moment, sir, please. I think I can extend some time for myself, because I'll also speak to the bar's perspective and what we are trying to do in this regard. So, again, orientation of the people that you work under matter. So these things, you can't treat them as isolated scenarios. You have to look at a lot of things. Now, if a lawyer tells you, I don't feel I can pay you enough, but they want to take up all your time, I don't think that's fair. If you feel you can't pay a lawyer enough, speaking to the employers now, that lawyer should have, room to be able to look for their own work, to augment their pay. To augment their pay. So please don't be paying somebody 100K and you want to take the person's entire time. Give the person room to hustle some PP. So there are different styles. Some people are comfortable with their associates handling private practice. Some other law firms want you to bring your private practice on board. If they want you to bring your private practice on board, they create an enabling environment for you. Tell you, oh, is it that you take everything, like my boss did, take everything from what you earn. Use the office resources, train yourself, take whatever you earn. Some others will tell you, take a percentage of what you bring in. So to young lawyers as well, the reality of the situation is that majority of the law firms in Nigeria are small law firms. And your employers are probably struggling to pay your salary. That's the truth. And that's why we keep on having this remuneration conversation. Because we must charge what will enable us to be able to live well and pay our staff. Now, if you are in a small firm and you know that you can't pay enough, so it's either you give the young lawyer a percentage of what they bring in, or you give them liberty to do their own PP. And now, young lawyers, you need to understand that you're a lawyer. I don't believe in that when somebody comes to tell me, I don't have work, and you're a lawyer. I don't believe in it. Because there are so many avenues for a lawyer to earn revenue. If it's CAC, if it's trademark, if it is whatever, I don't want to believe that a lawyer is out of job. You can apply yourself. Now, if you can apply yourself as a lawyer, what value are you bringing to that law firm? If your please don't crucify me, I'm just speaking facts. If your salary is not enough, can you think about being part of the solution to the problem? If your boss is cleaning out and making all the money, you have a different problem. If you're in a firm that is trying their best to give you, the best that they can do, what can you do to add to that firm's bottom line? Can you also help apply yourself? If your bosses are doing work and bringing in business into the law firm, do you just want to sit and receive a salary every time? Do you want to apply yourself, bring clients into the firm? That may increase your take home. That's a suggestion for both management and the employers. Management, please, if you can't afford to pay your lawyers enough, give them room to earn and do PP, private practice. If you don't want them to do private practice, incentivize them with the percentages for when they bring in work, and also incentivize them with other things if you can. So we cannot treat it as an isolated situation of employers-employee. I have so much to say, but before the moderator will override me. Now for the bar. We've been talking about this thing. We've done remuneration town hall. You guys said you don't want your money to be regulated. We've put that one on pause. We are still charging what we are charging and expecting to pay lawyers well. Chair of Younger Lawyers Forum, I gave him an assignment. I said they should go and carry out a survey so that we really know what the salary scale is for different categories of law firms. Because the truth of the matter is, you may be in that your law firm. Your boss does not even know what is obtainable outside. So we want to come up with some sort of a guide as a branch as to what is obtainable in terms of remuneration. Based on, so when the survey comes to you, please respond, because we need data to be able to push any advocacy, anything that we are going to be doing as a branch. So when that data comes out, we'll publish it and say, branch members, law firms, please, this is what is obtainable at the moment. Yeah. Want to charge more, however you want to go about it, so that even your boss that thinks it's still okay to pay 50K will realize that that ship has sailed. So as a branch, that is what we are going to do. We are going to come out with some sort of an advisory, and of which that advisory itself, the reality should make us ashamed, because we know how much we pay other people who do not have as much or many qualifications as we do, which takes us back to improving value. As a lawyer, your value should not be tied to your salary alone. Don't crucify me, but it's the truth. And if you want to set up, what's the end game? Set up your own law firm, become a partner in a firm. If you're setting up your own law firm, will you not need entrepreneurial skills? So at what point are you going to cultivate it? When you want to set up your own practice, you will start while you're working with someone. You will start hustling briefs and bringing it to the table. If you want to become a partner in that law firm, how do you think you're going to make partner without bringing in money, without bringing in clients? So please, don't sit down and think that it's just about salary. You are a lawyer. Your capacity is so wide, and you need to open your brain and expand it. Thank you very much. We continue to dialogue on these issues.
I think you'll agree with me that the chairman has answered all the questions, save for the one on AI, which I'll just yield the floor to address the question on AI, and then we just close out in 1 minute from each of the panelists. You can take a 1 minute now, Otumba.
I think that to my point around artificial intelligence and the fact that whilst today what you're doing is that you tend to use it to help your work and improve productivity, right? The reality of the matter is that it's actually your biggest competitor, right? So every time you are using it also, you're training it to be a better model, right? So every information you feed on it is enjoying it, right? But again, I'm not going to say that. So there are law firms, and I think we do have Cloud for Office in my firm. But the reality is that's not going to be your primary use. What work would there be for you eventually? There are many things. So you become, you start to look at the product of the AI itself, right? You start to check for hallucinations. There are many things that you can still do, right? And there's so many things that at some point in the nearest future, that would be the first question that an employer would ask an employee on how best you can use it. The same way, many years ago when our parents were seeking employment, no one was asking them if they could use the internet, right? But today, you would write there that you are MS Word and you are Excel and Microsoft certified and you know how to use it. Why are you saying that? Because it has become a tool for you to use. That's exactly what artificial intelligence will do in your work. So whilst you're enjoying it, just also know that it's going to be there to help your work. It might make some people lose their jobs. But again, overall, it's going to enhance productivity and we would all make more money by the use of it. I think that is it in a nutshell. And so that it doesn't seem like this, my friend, was not answered. And I'll tell you, I stand with you authoritatively, and I think that it is very unfair for people to employ and exploit lawyers. I think that we should pay people fairly and we should be very nice to them. Thank you.
Thank you. So I'll start from just 1 minute wrap up, and then we close out from you. Yeah.
Okay. So I think to wrap up from my end, I would like to speak on the question the lady asked about negotiation, especially for young lawyers. I would like to say that young lawyers would need to have a change in mindset. We shouldn't be afraid to have conversations about negotiation because these conversations can be had professionally and respectfully. A negotiation is basically a conversation. The two parties have something that the other person wants. We have the skills, capacity, they have the platform and opportunity. So I would like us to move on from seeing it like the other party is doing us a favor. I know that it can seem that way because for what you cannot accept, there's like 20 other lawyers that will probably accept it. But if we can have a change in mindset and see these negotiations as conversations, it would help a lot when it comes to bargaining and having conversations about remuneration. Aside that, I would also like to say, again, to add to what the chairman said, you also have to invest in yourself. You shouldn't come to a conversation about negotiation when you are not, should I say, sure of yourself, when maybe you are not even at the level where the other person is, how do I say this? You're not at the level that would be attractive. Let me just say that. So young lawyers should also try as much as possible to invest in ourselves. We should toot our own horns, build professional relationships, and hopefully we can, in the future, get remuneration that we deserve.
Thank you very much. Gideon, 30 seconds, just round up.
Thank you. I would say two things. First, to the employers and to the senior lawyers in the hall. It's very important that we are kind, we respect others, and we listen to them. because it is from the history that we have with these persons that they cannot just reach out and have the conversations with you. They feel you would not listen. But on the other side, to young lawyers, I think that a lot of senior lawyers are also willing to help as much as possible. And the door is always open, but most times we don't know how to knock. So people are more willing to help than you realize. So try to knock that door and go have that conversation. Thank you.
Thank you very much. Tolu, 30 seconds.
Perspective of to the employers and to the employees. Employers know when they are not doing well. That is the truth. If you're not paying your lawyers well, you know that you're not paying your lawyers well. And as for employees, you know when you're not doing well too. If you're doing well, I would always say that if you think you deserve more, approach your boss and talk about it. I've done that before. And if you think that you have spoken about it and that person is not able to pay you, and then I think you should carry your business to where they can pay you. Move on. If you feel that you have more value and they're not recognizing it, you're not being appreciated enough, that's if you actually have the value, then move to where you think you are appreciated. Or try to start your own practice.
Thank
When
you.
you finish from law school, you're already a lawyer, you can start your own business. So why not
Thank
start?
you. Otumba, 30 seconds. 30 seconds.
All right, thank you. I think there are two sets of lawyers that they were speaking to, actually. So there are lawyers who are working in law firms who are young lawyers. And I think that those lawyers, if you employ them, please do pay them and pay them very well and compensate their efforts. Because I don't like to use the term remuneration alone, whether you're using it together as compensation. But I think there's the other side of the lawyers that the chairman had mentioned that they should do PP, even though we don't support that in DOA. No, I mean, I'm just teasing. But I mean, those that you want that are doing private practice or that are hustling for the same job as we're hustling, those ones, I don't know. I mean, all of us are all looking for pay together. So that's a different ball game entirely. So even I am looking for more pay, like she said. But for the ones working in law firms, I think they should be well paid. Thank you.
Well, mine is to thank our panelists. I've listened to you all. I thought you've said as mine. I have not to add. Thank everybody for listening to us. Thank you.
Please make that applause better for our final panel, the most favorite panel of the evening. Make it better, make it better. Thank you all. Please, you can come take the center stage for pictures and doing us the honors of present tokens and plaques. Please put your hands together for the former chairman of the NBA Lagos branch, Honorable Justice Tyro Tired, a friend and an active participant of the branch. Thank you so much, sir, for always being present, for always being here, for always participating. Can members of the Law Week Planning Committee please get ready for their photo op?
I know why you are here, and you've performed wonderfully well. In appreciation, I present this to you on behalf of NBA Lagos branch. Thank you very much. My chairman, congratulations, you've done well, both in and out of office. Thank you very much. I just want to say something. You mentioned one name, Chidi Ulogo. I've always known him as a gentleman. I remember many years ago when I was not too young then. I was in a case, maritime matter. Read the file. Said, can we meet in my office? I went to his office. We sat down. Said I will ask my defendant then, settle this matter. And the
humoristic lines.
I'm not surprised what you said about me. Congratulations. Thank you very much. Yes. We add your name. I don't want to be repetitive. But I thank you, and on behalf of the branch, thank you so much. Have you?
Picture. Can we have, okay.
Gideon. Chairman of Young Lawyers Forum. Thank you for your intervention, and I'm sure that by the next conference, things will be better for young lawyers. On behalf of the branch, we give you this. Thank you very much.
For their pictures, can we have all the panelists take pictures with the chairman? Members of the Law Week People are coming to take pictures. Members of the Law Week Planning Committee, please make your way to the stage for your pictures. Members of the Law Week Planning Committee, if you're outside or you are inside, please, just after this session, you'll be taking your own pictures. All right, a round of applause one last time for our panelists. They've done justice to the subject, beyond paying dues, fair remuneration, and sustainable growth. Okay, so just the panelists. We can't get enough of these panelists. No, I'm so preachy. We want the panelists to take more pictures. Yes. Just the panelists. Yes. Just the panelists. Esosa, just we still need the panelists on stage. Yes. Panelists and the moderator. Yes. Just, okay. Just descend a bit. Exactly. Can we have the handheld mics? Walking handheld. Okay, yes. Can we have one more? Is that functional? Can we have hand? Okay. All right. Can we have members of the Law Week Planning Committee? Members of the Law Week Planning Committee?
Members of the Law Week Planning Committee, this is appreciation session. But if you leave at your loss, you see all this? We have more laptops. We have return flight tickets. We have law pavilion. If you leave, you do so at your own risk.
Please do not leave. We're about to have our raffle draw just after this appreciation session.
We even have more gifts. If you leave, please don't leave. We are wrapping up. We have wrapped up already. We are just in appreciation session. I want to take the time out. Please, members of the Law Week Planning Committee, I'll hand the microphone over to the chair of the Law Week Planning Committee after I've made a few comments about her exemplary and sterling leadership. I want to especially thank Mrs. Obosa Akpata, who has led this phenomenal team to give us this world-class conference. She has been the best to work with, always taking on everybody's comments, our opinions. You know, she's amenable but still firm. So, in fact, there has been minimal, it's always so, in these our planning committees, a lot happen. But I think this one has gone rather smoothly for most of it. So I just want to say thank you very much to Mrs. Obosa Akpata and the entire membership of the Law Week Planning Committee for this amazing. We still have 3 days to go, but so far so. I'm sure we can say that it's been amazing so far so, right? Do you concur? Yeah. Round of applause. Thank you, but I'll give her the microphone to say one or two things.
I would like to use the opportunity to say a sincere thank you to everyone you see here. My alternate, Dr. Kubi Udofia, my vice, Mrs. Tola Bokno, and the head of programs, Dr. Nike Esson, supported by every single person. If you will permit me, I would like to, if you will permit me, I have to also call out the head, the chair of the Programs and Content Committee, Subcommittee. He's a very gentle man, So, Baba Jimmy Ayorinde, please step out. He's representing not just himself, but his alternate, who is unavoidably absent, Dr. Kola Mayomi. You see, that's the problem. When you start to call out, you get into trouble. I cannot now finish this conversation without calling out. There are always people in your committee that you harass, they harass you because you are all working towards the same goal. I cannot finish this conversation without calling out Kelvin Aya, supported by his alternate, Rita, and of course, our head of publicity, Oliver. And I know he's also supported by Coco. Now, yesterday, we were all very excited at a particular raffle draw, and it was that of our gentle, how can you see she's right at the back, please come out here. Our gentle but awesome and dependable Secretary Shola. They're always so soft-spoken, it doesn't matter the pressure she's going under. There was a night she said to me, "No problem, Madam Chair, I'm not even going to sleep." I said, "No, Shola, you will sleep. Because 2 days ago, I fell ill because of this walking till 3, 4 a.m. So you will sleep and we'll take this up tomorrow." And of course, ably supported by her assistant, Joy. So please pardon me if I haven't called you out specifically. If I haven't called you out specifically, you have all been fantastic. In fact, I'm happy I saw Sopuruchi. These young Gen Zs, Sopuruchi has been fantastic. We had to pull her, into publicity. But sincerely, I say a big thank you to every one of you because I have got support from everyone. And in fact, members of the committee who are also my colleagues in the firm had to do double shift. And I have to mention Toyin Eyitayo. Now, we would like to say a big thank you because it's easy to say all of this. Without the support of our sponsors, we won't be able to afford this hall or the venues we have got. Our sponsors have been fantastic. From our headline sponsors to the friends of the bar. Every penny came in useful, and we are most grateful to them. And to our partners as well. I don't want to reel out names, but we know them because we have publicized them. We are grateful. Now, it will be remiss of me to drop this mic without thanking someone who in this time has become a sister. A most supportive lady. Very solution-minded, I must confess. Nothing phases her. So after a while, I said to myself, don't worry, Obosa, this may be a bit of a new terrain to you. Not that I haven't managed or run or put together conferences. I actually have. But with the NBA, hey, it's a different ball game. But this lady was always available. She was actually in the trenches with us. Uche, thank you very much. I call her Madam Chair. That is the truth. Thank you. To all of you, without whom we will not have a conference, I want to say thank you. To those who came early, to those who came later despite the rain, please accept our gratitude. We are grateful. And to our seniors who have remained here to encourage us, Ma, thank you very much. We're grateful. Mama Harriet, who went and came back for the young members group. That is how much she loves young people and what we're doing. We say thank you. I'm happy we have a representative of the bench with us. Yes, retired. The Honorable Justice Taiwo, retired. Sir, we say thank you. I would love very much to keep mentioning names. For our aspirants, you know I cannot mention you because tomorrow they will capture it and say something else. But indeed, we say thank you. We see your love for the bar, and we are most grateful indeed. I would also, please pardon me as I round up, and I am rounding up, to say a big thank you to a perfect gentleman. Always the first in the hall. Was with us in the health walk, went through it all. Thank you very much, sir. Thank you. Most appreciated, sir. God bless. And with that, we come to the close of the technical sessions today and look forward to seeing you all, yes, as we go into the remaining 3 days of the law week. Thank you all very much.
Thank you. I just want to make a single intervention before they take a vow. I want to encourage you people. Whenever you're called to serve, please don't hesitate, because that is where your capability is being pictured. I used to be like you many years ago. In fact, we really made up the Lagos Bar when we served, and I was the first person to donate a bus to the MBA Lagos Bar. Wow. So what I want to tell you is through serving the bar that I am where I am today. From the bar, I became a federal commissioner, Federal Judicial Service Commission. From there to NJC, and today to a life venture. Why? Because I was committed and I was humble. I was always doing what I am supposed to do, even excel my boss. So my advice, don't stop today. Whenever there's a call to duty, please put in your best. It does not matter. Put in your best. And besides, you are in the best profession in the world. So like the chairman said, try and train yourself and prize yourself. Forget about this issue about young lawyers are being underpaid. No, if you're being underpaid, but you have been trained to be better than AI. That's what you should look for. How to be better than AI so that you don't lose out looking for money, but serve and it will pay in future. Tomorrow, one of you will be like me or even exceed me like a life venture. Thank you so much.
Thank you very much, Ma. I'm glad I had the opportunity to mention, though in absentia for very good reasons, the chair and alternate chair of our fundraising subcommittee. Please give them they understand. Coincidentally, there are 2 headline sponsors. They were fantastic because they actually brought encouragement to us when we needed it the most, right at the beginning when we started. So our gratitude also goes to them. Thank you.
There you have it. Members of the Law Week Planning Committee, they've delivered on their mandates and given us a stellar conference, a stellar Law Week. Round of applause for them and a shout. A round of applause and a shout.
So before we go into the raffle, we are still on appreciations. See now, I just got another alert. See, the sponsorships are still coming. Another 5 million has entered. So when you say thank you, you get more. So I want to take this moment, as we've appreciated the Law Week Planning Committee for the phenomenal work that they did, I want to take the moment to expand on appreciating our sponsors. It's important to say thank you. Without them, we will not be where we are. And again, I did this yesterday, but I'll do it again because they did spend so much, and without them, we'll be nowhere. To our headline sponsors, the law firm of Kekere Ekun, Salami & Co., and the law firm of the Equity Temple. As the planning committee chair has said, coincidentally, they are the chair and alternate chair of the fundraising of the Law Week Planning Committee. Thank you so much for your headline sponsorship. To Mr. Femi Gbajami Mila, our Sapphire sponsor. Thank you so much for your generous donation. To our Elders Night sponsor. To our Elders Night sponsor, the law firm of George Etomi and Partners. Thank you very much for your generous donation. To our gold sponsor, Babalakin & Co., thank you very much. Our bronze sponsors, Patrelli Partners, Alege & Co. Kogito, can you project our partners on the screen as I'm appreciating them, please? Alege & Co., Tayo Oyetibo LP, Wise View Legal Consulting, thank you. Stretford Hill Limited, those are our bronze sponsors. Bronze sponsors. Thank you very much. So our flash, so we can move to corporate sponsor. Gold, bronze, thank you. Corporate sponsors. So our corporate sponsors, the law firm of Stream Sowers and Corn, thank you very much. To the law firm of Country Hill Attorneys and Solicitors, our health work sponsor, thank you. Femi Atoyebi and Co., thank you very much. We're on corporate sponsors. Kogito, please, corporate sponsors. Foundation Chambers, thank you very much, Leonard Silk, and your law firm and your partners. Thank you, sir, for your generous donation. First Cardiology Consultants, thank you. Sublaw, Sofunde Osakwe, Ogundipe, and Belgore, thank you. IHS Towers, Baron Architecture, Seplat, Oguntoye and Oguntoye, Gab Sterling, Drosk Company Limited, Paid HR, thank you very much for your Sunlink Manpower. You see why I say project it, in case I miss anybody. Thank you very much. Now, moving on to our session sponsors. We have Law Pavilion and Penwell Prime Limited. Thank you very much for your generous sponsorship. To our tea break sponsors, the law firm of OO Alao & Co., Niji Oni & Co., Perchstone and Grace, thank you very much for your generous donation. To our other corporate sponsors, Kenyan Airways, unfortunately I can't win these tickets because I'm not eligible, but thank you to Kenyan Airways. Thank you to Charles Adeyorinju for his donation of 10 laptops for our raffle. A lot of people left here happy yesterday, and more people are going to leave here happier today, thanks to his donation of 10 laptops. Mr. Charles Adeyorinju, thank you very much. To Law Pavilion, thank you for your subscriptions. To Nigerian Bottling Company, thank you. Evercare Hospital and AFCA Printing, thank you very much for printing our brochures. Now to our Experience Center. Did anybody here experience the Experience Center? It's so fancy. It's downstairs. If you had meetings, if you didn't have a good office, that would have been a good place to be and have your meetings to up your fee notes. It's downstairs, very lovely. Thank you to our Experience Center co-sponsors, Kogito. Thank you very much for co-sponsoring the Experience Center, and Law Pavilion. Thank you very much. And to our individual supporters, Libra Law Practice, the law firm of Mama Hirat Balogun. Thank you very much. We have Uwensuye Dosomwan and Co. Thank you very much. We have Ekweme and solicitors. Thank you. Shola Ajilola and Co. Thank you. CLP Legal. Thank you very much. Dwale Ovia and Alex Adedipe. Thank you very much. And we also have Esha and Macarius. Thank you very much for your generous individual sponsorship. To the friends of the bar, Nine Wells Law Practice, Ingige and Co., G.O. Shodipo and Co., Nicom LLP, Moshood Abiola and Co., Doyin Roads Vival and Co., SPA Ajibade and Co., Ada Ikendu and Associates, Akinwumi and Busari, Adetunji Shoyoye as an Associates Law, Legal Practice, Ayodele Akintunde and Co., thank you. And gift to the bar, Sadiku Momo Ilejueno. Thank you, sir. IOLA Legal Services, thank you. Sethage Partners, thank you. Thank you. We can't thank you enough. We are so grateful. This is, if we do all the planning and there's no money, if we do all the planning and there's no funds, thank you. The beautiful experience you're having is thanks to the funds that we received. And we are grateful. We don't take your support for granted. Yes, we'll continue coming back to you. But we know that the good Lord will continue to replenish your coffers such that whenever we come knocking, you'll be able to answer us. Thank you very much. Okay, now to the main business of the day.
Okay. It is now time for the time we've all been waiting for. In fact, let me rephrase. It is the time we've all been waiting for. Who is ready? Are you ready? If you are ready, let me hear some noise. Are you ready? So even you that has a law firm. Did I see Mr. BC Makonjola say he's ready? Former chair. Did you say you are ready? You want to win a laptop? You're supposed to be giving laptops now. Okay. So helping us with the raffle draw is going to be Kelvin Anyam. Please put your hands together for Kelvin. He's the chair of logistics and is a co-opted member of the ESCOs. I don't think we've even hailed our ESCOs this time. Okay, we did. Oh, okay.
While we are getting ready, for those who were not here when we took a bow earlier, please, ESCO members, can you please come out?
I see all of them. Oliver Omoredia.
Majority of them were members of the Law Week Planning Committee, though. But ESCO members, I think just a few of us came out when we called earlier. Are we more? Yes, there are more in the room now. Please, can we come out in our full compliments?
Let me call their names so that everyone can know their names. We have Oge Chimokelu,
Where's Mr.
our Ministry of Finance. We have Adekunle Olaofe. We have Benita Olejeme. Rita Nwokocha, Social Secretary. We have Madam Adebimpe Bada. Acharubi Adejo. Mr. Michael Igwebuike. And Oliver Omoredia. I hope I got all the names. Yes.
YLF chair, Gideon. I think the vice chair was here earlier, but I think he stepped out. Who's missing? We are 15. Who is missing? Secretary. He was here. So maybe he has stepped out. One. Mr. Secretary, are you here? If you're here, please come out. Please, members of MBA Lagos branch, please, I want you to give a standing ovation to the executive committee members because they have been the best. If you say our administration is doing well, it's a product of the team. You elected some of them were co-opted, but they have been fantastic teammates. They make it work. They make it work. And minimal stress. We understand ourselves and we all make accommodations for each other. I want to use this opportunity to specially thank each and every one of you from my heart. Well, I'm a woman, so I'm allowed to be emotional. I love you all. Thank you for everything that you do for the MBA Lagos branch and for your commitment. Thank you. Thank you.
Thank you. Please send our love to the Secretary of the branch.
Send our love to the Secretary of the branch, the Vice Chair, and also patients. All right. Now the moment you've all been waiting for. And this is how it is going to go down. Rita and Wakocha, you are not eligible. Okay, so this is... If you won yesterday, you are disqualified. Abundance, Abondi of Lagos, you are not eligible. We've seen your video. So this is what is going to happen. Our branch chair is going to do us the honors of picking. Do we have blindfold? Are we going to blindfold her? You know, this is ICPC, EFCC in one. So what will happen is that, can you all hear me? Can you all hear me? Oh, now you can hear me. The first winner will walk home with a laptop. We have 5 laptops sponsored by Charles Adeyoriju. Please, a round of applause for Charles. I saw him somewhere making so many phone calls now. He's a big man. So the first pick gets to go home with 1 laptop. Then a law pavilion subscription. That's for the second pick. The third pick is 1 laptop. Then 3 laptops will be won at once. And finally, a Kenya Airways ticket to any destination in Africa. Are you not excited? I've just been told that inside that my avian, another avian there inside. So I've been overruled, which means we're exhausting the laptops before we get the law pavilion subscriptions. Then Kenyan Airways to travel to any destination in Africa. All right, so can we have... No, we have to roll it first. Let's roll it. I don't want Abundance to win again. Okay. Roll it exactly. This list, was this list written today or was it yesterday? Today. Okay. Number 16. Number 16. Commercial break, please. Number 16. It is not written work culture. It is Olawuyi Ayodele. A round of applause for Olawuyi Ayodele. Oh no. Olawuyi has gone home. Sorry. Going. It's not you. Olawuyi Ayodele is not here. Going. Gone. Number 27, Chisom Stella Maris and Nyekwemba. A round of applause for our first laptop winner, Chisom Stella Maris and Nyekwemba. Can we have Mr. Charles Adeyoriju do us the honors of presenting this? Mr. Charles Adeyoriju. A round of applause for our laptop sponsors. 10 laptops in this economy. I wish I was a winner today. Do you have a laptop? You don't. Oh my God, you're surprised. This can only happen at the NBA Lagos branch. A round of applause for NBA Lagos. All right. We have 4 more laptops to be won. So if you are still here, you can be a winner. All right. Madam Chair. Pick a name that is not written on Wokocha. Number 45. Is it 45 or 45? 45. Number 45. Enobong Akpabio. Enobong Akpabio. Going 1. Going 2. Is she the one? Show us your NIN. Your birth certificate. We have to confirm. Number 45, Enobong Akpabio. 1 laptop courtesy of Charles Adeyoriju. Just like I said, this can only happen at NBA Lagos. All right. Madam Chair, use your lucky fingers to pick a name that will please the House. Hmm. 38. Number 38. I'm not seeing well. 3 and 8. Not 8 and 3. 3 and 8. Deborah O. Olarewaju. How do you know? She knew her number before this. It's not about sitting in front, too. Those of you at the front, go back. You can see that all the winners have been from the... Okay. A word is enough for the wise. 2 more laptops to be won. Two more laptops to be won. Even our sponsor wants to win a laptop. Hey. Number 41. Number 41. A personal favorite. I'm so happy. Nwosu Isabella. She was just called last year and she's already winning since here. Come on, hug me too. Yes.
So there's one more laptop to go. But yesterday, I was accused that my fingers are female sensitive. And it seems that's the case. I will step down. Somebody else should do the final. Mr. Olabisi Makonjola, please come and do the final raffle. Come, sir. Come. Let the brotherhood be proud of you.
And maybe he can even add 2 or 3 more laptops. Who knows? Okay, sir. The last laptop to be won for today. Number 12. Nwa Buaku Ebeleju. He still picked a woman. Was there gender inequality in this? Was there gender equality in this? Can we appeal? Men in the house, can we appeal? Instead of you to be sponsoring laptops. Instead of you to be all right. So our former chair would also do us the honors of picking the winners of the Law Pavilion subscription. So, Rita, what did you say? God, let them pick Rita and Wakocha. Number 24, Daniel Iyortium. Daniel Iyortium. Clap for him now, please. A round of applause. You people who don't want to read, you don't want Law Pavilion. You want laptop so that I can be watching Netflix. Trust me, he gets a warm handshake and a picture and a whisper in the ear. Maybe Mr. Olabisi will do something after. Who knows? What God cannot do, exactly. He said Law Pavilion is worth more than a laptop. Rita does not agree. All right. Last but definitely not the least. Number 37. Oluwatobi Oyebade. Oluwatobi Oyebade. The Law Pavilion subscription. Chair Emeritus, we brought you to pick men. Thank you very much, Branch Chair, for a job not well done. You did not pick a man. Okay, I think he picked one man. All right. Now, we've come to the pinnacle, the peak of this very moment. Because it cannot be the peak of the event. We still have, a grand closing party. Just be reminded that tomorrow, Wednesday, we have master classes at select law firms. And in the evening, the Young Lawyers Forum is... Please, Kelvin, yes. Don't disqualify. I saw Rita's name fall down. Please, she has to win something. Please be reminded that tomorrow, Wednesday, we have master classes at select law firms. The Young Lawyers Forum would also be watching a movie. You get your dancing shoes on and watch Michael at Ebony Live Cinema. I know the link is out now, and at the last check, 60 persons have already registered. So please do well to register. And we'll also be having simultaneously the Elders Night sponsored by George Itomi and Partners. On Thursday, it's time for the town hall where you get to hear from all your favorite candidates. On Friday, the grand closing party. Ain't no party like an NBA Lagos party. And you know, Rita Nwokocha is our social secretary, and she's been holding it down for more than a year now. So please, make your way to the colonnades in your white and denim for the closing party. Okay, Kelvin wants to explain the Law Pavilion.
So, good evening, everyone. I know that some of you are surprised that I had to replace the papers. Law Pavilion had a different arrangement for how they wanted their tickets to be won. Kenya Airways had a different approach to what they wanted to do. So what happened was they provided us with a barcode, which was at the registration desk. And then if you scan, you go to your mail, confirm registration. They will go to their back end and then give me a list of names, which about 125 names. So their own list was different from the one that was written in the morning. So if you didn't scan the barcode, obviously your name wouldn't be here. Okay, so we're going to spin and then we're going to pick, and I will call according to the list. Thank you.
All right. Are we ready? Are we ready? So what we are doing, we have 2 sets of gifts. 3 sets of gifts, rather. That's 2 sets of gift bags, physical gift bags. You take this home. And a flight ticket. That one is abstract. You cannot... Yes, that's the last one. You take it. Maybe... Okay, I think the flight tickets are here. Yes, this is it. Exactly. So anywhere in Africa, Madam Chair does not travel Africa. She does Europe, outside the planet, you know, Elon Musk, Starlink. All right. So, doing us the honors, please make welcome on stage an elegant and excellent woman. I just got to find out about her just this year, and it's been fun. It's been a pleasure working with her, just looking at her when she talks. She's firm, but, you know, when she smiles, you know that you are in for a ride. Please put your hands together for Mrs. Obosa Akpata, the chairman of the Law Week Planning Committee. You already know, no partiality. She's coming to make the best picks of the evening. Is there a way you can just, you know, even if it's one of the tickets, even if they just drop me in Ghana. I've just been provided with a list of possible winners. I'm seeing big names here. She's closing her eyes to make the first pick. She's closing her eyes to make the first pick. We have 125 names on this list. Who would go home with a gift bag from Kenya Airways? Can I independently confirm that? Number 99. Winning number 99. Winning a package, a gift bag from Kenya Airways. Please put your hands together for Oluwaseun Oreshegun. Make that better, make that better. He has been flying Air Peace all his life. But from now on, he gets to fly Kenya Airways. So, he gets a gift bag from Kenya Airways. Okay. We'll call on Adebimpe Bada. Yes, Madam Adekbimbe Bada. Please come and present. You look like you are from Kenya, ma. So please do us the honors of presenting the Kenya Airways gift bag. And there's an Kenya Airways are so thoughtful. They know that rain is falling continuously in Lagos, so they gave him an umbrella. Please, just to bring to your notice that the chairman of the Law Week Committee, she's impartial. Her first pick was a man. Men in the house, is she doing good? She's doing great. I know the women, they're already angry. Rita is now on her phone. One more pick for a customized, a much more loaded gift bag. Number 7. Number 7. Winning a much more heavier gift bag from Kenya Airways. All the way from Ikorodu. Damilare Oyinlola. Gone. She has gone back to Ikorodu. Please, Ikorodu is not bad, though. I know that's where Abondi is from. One more pick before the flight ticket. Number 21. Number 21. All the way from Abuja, Nigeria. Afam Mefuna Okeke. Afam Okeke. Gone. Madam Chair has picked another man. Oh. You are doing well, ma. Long shall you reign. Number 75. The name looks male. Ihai Chuku Uwa. Ihai Chuku Uwa. I said it. Ihai Chuku Uwa. A round of applause. Well, it seems he's not too sure. Is that his name? Are you sure that's your name? Okay. We'd like to invite the treasurer of the branch, our Ministry of Finance. Our Ministry of Finance. Please do not forget tomorrow the master classes sent to your emails. We would also have the Young Lawyers Forum movie night at Ebony Life. We are watching Michael. And the Elders Night, strictly by invitation, sponsored by George Itomi and Partners. On Thursday, we get to hear from all our candidates at the town hall. And on Friday, the closing party, the grand closing party. What are the colors of the day? What are the colors of the day? The closing party. White and denim. You want to see the chair of the Law Week Planning Committee? They say she's firm. We'll see her boogie down that day. Maybe we'll see them booga. Anyhow. All right. Last but not the least. Now, we are now at the most important moment. We get to have the last pick. This pick cannot be Gideon Edem. He just came back from Kenya. It might be Rita Nwokocha. Maybe she's lucky. It might be Gabriel Esosa. He has given his all to the Law Week. It might be Cynthia Ekeka. She's waiting. Fingers crossed. Soprichi Rufus does not look like she wants to travel. She went to Ghana last year. So, my chair of the Law Week Planning Committee, who can it be if not Nimi Edime? All right, the last pick of the evening. Kelvin, the way you are rolling that in, I'm feeling headache because my own is... All right. No, whisper it. Don't. Let me see. It has to be shuffled. Isabella wants to win again. Isabella cannot win again. No. Abondi cannot win again. No, Abondi, you can win in life, but you cannot win here. Nobody knows their number on this list. 119. Can we have absolute silence in the hall, please? This is serious business. This is serious business. 119. Simi Lolua Ige. Simi Lolua Ige. Simi Lolua. Going. Are you sure that's her? Who knows her in this profession? Let us see your name tag. Huh? Let us see your name tag. Are you sure? Are you sure you don't work for Kenya Airways? Where does she work? Who knows her? All right, a round of applause for a winner. A round of applause for Similolua Ige. She gets to travel to anywhere in Africa. We just hope she has a passport to. Simi, hope you have a passport. All right. All right, there you have it. Congratulations. A round of applause for Simi. A round of applause for Rita Nwokocha. She's such a good sport. And I'm sure she will give us a stellar closing party. Please, the owner of this key. Is your key? Okay. Come and go home. Okay. We would now like to call the treasurer of the branch, our very own Ministry of Finance, Ogechi Mokelu, to please give us the vote of thanks. Don't go yet. A round of applause for her one last time.
I didn't win a laptop. I didn't win a ticket. I didn't win the gift bag. I won. So, good evening, everyone. On behalf of the chairman of the Nigerian Bar Association, the chairman of the Law Week Planning Committee, the entire membership of the Law Week Planning Committee, we want to sincerely thank and appreciate each and every one of you for staying behind up until now. We hope that you participate in the rest of the activities for the week. And we hope we did well, and we hope you enjoyed yourself today. Thank you very much for staying back. Enjoy the rest of the day. God bless you.
All right, thank you very much. We started on a very high note this morning. I was not just on my own on stage. I was ably helped by my co-host, Chinasa Akachuku. Please, a round of applause for Chinasa. I want her to do us the honors of a closing statement. And then, did your MCs do well? Did your MCs do well? Will you recommend us again? Thank you very much. Chinasa.
So thank you everyone for staying with us to this very end. I am very happy that we are all smiling. This ended on a very high note.
Cogito,
you don't have any respect for us. You don't know that we're the one that anchored this entire event. We're speaking and you're playing music. Is there a technical error? Okay, I take it as a technical error. Apology accepted. All right, so ladies and gentlemen, thank you for staying with us till this very end. I am very grateful to have hosted with Nimi. Thank you, Madam Chairperson. Thank you to the chairman of the planning committee and to all the members of the ESCOs and the planning committee. This event couldn't have happened without your powerhouse behind the scenes. Thank you for the sleepless nights. And we'll continue tomorrow, like we already said, a masterclass. And then we'll have the wind down in the evening at the movies for the young lawyers, elders nights for the elders of the bar. On Thursday, we have a town hall meeting. On Friday, we will turn it down. I don't know if an artist is coming, but I look forward to it because that's how we do it every year. Rita will tell us better. But in the meantime, get your sneakers ready, get your denim ready, get your whites ready, and be ready to turn it down on Friday. Ladies and gentlemen, good evening.
All right, and with that, we say a thank you, and we close the technical sessions of the MBA Lagos Law Week 2026. Good night. Thank you all. If you're a member of the committee and you still... If you are a member of the committee, a Law Week Planning Committee, and you stayed till now, or members of the ESCO, please, we have refreshments for you. You know, Gideon Edem, we have refreshments for you. Please don't go. Oliver, we have refreshments for you. The chair of the Law Week Planning Committee, we have refreshments for you.
This picture is not final.